ಹಾಂ ಆಯ್ತು ಬನ್ನಿ ಆಯ್ತಾ ಸಿಗ್ಲಿಲ್ಲ ಹುಡುಕಿದೆ ಎಲ್ಲಿಯೋ ಉಂಟು ಪಾಸ್ವರ್ಡ್ ಮಾಡ್ತೇನೆ ನಾನು.
My lord, on Friday, a matter has been moved. An ex parte order of injunction was granted by the trial court not to deliver possession in respect of certain property by the developer. My lord, there was no occupancy certificate. I am the landowner. There was a dispute. They have moved this honorable court and obtained a stay of that ex parte injunction. The difficulty is that the developer is, based on the stay granted, he is claiming that the stay has been vacated and he is already allowing people to move in into the apartments. There is some urgency, my lord. If your lordship could take it up tomorrow, I will convince your lordship.
You give the memo. All the memos will come
My lord,
tomorrow.
the Leonard court officer said that matters will be listed day after tomorrow. Because of the urgency, I am making this mention.
Tomorrow it will come. Tomorrow.
Tomorrow.
With your lordship's limit. School buses, of the government of age of the vehicle, fitness certificate is rejected. Matter is covered by 2 decisions of dishonorable.
No. There is other.
I have
the other
stopped the
day,
vehicles.
No. The other day there is a batch posted to when on today it's there. Tuesday or some. Give the memo. We'll see. Yes.
2:30 minutes.
And please, no 2:30. No urgency for that. Why are you mentioning when a court officer is taking all the
No,
memos?
it is emergency, my lord.
Huh?
It is the extension of parole, my lord. Your lordship only granted in 15 days in vacation bench, my lord. But now he's going to second time surgery, my lord. The petition is necessary to present.
Why are you coming here?
My lord, your lordship only granted 15 days in vacation bench, my lord.
So again, now you want extension of that?
Yes, my lord.
No, whoever is having the toaster is not with me.
No, my lord. Your lordship only granted.
Granted. No, you have to have a fresh application.
No, my lord. I am filing IA for extension, my lord. Tomorrow, my lord. Watch over.
There's some urgency, my lord. The trial court did not grant the ex parte injunction. My lord, tomorrow is the auction, my lord, of the property.
When I'm giving you all memos, give it to the court officer, but still everybody wants to
My
mention
lord,
and waste
my
the
lord,
court's time.
I wanted for 2:30, my lord. If not, kindly have it tomorrow, my lord, please.
It will come tomorrow. Give it to the court officer. Yes.
My lords,
All memos you give it tomorrow. Doesn't matter.
my lords, delivery warrant has been issued, my lord. Hence there is a urgency. Delivery warrant has been issued, my lord.
Give it to the court officer. It will
30,
come
my-
tomorrow. No 2:30.
30,
No 2:30. Yes, call the list.
Pending matter.
I appear for petition. I informed the other side. Next month, July.
Same the other day you're mentioning about.
Yes.
This is matters in the month of July. 47. 48 also.
48. Connected. It's both are connected.
48 till 48 next month, July. Don't give a date, just say the month of July. Yes.
49, I'm prepared for respondent. I informed the other side, my lord. 2 weeks time.
There is an interim order.
No, my lord.
Then why do you want time? This is matter in the month of August at the request of land council for the respondent. Yes,
55, my lord. I'm withdrawing the petition, my lord. Becomes infectious. 55, my lord. 55. Matter settled between the parties in Lok Adalat.
memo is filed stating that the dispute is settled between the parties. The petitioner wants to withdraw the petition. Memo is taken on record and dismissed as withdrawn. Yes, next.
Looks list to serial number 43, my lords. The council on record, my lords, has met with an accident. He's torn his ankle.
Serial number?
43, my lords, list 2. He's unable to.
When do you want?
Next week, my lords.
It is submitted that the land council for the petitioner met with an accident and request is made seeking adjournment. This matter on 14th of July. Interim order, look at it if it is there.
Interim order is there.
Till the next date of hearing.
Grateful.
Yes. Yes.
My lord, is it first matter, my lord?
Yes.
My lord, the appeal is allowed. In fact, my lord has ordered transfer of
yes.
Amount to the, it should be refunded, my lord. Para 10 of judgment, my lord. Roman 5. Amount shall be forthwith transferred to the tribunal. That is the order my lord has made. In fact, if I remember correctly, my lord had said it should be refunded to the appellant. Somehow this has
when the enhancement is there, why should it be refunded to you?
My lord, your liability is fixed on the other vehicle. Para 4 may kindly be seen. My lord has fixed the liability on the other vehicle, my lord, not even the insured of my vehicle.
This court has disposed of the appeals. This court has allowed the appeal of the insurance company and fixed the liability on the owner of the vehicle.
Other vehicle.
Clause number 4, clause number 5 of the operative portion of the order. The amount in deposit is directed to be transferred to the tribunal. The present IA is the matter is placed before this court. The caption for being spoken to, and the land counsel for the petitioner submits that as the liability is fixed on the other vehicle and the insurance company is allowed, this court has directed has observed that the amount can be withdrawn by the insurance company. The same is not forthcoming in the order. This court has perused the order and considering the submissions. Clause 5 of the order shall be the amount in deposit shall be forthwith transferred to the tribunal, and on such transfer, the respondent insurance company is at liberty to withdraw the amount. Accordingly, the registry is directed to make the corrections and upload the corrected copy of the order. In one, this is in one.
Before the tribunal, madam?
Yes.
Please. Please.
Appeal for petitioner, my lords. The terms of compromise are finalized, my lords. The respondent wants to change some wordings in the petition. Kindly post it on Wednesday, my lords.
You only asked the other day for Monday.
Yes, my lords. It is settled. We discussed.
Ma'am, you have some time to changes that
Listen, matter
compromise.
Wednesday.
Kindly have it on Wednesday, my lords. Wednesday, tomorrow, my lords.
So both the parties. If on that day again you ask for time, I'll adjourn it to August.
No, please.
Yes.
Interim order may be extended.
Interim order only granted is extended. Next.
Grateful.
Petition. My lord, I request for the pass of senior counsel in another court.
In this matter, they
filed that.
What is the reason? Why should this matter be taken at the top of the list for seeking an
My lord,
adjournment?
sorry, maybe senior counsel.
For seeking a password.
On merits, my lords, I don't think there is any submissions to be made. Only thing is, my lords, that they have not quantified the amount.
They have filed an affidavit.
I
What do you
filed
say
affidavit.
about it?
My lords,
They have filed an affidavit the other day.
Please,
What do you
ma'am.
say about it?
my lords, in that affidavit, what they have done is, my lords, they have asked for release of out of 11 flats that has been attached, 7 flats to be immediately released on a payment of 5 crores, and also the house property. Put together, my lords, out of 12 properties, 8 properties to be released immediately. And my lords, they'll be paying me only 5 crores.
No, no.
No,
They
my
said,
lord, the affidavit what I have filed, my lord, there are totally 12 flats it's been attached, my lord. I have filed an affidavit of undertaking for 5 flats. I have told, I have mentioned in the affidavit, I'm ready to pay 5 crores immediately, and they let them release 1 or 2 flats. By 2nd July, I'll pay another 10 crores. Let them release another 2 flats, and by 15th August, I'll pay another 5 crores. And by 15th September, whatever is I have paid certain
it is
amount.
going till September, if I remember. He said like June, July,
No, my lord,
2 months he said.
I will be required to pay the entire amount
My
in
lords,
2 3 months, my lord.
Even they're not quantifying the amount. To quantify the amount, they are saying keep the matter pending. I will go to the executing court. Yet again, I'll dispute over the
No, no, I'm
remaining
not-
amount payable.
No,
My lords, the
I'm not
understanding
dispute-
was
my
that,
lord, kindly see
the
my
understanding
affidavit,
was
what I
that
mentioned.
3 installments.
Let us look at that affidavit.
Please, my lords, I made it in a more simpler way. Court officer, please. If I just
Give
point,
that affidavit also.
I have given them, please, my lords. My lords, this is my
In this it
objection.
is there.
My lords,
Affidavit is in this.
No, affidavit is.
this is the objection to the affidavit. If I take your lordships through page number 2 of my table, which I given now, this is exactly is what they are proposing, please, my lords. Immediately, payment is nil. 7 flats to be released, out of 12 flats, and 1 house to be released. Remaining security will be 5 flats. On 8/6/2026, that is today, please, my lords, they are supposed to pay me 5 crores and 2 more flats to be released. So put together, 9 flats will get released, my lords, is what their proposal is.
Now, what is the difference between the first column and the second one?
That's what they're asking, my lords, for passing the order in this matter. First, the release of 7 flats should be done, and the house property also should be released. Thereafter, they will start making the payment.
Again, no. First, this payment by petition for the first column nil. And immediately at 5 lakhs, again 7 plus 2, 9 it is becoming.
Please, my lords, exactly.
plus a
That is their proposal.
No,
Which
my
is what
lord,
we are
my
objecting,
lord,
please, my
there
lords.
is already
This is
5
incorrect.
flat-
This is absolutely incorrect, please, my lords.
I'll hear the senior counsel.
Please, my lords.
They can't be there. Please instruct your client. If this is the way, I'm not going to accept it. I'm not going to pass any orders on this. You're only dictating it.
No,
Saying
no,
that I'll.
no, my lord, we
The
intend.
senior counsel come afternoon. Yes.
Please.
Yes. You the memo.
Madam, so I am the GP of the petitioner. Actually, I want to withdraw the case. The reason is that respondent number 1.
What is this petition for, to file a petition in future? Future for what?
And actually, that we issue a possession notice. Respondent number 1.
Now, whatever you have questioned before this court, with regard to that, why should the court grant you a liberty? If any other action is, any other order or
No,
any
sir,
further
actually,
action?
madam, in other court, TRT court, he has submitted that the amounts has been deposited. The amount has been, it is still pending with the DR court, TRT. Yeah, copy. Madam, sir.
That's what you say, position notice no longer exists. So I'll dismissed as infructuous. The petitioner has filed the writ petition questioning
Actually,
the-
madam, respondent number.
If at all they initiate something, you are always at liberty. The present writ petition is filed questioning a position notice. And now a memo is filed stating that in the hearing dated 8/4/2026 in WP number 39390 of 2025, the counsel for the respondent number 1 has submitted before the court that the loan amount against the home loan has been deposited by the respondent number 2 and also plays a bank statement. It is stated that the possession notice dated 19/11/2024 no longer exists, which is the main cause of filing the writ petition. Hence, The petitioner wants to withdraw the writ petition. The writ petition is dismissed as withdrawn, and the petition is always at liberty to question any further action initiated by the respondents. Yes.
Petitioner, my lord. Seek for withdrawal of the petition with the liberty to file a fresh petition, my lord.
What is this? Why you want the
My
liberty?
lord, we have not challenged the amendment of CPC, my lord, in this, my lord. So liberty may be granted, my lord, or else the petition would be like incomplete, my lord.
The writ petition is filed seeking to withdraw the writ petition. It is submitted that the trial court has dismissed the written statement as the same is filed with 6 days delay, and the petitioner wants to question the amendment to the CPC. Hence, the memo is filed seeking to withdraw the writ petition. Accordingly, the writ petition is dismissed as withdrawn, giving liberty to the petitioner to file a fresh writ petition within a period of 1 week from the date of receipt of the copy of this order.
Much obliged.
The petitioner, heard by you.
Yes.
That's the order under challenge is an order passed, and that reason why maintainability is issued is raised, my lords, is for the reason that 39 rule 1 and 2 ex parte order is challenged. Lords, with consent of my learned counsel for the respondent, my lords, if the application before the trial court is to be disposed of in a speedy, expeditious manner, my lords,
When did you file the vacate petition?
my lords, in the last week, my lords, 2nd of June.
What is that IA?
IA for vacating the
There
interim.
is no number for the IA.
IA number 2, my lords.
Yes, we'll ask them to dispose it off.
Speedy. Just now we have received the hard copies.
Anyway, I'm not passing any order, only directing the trial court to dispose of the matter.
Yes, your lord.
The writ petition is filed. Where is the prayer? The writ petition is filed. Questioning the order dated 30/4/2026, passed on I number 1 of 2026 in Com OS number 152 of 2026 with the first additional district judge D.K. Mangalore. Land Council, the office has raised an objection with regard to the maintainability. Land Council for the petitioner submits that an ex parte order is passed by the court without even considering the without giving any finding with regard to the prima facie case balance of convenience and irreparable loss. Hence, the petitioner has approached this court. Next, Land Council appearing for the respondent submits that the writ petition before this court is not maintainable. Further, they have received the writ petition papers today. Where is the order?
My lords, order is at annexure M, my lords.
Page number.
117. Last annexure, my lords. Very last.
The next file. Petitioner has already filed IA number 2, seeking to vacate the interim order. In this matter, notice is issued, returnable by 2/6/2026. Considering the same, this court is not inclined to pass any or go into the merits of the matter, and deems it appropriate to direct the trial court to expeditiously decide the matter. Accordingly, this court is passing the following order. The writ petition is disposed of, requesting the trial court to dispose of the pending IA number 2 as expeditiously as possible.
IA number 2 as well as IA number 2 is the 39 rule 1 and 2 which they have tried. IA number 3 is my IA, my lords. I'm sorry. IA number 3 is my IA for vacating interim order.
To decide IA number 3 as expeditiously as possible.
Gratefully.
For the petitioner.
Yes.
I'm sorry,
I
my
guess-
lords. I'm sorry, my lords. May I seek for a time period which to be
Within 1 month. Yes.
Against a order on IA number 12 and 13, this writ petition is filed. IA number 12 is for reopening the case. IA number 13 is for recalling PW1 for cross-examination. Single writ petition is filed, office has raised the objection saying there are two IAs, one writ petition is not maintainable. To avoid complication, we paid another set of court fee also, but still office objection.
So that's what I think some circular is issued to the registry in this regard. Because in some of the cases, though in this case, they're all connected. What is happening is in unconnected, I guess, they're filing one writ petition and that is giving lot. No, we don't know what to do with the writ petition, dismissed, allowed. So that's how the office objection with regard to the maintainability is overruled. Let the council submits that. IA number one IA is to recall. One IA is to reopen and the other IA is to recall further cross-examination. As such, they have filed one writ petition. Considering the same, the office objection is over. Yes.
It may be called on 11th, my lord. The connected matter, your lordships have already.
What is the date? What is
16188.
Ask him, write it.
Please, I will give it. It's posted to 11th.
Let's along with so and so. Yes, next 8.
Declaration of title and injunction. Property is an agricultural property. In the impugned order, the judge says that you pay a court.
What are the office objections?
The office objection is, my lord, they say since it is an order under Order 7, Rule 11, a CRP is made. Suit is not yet dismissed. A conditional order is passed. Against the conditional order, I am before my lords.
What is the conditional order?
The conditional order is if I don't pay court fee within a prescribed time, this suit will stand rejected. Kindly come to page 32, my lord. Plaintiff is directed to value the suit on the market value of the suit scheduled property and pay court fee ad valorem basis by filing fresh valuation slip within 4 weeks. Failing from the date of suit, in default, the suit will stand dismissed. That I have challenged. Suit is still pending.
Yes.
Well, now, I am now before my lords on the issue that admittedly the property is an agricultural property. Suit is for injunction. The defendants claim title in respect of the neighboring property. There is little encroachment on my land, against which I filed this suit, valuing the suit and paying court fee under section 7(2).
Yes.
That is the matter, my lord.
Let's see the order.
My lord, kindly come to para 13, my lord. From para 13 onwards, come to para 15.
As of now, it is situated within the limits of the municipality.
Municipality.
Yes, how can you call it an agricultural land now?
My lord, it is not yet converted under section 96 of the Land Revenue Act. Until it is converted, it remains an agricultural property. My lord, there are a couple of different views, my lord. If my lord, if I'm asking for a
Paying the tax.
Tax, I'm still paying the land revenue tax. I produced that also, mutation.
Where is that?
My lord, kindly see the para 15, my lord. In the present case, admittedly, RTC and mutual suits are standing in the name. Present suit is as on the date of the only reason the court assigns is since it is now falling within BBMP. I have produced the taxpayer receipt, RTC, all documents. Court admits that as on date, the property is still agricultural property. The defendants also admit that. The only contention that the defendant raises is that they are the owners of the neighboring land wherein sites are formed, and there is alleged encroachment on the eastern side of my portion of my property.
What are the documents that are filed before the court?
I have filed RTC, mutation, latest RTC, taxpayer receipt, everything I filed.
As an agricultural land you have paid?
Agricultural tax, yes, ma'am.
Please come. Land counsel for the petition submits that the court has calculated the court fees, considering it as a agricultural land, but the same as a non-agricultural land. But the property is an agricultural land. In support of that, he has filed the RTC extracts. Considering the same, they shall be stay of all further proceedings. Pursuant to the order dated so and so, in the next date of hearing, same the petitioner shall take out hand summons on the counsel, appearing for the respondent. We shall file a memo to that effect by 1st of July, or else a stay granted by this court.
Please, my lord.
Stands vacated. In all these matters, first notice to the respondents in addition to, yes. Next, next with regard to the office objections, the land counsel appearing for the petition submits that the court has not rejected the claim But in fact, as director, passed a conditional order and questioning that the petition is before this court. And the objection with regard to the maintainability cannot be sustained. Considering the submission, the office objection is over. Yes.
Great to hear.
My lord, petitioner, please, my lord, she is owner of the, my lord, land bearing. Petitioner, my lord, she is owner of the land bearing survey number 67/3, new number 69, measuring to an extent of 2 acres, please, my lord, having purchased in the year, please, my lord, 1993. My lord, in the year 1984, please, my lord, respondent number 1 and 2, they filed a suit for partition, which has been renumbered as OS2 of 2001. My lord, there are 39 scheduled properties are concerned, please, my lord, which are classified as Schedule A and Schedule B. In the suit, please, my lord, the scheduled property, my lord, which I am claiming writ petition scheduled property, which I am owner, the property was not included. My lord, the matter went up to this court, please, my lord, in a division bench. My lord, the matter was remitted back, please, my lord, for the reason that, please, my lord, few properties, please, my lord, respondent number 1, wife, she was the owner of the property and she was not made as a party to the proceedings is concerned. This court held that, please, my lord, since she is not a party and there is a finding that there is a decree in respect of the item number 37 to 39 is concerned, matter was remitted back, please, my lord. While remitting, my lord, on remitting
for partition.
Suit for partition. On remitting also, please, my lord, the petitioner's scheduled property was not included. My lord, they filed an FDP, my lord, the respondents number 1 and 2. My lord, in the FDP, please, my lord, they file an amendment application, please, my lord, seeking to incorporate Schedule C properties is concerned. Among the scheduled properties, please, my lord, petitioner's scheduled properties was also been included. Along with this, please, my lord, they also file an amendment under section 152 of the CPC seeking an amendment to the preliminary decree to include my scheduled property, please, my lord, under which, please, my lord, petitioner was not a party. Petitioner is not a party in the original suit, either in the division bench or, my lord, the matter remanding back or in the FDP proceedings. My lord, they file an application for amendment, please, my lord, the respondent says no objection and the application is.
This property which is included is in your name.
It's in my name. I have produced the registered sale in 1993. As on today, it's in my name. Why they sought to include, please, my lord, I am the wife of respondent number 2. They takes up a contention in the original suit, please, my lord, in spite of taking up contention, they did not include. Just because, please, my lord, when they file an application for division of the properties and when they go to the near the scheduled properties, they can.
What did the respondent number do when this IA is filed? Seeking to amend.
Well, respondent number 2, please, my lord, he had not at all instructed the respondent number 1 to file the IA. Respondent number 2 is the wife of the petitioner. He has not at all instructed the respondent number 1 to file this application.
Your husband is a party to the partition.
Yes, please, my lord, he is a party to the proceedings.
So when an IA is filed,
please, my lord,
you were not aware of it.
I was not aware. My lord, kindly see the sale deed, please, my lord, of the year 1993 and the RTC, please, my lord, of the year very recent. It still stands in my name. It's my Stridhana property. Section.
That order where the court has allowed that IA.
Page 24. It is based on the consent. It is allowed. Page 24. Page 26, my lord, relevant. Para 4.
Why both you and your husband are not together?
My lord, we are in good terms. There's no dispute about it. But the reason is that, please, my lord, respondent number 2, as my husband has not instructed the respondent number 1 to file this, to give consent not to implement this particular property. There are other properties, please, my lord, certainly. There are other properties to be included, please, my lord, which is not standing.
No, your husband, because the property belongs to his wife.
Please,
your
my lord.
husband has not objected for that. He has accepted. He has.
My lord, what has happened? He has not instructed the council, please, my lord, nor the respondent number 1. Why? Because affidavit is sworn.
It is not instructing. It is that he kept quiet.
He kept
quiet there, and now the wife comes before the court by seeking leave of the
my
court.
lord, respondent number, my lord, respondent number 1 has sworn to the affidavit on behalf of the respondent number 2. He has not instructed it. That is what my lord specific condition.
Where did you say so?
My lord, in the writ petition, my lord, I say so.
Even the respondent is before this court. Husband is also before.
Yes, please, my lord.
Where did he say so?
My lord, I have, my lord, in the writ petition, please.
First of all, let's see this order.
Please, my lord, impugned order. My lord, it commences from page 26, relevant. Para 4. Submits that he has no objections to allow the IA number 3. In view of the said submission and the grounds made out in the affidavit, referred supra, this court is of the opinion that the proposed amendment is necessary to adjudicate the question.
Where is it, page number?
Well, at page 26,
Hmm.
relevant I am reading
Hmm.
from para 4. Now I'm para 5, please, my lord. Para 4, please, my lord, where the respondent counsel says no objections to allow the IA number 2. Para 5, please, my lord. In view of the said submission and the grounds made out in the affidavit referred supra, this court is of the opinion that the proposed amendment is necessary to adjudicate the question in controversy and as such the necessary for determination of the real controversy. Accordingly, in view of the
Where is the
submission made,
IA affidavit? Where is IA affidavit?
my lord, IA 2.
Page number?
My lord, it commences from page 157. My lord, page 158, serial number 5 is the scheduled property.
So what do they say about this property?
My lord, page 161, please, my lord, affidavits formed by the respondent number 1. As far as this property is concerned, please, my lord, para 5.
Para number 5.
Para 5 and 6. Defendants have filed a written statement and took the defense of that property bearing number so and so, please, my lord. It comes in page 163 in 5th line. Property bearing survey number 67/3 after coding new number so and so, please, my lord, your lordship. Are also joint family properties of the parties to the proceedings. On the basis of the pleadings of both the parties, issue number of this honorable court framed issues in IA number 8, 10 and 11 answered as affirmative in the judgment dated 14/3/2006. Clearly held that the parties are entitled to get share in the said properties of which.
No, please come to this. On the basis of the pleadings of both the parties, the honorable court framed the issues.
My lord, for the moment, for that also, please, my lord, kindly come
As
to.
affirmative, and in the judgment dated 14/3/2006, clearly held that the parties are entitled to get the share in the said properties also.
That scheduled property, even though they take up a contention, please, my lord. Firstly, my lord, my submission would be in the suit, please, my lord, I was not made as a party.
What are you doing? Your husband is a party.
My lord, my lord, certainly, please, my lord, I was, my lord, kept dark in this particular respect.
No. First of all, in the year 2006 itself, this property which you are mentioning about is a part of the suit schedule.
Well, it is not a shoot schedule.
That's what he says.
Well, kindly refer to the decree, my lord.
Let us see this 14/3/2006.
My lord, page 38.
Yes.
Issue number 11.
No, page number?
38.
Yes.
Issue number 11, please, my lord. Whether the defendants prove that the land bearing number, survey number so and so of Thorelia measuring to an extent of so and so was purchased in the name of Jailaks Mama, wife of Kashaya Plain. Please, my lord.
That's you.
That's, my lord, the petitioner herein. In the name of plaintiff number 3 out of joint family funds.
What is the finding on this?
My lord, absolutely, my lord, there is not even a single
Let's see.
Yes, please, my lord. Para 16 to 26.
Yes.
And my lord, the issue number 11, please, my lord, is given as affirmative. Issue number, please, my lord, it commences from page para 16.
1 to 12 were decided in this.
Yes, please, my lord. My lord, if your lordship would peruse the entire order sheet, please, my lord, entire observations.
That is not for this court to look into that. Or the issues number 1 to 12 are held in affirmative. That means the court has held it in favor of.
My lord, there is not even a single observation.
That is not for this court to look into it.
Lord, may I submit, please?
If you are agreed by that, you would have questioned it.
Certainly.
There appears to be a collusion between. We can't.
My lord, may I submit only this much, please? May I only? My lord, scheduled property is not being included in the preliminary decree. Kindly.
That is what they are saying. When though there was judgment shows so, but it was not included. But there is a finding against you.
My lord, there is not even a single my lord, to come to an finding.
There is no, according to you, that judgment and decree is bad for whatsoever reason, you could have questioned it. Now the issue is framed, issue is answered. How it is answered, we are not sitting in appeal on that.
Please, my lord. Yes. My lord, if your lordship would peruse, my lord, the findings, please, my lord, rendered in the division bench. My lord, what happened? Respondent number 1 and 2, please, my lord. Respondent number 1's wife scheduled property was also included. Item number 38 to 39. The matter came up before the division bench. My lord, the division bench finding is that the scheduled property of respondent number 1's wife are being impleaded. The trial court ought to have impleaded and given an opportunity. That is the finding of the division bench of this court, please, my lord, in an RFA. May I take your lordships, please, my lord, at page 81. There is a categorical finding.
First is finding set aside.
My lord, this finding was not set aside. But please, my lord, that was the,
Of any amount of observations, discussions, that is not a judgment.
my lord, my submission would be, please, my lord, the preliminary decree, please, my lord.
You are right from 2006. You have just been a mute spectator to all this.
My lord, I was not even made as a party, please, my lord. I was not even, they could have implemented the petitioner is concerned and they could have, and moreover,
Court
please, my
will
lord.
not accept this kind of submissions. There is a judgment and decree where that particular property is held to be a joint family.
Behind my back.
Your husband is a party. You are in good terms with your husband. You are aware of this. In spite of that, you kept quiet from 2006. Now you come before the court and say that, that property without notice to me is.
Well, certainly, please, in FDP also, I am not made as a party. In FDP also, I am not made as a party, and they also file an amendment application, please, my lord, to amend the decree. That application is not still considered. Without there being any preliminary decree in respect of my scheduled property is concerned, please, my lord, they.
For the court, why are you coming here?
My lord, now they have already allowed the application for amendment. And my lord, this court is the jurisdiction, my lord, to entertain and interfere with in respect of this property is concerned.
This kind of litigation.
My lord, certainly, please, my lord, if I was made as a party and if I have suffered the decree and if the my lord, defendants herein, my lord, they have implemented the written statement scheduled property is concerned, please, my lord, certainly have.
There is a judgment and decree, whether it is just no more or less clear. It is a correcting the decree, nothing else. Because there is a decree against you. Considering that property is a joint family property, that finding has attained finality.
My lord, may I take your lordships to the.
If you are aggrieved by the judgment, you should have questioned it.
Please,
even now you can say that I am not aware of it and go and question it.
Certainly.
No, just because this property was not shown in the decree, which is subsequently, though there is a judgment, but that is not added in the preliminary decree. Now they filed an amendment. Amendment is allowed, and I do not find any reasons to interfere with that.
Well, kindly see, my lord, the amendment for decree, page 165.
Yes.
Well,
it is consequential to the judgment unless and until the judgment is set aside. Unless and until you are aggrieved by that, you cannot say that all the consequential proceedings you are aggrieved. That can't be.
Well, if your lordship could peruse the decree, my lord, kindly peruse
I
the.
understand that in the original decree, this is not, this didn't find place. But as per the judgment, there is an issue. There is a finding against you.
My lord, finding, please, my lord, in respect of an observation is also, please, my lord, there is no observation to that extent is concerned.
That will be questioned when you question the judgment, not an ancillary.
Lord, can I say this, please, my lord? Your lordship may adjourn for a moment. In the meantime, I'll challenge them, my lord.
Yes. The Lysis matter in the month of July.
Please, my lord.
I am not. Yes, next.
I represent the petitioner.
Yes.
I challenge the order passed by the trial court filing the application under section 10 of CPC. The trial court has dismissed the application. Upon that, by order dated.
Where is the order?
Order is in page number 11. There are two suits are there. Both the suits are partition suits only. In both the suits, the properties are the same, parties are also same.
They are both the suits are pending on the file of which court?
Very same court. Third additional senior civil judge Devanadi. Before the same court.
What are the suit numbers? Give the particular.
Suit number is first one is OS number 1618 of 2006. It is the earlier suit. That is also pending before the court. A suit for a partition. Another one is 609 of 2014. In a suit for 609 of 14, I have filed the application before the court under section 10 of this to stay the proceedings of the OS number 609 of 2014.
What is the difference between this suit and this suit?
Sorry.
Why two suits are filed?
Both the suits are for a partition and separate possession. I am the defendant in both the cases.
Why the properties are two different properties?
No. There are a couple of other properties are also there. Other parties are also there. But my properties in both the suits are same. Kindly see. Come to the.
What is the stage of this 2006 suit?
It is in evidence stage. Now it has come to the evidence.
And what is the stage of this 2014?
Here is also evidence.
No, when it is between the very same parties Why did you not when they are at the same
See,
stage?
kindly see earlier suit in OS number.
As per, clubbing of both the suits.
Please, your.
Why can't both the suits be clubbed together?
No, it cannot be, because here there are a 29 defendants are there.
In which suit?
In OS number 161, 45 defendants are there in OS number 1618 of 2006, earlier suit. In a suit for earlier subsequent suit, there are 4 defendants. I am the one of the defendant in that case. Here they are seeking 1/25th of one share in the suit schedule property. In all other suit schedule properties are also there. There will be a divergent opinion from the court in both the suits were decreed or dismissed. In a suit for earlier subsequent suit 609 of 2014, they are taking the contention stating that it is a individual property. It is a individual property. In a suit for 1618, they are taking the contention stating that it is a joint family property.
So this plaintiff is also a party to that.
Yes, Your Honor.
Then why did you file a separate suit? Because already
No,
this
no.
party-
Plaintiff is a defendant in the earlier suit. The plaintiff in OS number 609 of 2014, she is a defendant in OS number.
How does it make any difference? Now the properties are joint family properties.
No, it is not a joint family. I am purchased the property.
According to the plaintiff, that is a joint family property. Defendant is contesting it.
Yes, Your Honor. But there will be a multiplicity of the proceedings will start, and there are other parties are there already. They have purchased.
That you have realized in a 2014 suit in 2026.
Yes, but however, I have filed very recently. I have filed.
Please come to the. Please come to the.
Please, Your Honor.
Please come to the order.
Please. The order at in the last para in page number 16. In page number 16.
Let's read from paragraph number 8.
Please. In a OS number 1618 of 2006 is filed by the Srimati Kempamma, daughter of Munshyampa. It is contended in the said suit that once Sri Hanumantrayappa was the prepossessed of the plaintiff and the defendant number 1 to 15 therein. He had a sons, namely Anjanappa, Sri Kempamma, Sri Munishyampa, Sri Bachappa, and Sri Nanjappa. The plaintiff in the said suit was the daughter of late Munishyamappa. It is further contended in the said suit that the suit schedule properties, which are 64 items, are in the joint and ancestral properties of the plaintiff and other defendant number 1 to 15. Therein, the suit schedule properties in OS number 609 of 14, the present suit, were purchased by the late Veeranna, who was the son of Subbanna, son of Anjanappa, out of joint family fund. Therefore, she has prayed that she is entitled for her legitimate share. In the said suit, the father of the plaintiff herein, namely Veeranna, contended that the suit schedule properties in the present suit is self-acquired properties. The said suit is pending for the impeding other purchasers of the suit schedule properties therein. The defendant number 4 herein is also defendant number 27 in OS number 1618 of 2006. We are contesting on it. Kindly come to the last paragraph. How the trial court has come to conclusion. Almost they are come to conclusion on the basis of the trial. In the last paragraph, in page number 16, from 4th line, even then in OS number 1618 of.
I have seen that. I have read that part.
Please. So the proceedings has to be stayed because there will be a divergent opinion from the court expressed that.
From the same court, there will be divergent opinion.
Please, Your Honor.
In the very same court.
Yes, Your Honor. The proceedings needs to be stayed. Please.
Order will follow. Dismissed. Order will follow. Yes. Next.
Please, Your Honor.
Dismissed. Order will follow. I'll dictate the order later. Case is dismissed. Yes, next.
May the matter be passed over.
Pass over. Next.
Milord, I am from.
Kindly permit to file Respond, 1 minute.
Why do you file here? You should file it in the registry. Yes.
My lord, I appear for the petitioners.
Yes,
It is serial number 12, oh, my lord.
yes,
Petitioners, first defendant is the plaintiff before the learned trial court.
yes.
And prima facie, the order of the learned trial court suffers from procedural impropriety and
What
material.
is the IA? What is the suit for?
Suit is one for partition, my lord.
Yes, what is IA?
IA 3 is for appointment of a court commissioner.
Yes.
What happened was, initially, IA number 1, 2, and 3 were filed by the plaintiff. That is the respondent 1 herein. Order sheet I have produced, annexure A, my lord.
Yes.
Therein, in IA number 1, the prayer it made is to take up the case along with the application for ex parte temporary injunction and application for ex parte appointment of court commissioner to take inventory, etc., etc.
Where is order in IA number 3? Please come to that.
That is found in the order sheet itself, my lord. Page 13, page
Yes.
number 13.
Yes, that IA is allowed.
That IA is allowed. That is, according to me, initially what the learned trial court did is on 14/1/2026, that is day 1, the court refused to grant ex parte relief on IA number 3. That is found in the order sheet, my lord.
Yes.
Temporary injunction was granted by the learned trial court, and the order of the learned trial court, as far as IA number 3 is concerned, it is found at page 12, last line.
Yes.
Issues suit summons and emergent notice on IA number 2 and 3 to the defendants.
What is that IA?
IA 2 is for temporary injunction, which was allowed.
Temporary injunction, what is the order?
Not to encumber, not to alienate, not to mortgage, charge, etc., etc.
Yes.
IA number 2 was allowed. IA number 3, the learned trial court directed issuance of notice to the petitioners and the third defendant herein.
When is that? Where do you find that?
That is page 12, last line, and page 13, first 2 lines, my lord, in annexure A.
Yes.
That is, issue suit summons and emergent notice on IA 2 and IA number 3 to the defendants. But after obtaining the ex parte temporary injunction, it was actually posted to 5/2/2026, my lord. It was got advanced on 19/1/2026 before service of summons on my clients or the petitioners.
Yes.
So, my lord, the learned trial court, when once has come to the conclusion that plaintiff is not entitled to ex parte.
What is the prejudice that is caused to you?
Prejudice means without hearing the petitioners, the learned trial court.
Even assuming that without hearing you, an order is passed. What is the order? It is not adverse to you.
My lord, I have a citation which I have not brought. It may be called in the first week of July.
The order that is passed need not be questioned.
It may be called first week of July, my lord.
Why should it be kept pending till first week of July?
I'll cite the decision, my lord.
Today, for getting the judgment, you wrote require almost a month.
Then any date, my lord.
Let's do it tomorrow. Get the judgment. We'll close this matter. Yes, tomorrow.
I appear for the petitioner, my lord.
Yes.
An order allowing amendment is challenged by way of this writ petition, my lord. The order is at annexure A,
What is the suit for?
suit for permanent injunction, my lord,
Which year is the suit?
2022.
What is the amendment sought now?
Amendment sought is, since the date of accident, I'm reading from annexure B, page 22, my lord. The last two lines on that page. Since the date of accident, that is from 3/7/2017, the plaintiff was managed the entire electrical business at MG Road shop. And she also was managed the entire family needs. That is looking food and all other needs of her parents till 2020. So elaborating that, this amendment is sought for. Another suit is filed by the petitioner, a more comprehensive suit for partition, my lord. In that suit for partition, this suit property is item number 2. There is already an order of temporary injunction in that case. In the present case, the application for temporary injunction is dismissed. MA is also dismissed. Thereafter, the plaintiff has come up with this amendment.
Come to the order. Where is the order? Please come to the order. Where is the order? Page number.
Annexure A, my lord. Page 16.
Let's read the reasoning part.
Reasoning portion is page 20, my lord. Point number 1, plaintiff filed the suit for permanent injunction on careful perusal of the plaint and written statement of the parties. I found that paragraphs ought to be added or helpful to the proper adjudication of present suit, and it is adding more detail to the case and not putting up any new case. As per order 6 rule
Suit for
70.
bare injunction.
My lord.
Suit for bare injunction.
Suit for bare injunction.
Where is the plaint?
Plaint is annexure D, my lord, page 29.
Page number 29.
29.
What is the relationship between the plaintiff and the
They
defendant?
are brother and sister. My lord,
All these things with regard to taking care of the father and all, you have taken up in your written statement.
yes, my lord. And also, my lord may kindly peruse page 81, annexure H. There is a more comprehensive suit filed by.
That is true. What is now, as far as this suit is concerned, what is wrong with this amendment and how is it going to prejudice your case?
Yes, my
Or,
lord.
The defendant.
At page 83, the very same pleading is there in the written statement.
That's a different suit. This is a
Yes.
different suit.
Yes,
Now,
my lord.
is he introducing any new case by way of this amendment?
By way of this amendment, the both cases are pending before two different courts. Brother suit is before the learned senior civil judge
That
court.
is a comprehensive suit.
Yes, my lord.
This is for a mere injunction.
Injunction.
It's a bare injunction.
Injunction.
They have, no, it is, no, they have filed a written statement.
Yes, my lord.
They have already, the factual basis is there in the plaint and they wanted to add some more and they are not introducing any new case. What is the prejudice to you?
In respect of plain scheduled property, my lord, it is item number 2 in the other suit. There is already a finding that prima facie, it is also a joint family property.
Let it be. That will be decided by the court.
So in this case, the sister's case, she is trying to take up a contention that it is her absolute property.
No, she can take any she can take a contention. Ultimately, she has to prove it. And you have your own material to prove.
The very same matter is the subject matter of the other suit also, my lord. The very same matter.
No, can't she, because the another suit is filed, the suit for injunction not maintainable. If it is not maintainable, court will decide it. How come she can be precluded from filing this pleadings, additional pleadings?
So there is scope for two divergent findings, my lord.
That's a different aspect. If there are divergent opinions, what is to be done between the same party, that is left for you. Now we are an application under Order 6, Rule 17.
Yes, my lord.
On those grounds, we cannot, the court cannot dismiss this. Please come. Dismissed. Order will follow.
May I make one more
Yes.
request, my lord? If this case is also transferred to the court of the
For
letter,
that, I will not do that in this case. Your remedy is to file a CP and the court will decide it, not in this. Dismiss. Order will follow. Yes, next. No representation for dismissal tomorrow. Yes, sir. Same this also. Yes.
The suit is filed for recovery of damages.
Recovery of?
Damages.
Hmm.
The defendant was working with the plaintiff's company. He resigned from the job. A car of the company was given to him for use. He did not return the car. Ultimately, police complaint was filed and the car is seized.
What he has not returned?
Car
Car.
which was given to office car,
Hmm.
which was permitted to be used by him. Though he resigned, he did not return the car. Therefore, a police complaint was filed and police seized the car and thereafter we received from the court. Now, this suit is filed for the purpose of the damages for the abuse of the car. Now, I have filed the application because it is better that the expert assess the damages payable for the car, for the use of the car, so that the suit can be disposed of. I don't want to lead any oral evidence. I will depend upon the evidence of the expert itself. The trial court has said, I have not read the evidence, therefore I dismiss the application. That could not be a ground.
Apart from reading the expert evidence, when you have come to the court that there is a damage, you have to adduce some evidence.
No, I will depend upon the expert opinion only. The fact that I have not read the evidence is not a ground for the court to try and dismiss the application.
You will not prove your case.
No, I will rely upon the expert's opinion and get the disposal of suit.
Notice to the respondents. Petition.
Interim stay. I am the plaintiff.
Notice to the respondents. Why you want your suit to be?
Because if I don't read the evidence, the court will dismiss my suit for default.
Which year is the suit?
Suit is of the year 2018.
This is matter on 15th of June. The petition the land counsel of the petition shall take out hand summons on the counsel appearing for the respondent and shall a memo to that effect. If the memo is filed by 12th of June, list the matter on 15th. Yes.
There is another matter between the same parties in regard to the residential premises in WP 313 of 25. That may
Just
also
along with that on the date. Give the
WP 313 of 25.
write on a paper and give so that there won't be any confusion. Yes. Yes.
Correct.
Order, my lords, and challenge, my lords, is an order under Order 1, Rule 10. Lords, I have filed, my lords, an appeal, my lords, under Section 443 of the Karnataka Municipalities Act. Lords, an order for demolition passed, my lords, by the competent authority. Thereafter, my lords, I came before this court, my lords, and lords, the suit, the writ petition was disposed, saying, please go to an appellate authority. Lords, I filed the appeal, my lords, before the district court, my lords, under Section 443 of the Municipalities Act. Lords, the complainant, lords, who were the original complainant before the municipality, lords, they filed an application under Order 1, Rule 10, lords, saying they were also a necessary party insofar as the appeal is concerned. Lords, I take a contention that, lords, the suit appeal, lords, when an order is passed, it is only between the person who is in default, lords, and the municipality.
What is this? What are the notices that are issued earlier?
Lords, the notice was, lords,
provisional order for removing the construction, my lord. And my lord,
Unauthorized construction, illegal construction.
illegal
At the
construction.
behest of the.
At the behest of the complainant. Lords, the complainant, my lords, now files an application under Order 1, Rule 10. Lords, seeking they are also necessary party insofar as the case is concerned. Lords, I rely upon two judgments of this court to say that it is only between the person who is in default and, my lords, the municipality. At the best, my lords, the complainant who has initiated the complaint can be a person who can give evidence insofar as what is the defect is concerned. Lords, the court, my lords, comes to a conclusion that they are also a necessary party insofar as the proceedings is concerned, because they have initiated the complaint at their behest.
What are the judgments of the court?
Lords, the judgment, my lords, have also annexed. My lords, the trial court, my lords, relies upon one judgment, my lords.
Let's see the orders of this court.
Lords, that annexure, my lords, page 79, my lords, is the case law, my lords, of the division bench.
Division bench arising out of a writ appeal.
Writ, my lords, writ appeal, my lords, arising out of a order of writ petition. Lords, in annexure M7, page 79.
Writ petition and 226.
226. Lords, in that, my lords, also.
How come the issue of impeding and other decided by the division?
Lords, what has happened is, my lords, some cases are being treated as GMCPC. Some are treated as, my lords, local bodies. Lords, now it has been treated as, my lords, in this case as a GMCPC matter. Earlier, my lords, when the division bench passed the order, my lords, it was treated as local body RES. Lords, because of that, my lords, there is some confusion also. Lords, may see page 79, lords, annexure M. Lords, the facts at paragraph 4, my lords, if my lords see. Briefly stated, my lords, may I read, my lords? Briefly stated facts are that respondent number 4 had complained against the appellant herein in respect of construction being put up by the appellant. On the basis of the said complaint, respondent Municipality Corporation initiated section 23 of the Karnataka Municipalities Act. For the sake of brevity, a provisional order was made which was followed by confirmatory order. Being aggrieved by the order under section 321(3) of the Act, the appellant filed an appeal under section 443 of the Act before the appellate authority, that is District Court. In the said proceeding, respondent number 4 herein filed an application on Order 1 Rule 10, read with 151, seeking implement. By order of 31/7/2017, learned district judge permitted implement in the said proceeding. Being aggrieved by that order, the appellant filed writ petition assailing the same. Learned single judge dismissed the writ petition by holding there were no merit by it and affirming the order passed by the learned district judge. Against that, the appeal has been filed. My lords, my find, my lords, at page 95, lords, page 94 from paragraph 14, my lords, is the finding that is given, my lords, by the writ appeal court. Page 94, my lords, paragraph number 14. Therefore, the Honorable Supreme Court itself has said that if the object of the party is only to prosecute his own case is a list between two other parties, his implement is wholly unnecessary. Even though party seeking implement may be the one who has given rise to a list between the other two parties, as in the instant case, between the appellant and the respondent corporation. Lords, I'll skip the 15th lords paragraph. 16th paragraph is important, the finding that is given. In view of the fact that in the instant case, the appellate proceeding pending before the miscellaneous appeal court before the district court is one arising from the exercise of power and jurisdiction under section 321 of the Act, as extracted above. The list is between the appellant herein and the respondent corporation. Respondent number 4, though may be an informant or complainant giving rise to the exercise of power under section 321 of the Act by the respondent corporation, cannot seek implement in the appellate proceedings. He cannot agitate any cause he may have vis-a-vis the appellant with regard to the property in the appellate proceeding arising out of section 321 of the Act. The said appellate proceedings arises out of a statutory power by the respondent corporation against the appellant herein, and it cannot be converted to a civil dispute between respondent number 4 and appellant herein. It is to be borne in mind that in an appeal under section 320 of the Act, the right, title, interest of the respondent number 4 vis-a-vis his property would not be considered. The correctness of the statutory power exercised by the corporation, and in order to ascertain whether there is any infraction of the said section by the appellant herein or the person who is putting up construction or reconstruction, is subject matter of the appeal. The grievance that the respondent number 4 may have against the appellant herein vis-a-vis his property is not the subject matter of appeal before the district court.
When counsel for the petition is agreed with the order on IA number 2, wherein the court has impleted the complainant to the pending proceedings. Land Council has relied on a order passed in letter appeal number 10007 of 2018 dated 28th November 2018, stating that the complainant is not a necessary party to the proceedings. It is essentially it's a dispute between the petitioner and the corporation. Considering the judgment passed by the division bench, there shall be stay of all further proceedings pursuant to the order dated so and so. The petitioner is permitted to take out hand summons on the counsel appearing for the respondent shall file a memo to that effect by second. If the memo is not filed by second, the stay granted by this court stands vacated.
Please, grateful.
This is a writ petition, not which is emanating by one of the JDRs, a co-sharers, not out of a execution, which in turn emanates out of a FTP, not preceded by a preliminary decree. So, for the relevance of the case, there is a sketch which is attached.
So first of all, let us understand what is
Yes, I'll just come to that. I'll just come.
the IA.
No, it is not. It's a intra-court order. It's a intraday order. Where the executing court at 22, if my lordships could just see, 28/4/2026.
Page number?
22.
Yes.
22.
You're the JDR.
I'm JDR 1F. I have been allotted a share also. And DHR.
This order, let's read
Please,
this order.
I'll read.
28/4/2026 order.
DHR present, respective counsels present. In spite of direction of this court, JDR kept absent before this court. Shri BA has filed wakalat for so and so 9 Rule 7, setting aside of the ex parte order passed against JDR number 6. I'm not concerned with JDR 6.
Your JDR number 6.
1F.
1F.
1F. Learned counsel for DHR and JDR.
Is it JDR kept absent before this court? That is with reference to JDR number 7.
I didn't follow the question.
If you look at paragraph number 1,
Yes,
court
please.
says JDR kept absent before this court. That is JDR number 7 the court is referring to.
JDR number
First
6.
paragraph.
Yes, please. I
The
just,
court referring to JDR number 7.
I think JDR 6 or 7 was one of them, not me. Then the next parameters, learned counsel for DHR.
JDR number 1F. is
1F,
you.
I am there.
Submits that no objection.
No objection. The present petition has been filed seeking delivery of the position. Now JDR number 6 has come up with this application seeking setting aside of the ex parte order. That is not the issue in controversy. So that has been allowed. Hence IA number 2 is allowed on cost of 200. That is not the issue in case.
Yes.
Let him come on record. Then there was a delivery warrant issued against JDR number 1F written with Sharad that JDR number 1F has objected to delivery the possession in favor of the DHR, and the court has requested for the offense of the assistance of the police and the AEE for the identification of the clear portion which was allotted to DHR. Number 1. Peruse the same, even though there is a clear direction in of the Honorable High Court of Karnataka in WP number 23224 of 23, JDR number 1F has objected to deliver the position which was allotted to DHR as per sketch B produced by the court commissioner. And the PSA of Gonibidu is directed to give protection to DHR and court and any other person belonging to DHR while delivering position to the DHR as per
Yes,
share.
I've seen.
Please. Now this is the we are not objecting that the police should not come because even I want my position back. I'll just, if your lordship would see, this is sketch B. I will just show why the sketch B assumes relevance in view of the preceding order writ.
Oh,
Yes.
if there are any difficulties,
Minutes.
you have brought it to the notice of the court.
I'll just read the bailiff's report.
Filing an appropriate application.
Yes, but may I just read the bailiff's report? This is what minutes. I'll just take my lordship to the bailiff's report for a moment. The bailiff's report minutes is found at 40 minutes for a moment. My translated copies are at 40. Translated copies at 40. It is not. This is not a warrant issued against me. That's a misnomer. But it's a general warrant. Not that all of us want our position. It's not against me.
Yes.
On 4/3/26, went to the address as found in the possession warrant of the immovable property along with the plaintiff, and when inspected, there is no boundaries whatsoever to the immovable property, and 3 shops were existing on the said land. Cooperation of its
Yes,
assistance.
he returned the shara. What has happened?
Please minutes. Assistance. It has to be read as assistance. I'm sorry, it's a translation. Assistance of the surveyor is required to deliver the possession of the property to plaintiff, hence return the shara to the plaintiff. Then minutes, delivery warrant against JDR number 1 and so executed as need surveyor help to find the scheduled property. Then minutes, the next day, that is minutes again on this is the 22/4/2006. Your lordship will find the report at 40.
After that, what happened? After 11.
Same thing, minutes, same thing. They require the assistance of a surveyor.
Where do you get that?
45 minutes for a moment. For the purpose, there was another fresh warrant.
Surveyor is required, and at the time
Yes.
of taking possession, the defendants and their people made Galata a request to provide police.
Police help is required, and also for the purpose of identifying portion number 2. I'll just point out what is portion number 2. For the purpose of identifying portion number 2 in survey number 6/P11, item number 3, cooperation of the surveyor, it has to be read as assistance. Of the assistance of the surveyor is required, return with remarks. Then this.
No, without, at one stretch, he says that identification of the property is required.
Yes.
And at the other breath, he says that the property has to be delivered and police protection has to be granted.
Without identification, there cannot be that is what is our case. And what the court has done,
Counsel for the petitioner submits that. The court, without considering the fact that the property could not be identified even as per the report of the bailiff, wherein he specifically stated with the report, with regard to the report dated
22/4/26.
11/3/2026 and also 22/4/2026, which makes it clear that there is a dispute with regard to the identification of the property. Without identifying the property, the court ought not to have passed an
Police.
order to deliver portion of the property by giving police protection. For police protection. Next one, considering the report placed before the court, both the dates, it is so and so of the bailiff. It appears on the face of it that there is a dispute with regard to the identity of the property. Hence, there shall be stay of all further proceeding pursuant to the order dated 28/4/2026. Petitioner shall take out hand summons. Memo shall be filed by second, or else the stay granted by this court stands vacated. Yes.
Can I also be, because it's a out of district matter, may I be allowed to serve the trial court advocates instead of
Advocate, I said.
hand summons to the advocate, not appearing before the trial? That's all right. I'm great.
Petitions, my lord.
Yes.
Plaintiff petition, my lord. Suit for bare injunction, my lord. The father of the petitioners, my lord, have cultivated the unauthorized, my lord, by the government.
What is IA?
IA for TI, my lord, that was granted by the trial court, my lord. Against that order, my lord, they have prepared the MA. MA is.
Please come to the appellate court's order.
Please, my lord.
Page number.
Annexure G is the impugned order, my lord.
Where is it?
Annexure G, page number 52, my lord.
Yes.
Operative question, my lord. Page number 60, my lord.
Yes.
Para 12. On perusal of the copy of the list of applicants, it is noted that name of the father of the respondent plaintiff, namely Rache Gowda, son of Made Gowda alias Kattaya, appears in the applicant's column wherein he had filed the application for grant of landed property in survey number 101 to the extent of 3 acres. Based on the said application, the government granted the landed property only into the 1 acre 30 guntas jointly in favor of the respondent plaintiff and his wife. As such, whether to know that after the demise of his father, the respondent plaintiff has been cultivated the remaining land properly situated towards southern side of the suit scheduled property. It is request to be detailed trial, but at this stage it cannot be conducted full-fledged trial. Therefore, at this stage, this court is of the opinion that the respondent plaintiff is not having prima facie case and balance of the convenience obtain the injunction order against the appellant respondent. My lord. This is the order, my lord. But annexure trial court order, my lord, page number 35, annexures E, my lord. Operative question, my lord, page number 41. Page number 41 of the trial court order, my lord.
1 minute.
Please.
Where is the trial court's order?
Please, my lord, annexure E, my lord. Page number 35, my lord. 35. Operative question, my lord, page number 41, my lord. Para 15. Para 15, my lord. On carefully consideration of the plaintiff objections and documents submitted by both the parties, it prima facie appears that the plaintiff is cultivating the suit scheduled property by obtaining the grant from the government. But the contention raised by the defense regarding false document is a matter of address during the trial. At present, the plaintiff has established his case regarding his cultivation in the suit scheduled property by producing supporting documents and also balance of convenience.
Come to your plane.
Please, plaintiff
Come to your
annexure.
plane.
Please. Plaintiff annexure C, my lord, it is Kannada version, my lord. I have applied only, my lord, this so filed only in respect of
Finding of the appellate court that there are no, the entire property is a government property. You are cultivating.
1 acre 30 guntas.
Along with you, others are also cultivating. Please show to the court where
Please.
is the schedule of the property
Please.
and what are the boundaries to that property.
Please, my lord, whole my lord, 2 acres 37 guntas is there, my lord. Till today, my lord, they have not darkast, my lord. That is the darkast land, my lord. It is not fixed the boundaries, my lord, till today.
Then how will you get injunction?
Please, my lord, till today they have the difference, my lord. They have not till today they have not granted. They have application still pending for consideration there. But our application is allowed in respect of 1 acre 30 guntas.
Whether it is granted or not.
Please.
All of you are cultivating the government land.
Please.
So you're seeking injunction saying that you have been cultivating it from a long time.
1 acre
To
30
give
guntas.
injunction, there should be a boundaries to the property.
Please, my lord.
Where are they? That you
But my
please
lord,
show.
what is our submission, my lord? It is a huge land, my lord, government land, my lord. But till today, there is no
Notice to the respondents.
interim order, my lord.
Petition is permitted to take out hand summons.
Please, my lord, because of my lord.
No. We can't grant you an interim order now.
Because my lord,
If
what
the
is
memo, petition shall take out hand summons.
what is our
The
submission?
memo is filed by 17th of June. List this matter on 18th.
Please.
Yes, my lord. It's a partition suit, my lord. The impugned order is rejection of the amendment application filed by the defendants.
When was the suit? Which
The
year is the
suit
suit?
was filed in the 2023. The written statement filed on 24/6/2024.
the amendment application is filed on 1/7/2025, just to removing the word of plaintiff and, because in the written statement, deny the biological relationship of the plaintiff what they have set up. But unfortunately, para number 11, by in continuing wording, the plaintiff and the defendants,
That plaintiff is in Kannada.
the written statement in Kannada version, in page number 42, para number 11, in the last two line, ಪ್ರಸ್ತುತಪಡಿಸುವ ಅಂದ್ರೆ ವಾದಿಗಳು and ಪ್ರತಿವಾದ, that means plaintiff and defendants.
Para
number 11, second line, the ವಾದಿಗಳು ಮತ್ತು ಪ್ರತಿವಾದ means the plaintiff and defendants, the original propositor Nanja Bhavi, but in the rest of the contents, they given the clear distinction what there the plaintiff claiming the propositor is.
Come to your affidavit. Affidavit is also in Kannada.
Affidavit is also in Kannada, but in the only thing is what the propositor Nanja Bhavi claimed by the.
Now at least we'll understand from the order. Come to the order.
The page number.
What is the stage of the suit now?
Date of the suit is.
Not date, the stage.
Stage in the still one set of the peoples were made an application to implead. The still issue has not been proved, is still in
Proofs are not framed.
not being framed. The court observed that it is an admission, but it is not an admission. In the rest of the area of the entire written statement, categorically denied the biological relationship and their propositor's lineage.
Please come. Lend counsel to the defendant, lend counsel to the petitioner submits to the court without considering the application in its proper perspective, has dismissed the same. It is submitted that by virtue of the amendment, the nature of the suit is not going to change. And as observed by the court, there is no admission. It is a typographical mistake, but not an admission. And court ought to have allowed the IEA seeking amendment of the pleadings. Considering the submission of the learned counsel for the petitioner, there shall be stay of all further proceedings pursuant to the order dated so and so. The same hand summons by second memo on the counsel, or is the stay granted by this court stands vacated. Yes, 20.
Achha.
So what?
Suit for permanent injunction, my lord. I am aggrieved by the marking of photographs and the certificate under section 65B of the Indian Evidence Act, my lord. 20th February 2026, the documents were marked, my lord. Under the new BSA, it should be under Form A and Form B, my lord. And Honorable.
This is impugned order 20th February.
My lord.
Impugned order is of 20th February.
20th February 2026.
Let notice go. Notice to the respondents. Petition is permitted to take out hand summons if the memo is filed by 24th, this matter on 25th. Yes.
Plaintiff's writ petition, as against my lord, rejection of an application under order 26 rule 9. Lord, suit is for a comprehensive suit for declaration, possession, damages. Lord, I say this particular suitable property is carved out of survey number 9. Defendant say, because he says he also claims the same property.
What is the stage of the suit now?
Still, Lord, after completion of the trial, I filed this application on the ground that any number of evidence produced before the court would not decide whether it comes within survey number 9 or survey number 1. Lord, my prior was very limited. I have sought for, my lord, as a direction to the Taluka surveyor to have a ministerial act to say whether this site comes within survey number 9 or survey number 1. Trial court says plaintiff should have produced the layout plan or defendant should have produced the layout plan. But admittedly, these are all, my lord, revenue pockets. Yes, but relevant portion, my lord, starts at page 24, my lord. Till then, my lord, the trial court refer about the contentions of both the parties. Page 24, paragraph 13, my lord. The layout plan is a critical document in civil litigation, particularly in property dispute, that provides detailed scale, detailed representation of land, including boundaries, buildings, roads, and utilities. It serves as a visual binding guidance that defines ownership, establishes the local location of encroachments. It is needless to state that with the layout plan, the property can be identified accurately. It also helps to prove that property was purchased or developed in accordance with the officially approved layout. It is material to note that the plaintiff has sought for certain reliefs by filing the suit, shall produce the layout plan at the inception in order to define the area of the dispute. In the written statement, defendant number 1 and have specifically denied that defendant number 3 to 10 being legal heirs of Nojira formed sites in the portion of land bearing survey number 9, and have stated that one Veerappa was the owner of land in survey number 1 of Gavipura village, sold the same in favor of Muni Chinnappa, son of so and so, and a registered sale deed dated 5/10/1950, who in turn sold 38 guntas of land in survey number 1 Gavipura village in favor of Annayappa, who subsequently formed layout in survey number 1, and the defendant's property is one of the sites in the layout formed by Annayappa, who executed irrevocable general power of attorney.
Documents that are filed by you
Pardon,
to establish this fact.
Pardon,
No, the whole issue is with regard to the survey number.
Yes, my whole issue is that.
Well, let us see your plaint. What is the suit for?
Yes, ma'am. Suit is for, my lord, the client is at, my lord, annexure B, page 28, my lord. It starts from page 28.
Declaring that?
No, prior, my lord, is at,
Poverty.
yes, ma'am, page 38. Declaring that plaintiff is the absolute owner of the social property, and defendant number 1 has not acquired any valid title and interest over the social property by through the sale deed dated so and so.
Counsel for the petitioner submits that. The petitioner has filed an application for appointment of an advocate commissioner. Where is your IA?
That application is at, my lord, annexure D, my lord, page.
Filed an application. Under order 629 to appoint a taluka surveyor attached to the office of the
Page 61.
Bangalore Urban District to conduct the ministerial act of survey of the scheduled property to ascertain as to the survey number of the land in which the same is located. It is submitted that the petitioner has adduced the evidence from the site, adduced evidence to prove his case, and as to decide the dispute between the parties, the appointment of the taluka surveyor is very much necessary. And these aspects were not considered by the court. Considering the submissions, state notice to the respondents in addition, and summons. Memo shall be filed by 2nd of July. If the memo is not filed, stay granted with the transfer case.
Bless.
I'm in a peculiar situation, Lord. But I invited government to open a government school in my ancestral house in a remote place, my lord, in South Canara. From 1956, my lord, there is a school which was running. Subsequently, my lord, there were no students in that school and it was being used for illegal activities. Therefore, I filed a suit for ejectment. 2005 was the suit.
No, how did you let them?
No, there was a lease. There was a lease, very nominal amount of lease.
For how many years?
Lord, it got extended from time to time. 2005, I filed a suit for ejectment.
Purely lease.
Yes. Then, Lord, 2008, there was an order of ejectment. They challenged it in appeal unsuccessfully. Later, my lord, they said that they will acquire this property. There was a notification under the Land Acquisition Act for acquiring that lapsed. They did not take steps. There's a confirmed by the division bench of this honorable court. Then, my lord, 2022, I filed a execution petition for, my lord, enforcing the decree which has been confirmed by in appeal. In that, my lord, they file the school, my lord, administration, one of the persons, he files an application for, my lord, as an objector. And then, my lord, from 2022 till now, matter is again and again posted for negotiation. And in the meanwhile, my lord, what they have done is they have completely, my lord, it's in a situation, kindly see, my lord, page 123. This is my house which has reached this stage, 23 onwards, completely dilapidated. Roof has given way now, and they're not only one part, my lord, they use it, my lord, on and off. Not there is no school. They have got a new building now. But somehow they don't want to, some ego issue, they don't want to give back my Lord house. But I have tried my best, having Lord no other option. Kindly see the order sheet, my Lord. Even now, today it is posted for negotiation, page 120. Lord, Supreme Court has now said that execution has to be completed within 6 months. That has also been brought to the notice of the Honorable Court.
There is an element of settlement between the parties. Both the parties are
There is, we have, my Lord, earlier round, we have, my Lord, participated. We have said that
No, you should have brought it to the notice of the court that you are not interested for a settlement.
we have done it. We have filed a memo.
Where is that memo?
My Lord, I have not produced it. I have even, there is a report, my Lord, also which says that there is no,
This mediation, this process is going on from when?
my Lord, for the last 2 years. And my Lord, it is mediation, they don't say now mediation. It is posted for negotiation. For negotiation by. So it is now going on for negotiation. There is no,
So what is the relief you are seeking?
Lord, I'm not seeking relief, my Lord, of, I want the order to be set aside, which posts this case for negotiation. In the meanwhile, my Lord, the court has to take a decision of enforcing the, my Lord, decree. It can't be, my Lord, from 2008 till 2025, my Lord, and in the meanwhile.
Take court hand summons will decide the matter.
Yes.
This is matter on 18th of June. Will you be able to take out?
Yes, yes.
Please this matter on 18th of June. By the time the petitioner should take out hand summons and to the counsel appearing for the respondent before the trial court, we shall file a memo to that effect by 17th. If the memo is filed on 17th, list on 18th.
Great.
Yes.
But I appear for the Petitions Council. The second round of litigation, here there were backbuilding in respect of 3 meters. Then in respect of the meter bearing number 18656 millard, the Honorable Court has set aside the said backbuilding at page 49. Got it, millard?
1 minute.
Demand notice at annexure B1.
You are questioning the order dated 19/2/2026.
Yes, madam.
Letter dated 1/4/2026.
Yes. Last can you
To
come to
refund
page
the
49,
amount.
madam? Page 49.
No, before that, what is it order dated 19/2/2026?
26, madam.
19/2/2026.
The order passed by the ombudsman, madam. They say, madam, instead of giving reconnection as per the order passed by the Honorable Court, madam, the ombudsman is of the opinion, madam, that the amount is liable to be payable in respect of the water pump, and the amount which is to be refunded to me has to be adjusted to that meter, and therefore has dismissed the appeal. Rashmi, can annexure email.
Page number? Yes, page 92.
92.
Before this, the order of this court.
Before that,
Where is that order?
Page 49. Operative portion. Demand notice at annexure B1 so and so, Yelahanka, so and so is set aside. Consequently, my lord, there should have been a reconnection to me.
So, no. As far as annexure B, that is dated 6/1/2017 is concerned, the matter is remitted to respondent number 1.
There are no, madam, there are 2 means. Insofar as 1 meter is concerned, my lord, on the wrong submission made by the counsel for the KPTCL, I admitted, my lord, I would go for change of the meter. And insofar as the another meter is concerned, the matter has been remitted back to the appellate authority. Insofar 1 meter is concerned, annexure B1 is concerned, the first portion, it is allowed.
What happened with regard?
Ombudsman
has taken up with regard to this meter also.
Pardon me?
Ombudsman has taken up with regard to
Then,
this
since there was no reconnection pursuant to this order, in respect of the meter bearing number 18656, I took up the matter before the ombudsman. The ombudsman, as per annexure L, page 92.
Where do you get the meter number with regard to this? Come to the order portion, order discussion.
Of ombudsman, madam?
No, of this court with regard to the demand
Page,
notice B1.
Rashmi, can you see page 48. after para 10, my lord, para 10. From the above submissions and on perusal of records, this court is of the considered view that the impugned order be modified, taking into consideration of the following aspects. In view of the voluntary submission, concession made by the petition that he would make necessary application.
So because, what did you say? You would make necessary application.
No, I will come. This is first portion is in respect of the water pump is concerned. Next, my lord, as regards B portion. Now I am concerned with the order passed by this court insofar as the B is concerned.
This is the number of the meter,
Yes.
18656?
As regards demand at annex B1 bearing number so and so, pertaining to sanctioned floor of the premises which is let out for residence purpose, even as per the tariff schedule, the same falls under LT2A category. As such, petition with respect to said demand requires to be allowed.
As far as this meter is concerned, it's allowed.
Is allowed.
Then what is
Then, my lord, they should have, there was a disconnection. Since they had not given, my lord, I went on giving representation. Then, my lord, I went to the ombudsman. You last may kindly see the order passed by the ombudsman at page 116. Operative portion. Before that, my lord, may I take your lordship to page 109, page 33.
Who appears for the respondents?
H.V. Devraj.
We'll take it up tomorrow. In the first list itself. This is marked tomorrow in the first list. Mr. Devraju is directed to take notice on behalf of respondents 1 to 5. Oh, he's here.
He is here.
Sir, papers are served.
No, I have not given. I will give.
Or pass over or tomorrow?
That may kindly take day after tomorrow. I'll get instructions, but that way.
Day after tomorrow, in the name of Ms. Devraju is directed to take notice. Counsel of the petitions have the copy of the writ petition. Day after tomorrow in the first list.
I appear for the petitioners. I appear for the petitioners. That this case where that with regard to the compensation payable to the landowner on account of the drawing of the high tension line, where that line was drawn by notification was issued 2007. Subsequently, that work has been executed, compensation has been paid, consisting of that where, as per the Deputy Commissioner order, that entire compensation is paid to the extent the 12,37,081. With regard to the crops and diminution value of the land and other things as all has been
When
paid.
was the order of the DC?
DC that it has been determined per acre that taking notes of
When is the order?
2018.
18.
And then insufficient he files a petition under section 16(3) for enhancement of compensation. The land district judge that it is a taken note that subsequent notification of the value of the land that per acre the 62 lakhs that where that the diminution value that it is 50% of that 50% that it has all along this honorable court has taken the 30% of the diminution value. And other things is that earlier which has been paid diminution value which has not been taken notice concern. That 50%.
Earlier, what is per acre? How much is taken by the Deputy Commissioner?
2 acres, 2 lakhs.
2 lakhs.
Yes.
And as per the court?
As per the court, 62 lakhs.
Is per acre.
Subsequent notification. Per acre. Even assuming that it has been taken that it is in concern 62 lakhs. That it requires to be taken to 30% of the diminution.
No, you accept.
No, I am not accepting that it is a. So, for 2 arguments, I am that taking 50% of the diminution value.
First of all, if we take what is the market value, then how much would be the diminishing value? It's 50% is right or 30% is right, that we will go into. So first of all, we have to see if, because there is a lot of variation, 2 lakhs.
That variation is there. That variation is there. The 2 lakhs Deputy Commissioner, by virtue of that order, that 1 acre.
How he has determined 2 lakhs as a market value?
That taking that report from the Tahsildar, he has determined.
And this is?
This is not based on the sub-register value, SR value.
That is how, that is.
That is the how that it requires to take into at the time of determination 2018, earlier where the work has been executed. That this is the notification is subsequently 2019. The 19 amendment that it has been enhancing the market value that has taken so far as that is concerned. And relying on the dishonorable court judgment.
So instead of giving stay and all, take out notice. So
I'll take out that subject to depositing that it is so far as that is concerned 50%.
How much is now this
That
directed?
award is not that it is in a 31 lakhs.
Let's see which page it is.
That operative portion, 35 lakhs 65,000 rupees.
Page number.
Page number 89. As not that calculation, that 30% it take a note.
How much it will come to?
That the 89.
No. If you as stated by you.
Yes.
If you calculate the diminishing value at 30%.
Yes.
How much it would come to?
The 21 lakhs 39,200 requires to be paid. Plus that earlier we have paid 2 lakhs 30,000 rupees. That requires to be deducted. That we bound to pay 19 lakhs 9,000.
19 lakh?
9,000.
So deposit 19, let them
That
them withdraw the money also.
Like withdrawal that let come so far as that is concerned. I'll deposit land trial court so far as that is.
No, as per the calculation.
That with regard
some amount they should be permitted to withdraw.
Then after their appearance, that it can be that it is after hearing the matter. That so far as deposit, that I will ready to deposit so far as 19 lakhs 9,000.
Please come. At least some amount will direct them to withdraw. 10 lakhs they can withdraw at least. When there is undisputed, you are only on the point of
undisputed not with regard to the even assuming not an admitting so far as that is concerned. Value it is in a
have to look at it because the lands which are acquired and
it is not an acquired blood, it is a right of way which is utilized.
Whatever it is,
yes.
You have used it for some purpose,
yes.
for some public purpose. And this is in the year 2018, we are in 2026. We can't keep the matters pending like that, saying you deposit. If you deposit, what is that? How it is inured to their benefit, unless until they draw it. So, if you make submissions on the merits of the matter, if this court is convinced on that,
let them kindly order to issue notice. If any urgency is there, I'll move it and let it appears that so that I can dispose of the matter.
Respondents. Yes, this is matter after service of notice.
Much.
I beg to appear, my lord, for the petition.
Yes.
My lord, the petitioner is running a star hotel. My lord, there was a dispute, my lord, whether what is the license which had to be obtained for a star hotel. Earlier, my lord, we were having CL7.
Excise matter.
Excise. CL7 license was there. My lord, the department said, my lord, we have to take a CL6A license. And my lord, therefore, my lord, we paid the fees also to the CL6A license also. Fees was paid. Subsequently, they did not give us the license. We came before this court, my lord, in the earlier round of litigation. This court directed us, my lord, to continue with the business and directed them to consider our representation for issuance of 6A license. They issued a 6A license. During those time, my lord, there are some products, that is the liquor, which is in our custody. That has been seized by them. And they are not, my lord, releasing those items, which are perishable.
Please come to the earlier order.
My lord, may I take your lordship to Annexure H, my lord? Page 34. My lord, these petitions were pending. Annexure H. The interim, subsequently, my lord, these petitions were disposed of as being infructuous because license was given. Now, my lord, the interim order might be kindly seen. The last, my lord, the order dated 2/7/2024, my lord.
4/7/2024.
Yes, ma'am. 2/7/2024 and my lord 4/7/24, both the orders.
2/7/20.
That was the first order.
Oh, yes.
So as per this, my lord, they have now issued the license.
Let's read it.
Yes, ma'am. 2/7. In the grievance of the petitioner that he had applied for renewal of existing CL7 license and the same time, in the light of the objections raised by the department, he had also sought for a new CL6A license by paying the necessary fee. It is his case that the application that he has filed for grant of new CL6A license has not been considered and his request for renewal of CL7 license has not been considered. It is his case that, as a matter of fact, the Excise Commissioner has passed an order on 29/6/2024 extending the validity of the existing CL7 license till 7/7/24, and notwithstanding the said letter, the department has seized the premises of the petitioner. Learned AGA submits that the application of the petitioner for grant of CL6A license will be considered. In my view, having regard to the fact that petitioner has an existing CL7 license and has stood extended till 7/7/2004, the department shall permit the petitioner to conduct his business till 7/7/24. Now, my lord, after that, on 7/7/24, next order, your lordship may kindly turn to 4/7/24's order. May I read, my lord? In the objections filed by the state, it is admitted that petitioner has paid a sum of rupees 11,50,000 for grant of CL6A license, but it is stated that he did not make an application despite grant of time. So and so appearing for the petitioner submits that as a matter of fact, the petitioner has in fact made an application for grant of CL6A license and has also produced all the relevant and necessary documents. In view of the said submission, the second respondent is directed to consider the application filed by the petitioner for grant of CL6A license within a period of 15 days from today. The interim order granted by this court directing department to permit the petitioner to conduct his business shall continue till the next date of hearing.
Yes, come to the present.
My lord, now, your lordship may kindly turn to annexure A, my lord. Sorry, my lord, it's in
What it says.
Kannada,
Hmm.
page 19, my lord. It says, this, my lord, they refer to 4-5 letters, my lord, internal communications, which copies have not.
Why they have seized
My lord, that time, my lord, since we were running the Star Hotel under CL7 license, they had come and seized it. Now, my lord, we had in fact paid the fees also, then we have been given CL6A license. Now, since the license is already there, they have to, my lord, release it.
that time when they have seized, we were not having the license and
My
contrary
lord,
to
that
the
is,
license.
my lord, that is what we think, my lord, is the case, because they do not pass any orders of seizure. They confiscate because section 43 of the act says,
You the act.
section 43A, the procedure, my lord, is contemplated. The 43 of Karnataka Excise Act, my lord. 43A. May I pass on? Government.
Yes.
My lord, this is the procedure, my lord, what has to be done once the confiscation has been done.
Yes.
Confiscation by excise officer in certain cases, notwithstanding anything contained in this act or any other law for the time being in force, where anything liable for confiscation under section 43 is seized or detained under the provisions of this act, the officer seizing and detaining such property shall, without any reasonable delay, produce the same before an officer not below the rank of superintendent of exercise, authorized by the government in this behalf by notification herein referred to as the authorized officer. Next, on the production of the seized property under subsection 1, the authorized officer, if satisfied that an offence under this act has been committed, may, whether or not a prosecution is instituted for the commission of such an offence, order confiscation of such property, provided that the authorized officer may, pending final disposal of the proceedings in respect of the property seized under subsection 1 and subject to this section and section 43B to 43G, release the seized property except accessible articles to the owner of such property, release the seized accessible articles to their owners if he possesses a license under the act or the rules made thereunder on production of bank guarantee issued from the scheduled bank for a sum equal to the value as estimated by the authorized officer, which shall be renewable by him from time to time till the final disposal of such proceedings.
My lord, will file our objections, my lord. The state will file its objections.
When was this,
My lord.
when was the confiscation?
My lord, it was 10-1, my lord. My lord, it was seized on 27/1/2026. Subsequently, we wrote a letter to them, my lord, bringing to their notice, my lord, which I produced as annexure. On that, my lord, the deputy commissioner says, find out whether it is, if it is clinically proven or not, whether it is a correct liquor or not. Then you take action, then you release it. They do not do anything. Now the commissioner writes, you, my lord, destroy it.
I'll verify minutes. I'll verify minutes.
Get instructions, first
Please.
of all, before filing your objection.
Please.
List this matter day after tomorrow in the first list.
My lord, let them not, my lord, destroy anything, my lord, as on today, let it be there.
Tomorrow I'll take it up. Tell them not to do and get instructions by tomorrow.
Please, please.
This is a matter tomorrow in the first list. AGA accepts notice on behalf of all the respondents.
Yes.
Yes.
Lords, the two respondents, my lords, insofar as respondent number 1, I've paid process fee, my lords. Insofar as R2, my lords, I'm seeking dispensation, my lords.
Where is the memo? Memo is filed seeking dispensation of notice to
R2.
Dispense with at the risk of appellate. What about R1?
R1, I've paid process fee, my lords, it is await
It's a
notice.
2024 matter. The suit is pending before the trial court. Take
I will
hand
take out,
summons. Petitioner is permitted to take out hand summons on the counsel appearing for the respondent and shall file a memo to that effect. by 24th of June, or else the CRP shall stand dismissed as far as the first respondent is concerned.
I'm so obliged.
Is the only respondent.
He's the
Now,
only respondent.
then
It is a suit
the-
for
the-
eviction,
The
my lord.
revision, the CRP shall stand dismissed without further reference to the court. Yes.
I'm so good.
Lots. Two, she has not been taking notice at all. And 2012 eviction matter, and there is an interim order of stay, my lords. In fact, respondent
No
two is not even
representation
the,
on it's a matter of 2025. The process is not paid for issuance of notice to R2. And the vacate petition is filed by R1. This is matter for dismissal on 15th.
great.
And the registry is directed to inform the party in person. Yes.
Whether in 3, respondent number 102 may be treated as held sufficient. They have refused to receive the notice.
Where do you get that? Unclaimed.
Whether for others I will
The
take,
cover
others I will
returned,
take and
in
summons.
respect of R102, the cover returned with postal serra as unclaimed amounts to deemed service of notice. And where do you get for the others?
Others, my lord, I will take notice to their counsels appearing before the trial court.
You should have done it by this time.
Please, my lord.
No, where is it refused?
102, for 102 it is refused.
Unclaimed.
For others, so we have
For
to,
other respondents, in respect of R23, R30, 33, 35, 37, 38,
my lord, I will,
23, 23.
so all of them I will serve the summons, copy to the
All
learned counsel.
this, only this 23, 30, 33, 35, 37, 38.
Yes.
The petitioner shall serve the counsel appearing to these respondents before the trial court and shall file a memo to that effect by 24th of June, or else the writ petition shall stand dismissed without reference to the court.
Yes, please.
Yes.
Interim order may be extended.
Interim order is extended till then.
For the petitioner,
I
please.
appear for respondent number 1, my lord.
My lord, I have just received instructions that I may be filing the memo of withdrawal, my lord. The party hasn't.
It is submitted that the petition will come up with a memo for withdrawal. List this matter tomorrow.
Please, my lord. Much obliged.
Tomorrow in the first list. Yes, 5. No, tomorrow same list, not first list, in the second list. Yes, 5.
For petitioner, but issue notice to R2, my lord. The other two connected matters, R2 is appearing. If they undertake to file the wakalat, my lord,
Where is R2?
the other two connected matters appear.
Vandana PL.
Please, my lord.
Vandana PL is directed to take notice. Where is she? Or is to take out notice on the counsel appearing for the respondent before the trial court?
Trial court, my lord.
Because again, they will come up and say that we have no instructions to appear.
Otherwise, my lord, I will take steps, my lord, let them file the wakalat in the meantime.
We can't keep the writ petitions pending like
Please.
this.
Because, my lord, the other two connected matters, she is appearing for the 1 and 2.
There is no representation on behalf of the counsel appearing for respondent number 1 in WP 31219 of 2025. Then counsel submits that. No, in all the matters, her name is there.
Please, my lord, the other two connected matters, my lord, she is appearing. For in this matter, my lord, for R2, issue notice. R2.
It is submitted that in 5.1 and 5.2, that's WP 27323 of 2025 and WP 27726 of 2025. Counsel Vandana PL is appearing for R2, whereas in 5, she is appealing only for R1. This is matter on 16th of June. By the time the land council shall get specific instructions whether she undertakes notice for R2 or not. Yes. You have an interim order.
Please, interim order.
Order earlier granted is extended. Yes, 6.
Please. I have given counsel submission notes for the office objection that has been raised. Office objection may be kept in abeyance notes for the moment.
Why?
I represent
What
the
is the
respondent.
office objection?
Notes that the trust is not made as a party is the office objection that is raised.
What is, in the suit, it's a party.
No, a suit is a party. What had happened is this, my lord. Trust was a party. It was represented by the then trustee, one Mr. Varadaraj Prabhu. Varadaraj Prabhu died. And after his death, my lord, the impleading applicant, who is the respondent in all these cases, filed application to come on record as per the terms of the trustee. That application has been decided subject to ultimate decision of the main matters in all these cases. This is what has happened is the trust has not been made party. That is office objection raised.
The right, my lords, of that Varadaraj Prabhu to represent the trust itself is in dispute, and this honorable court, my lords, at page 188, in an identical, my lords, dispute between the parties, has held that person has no locus standi to represent the trust.
So whatever it is, you are questioning a particular order passed by the court.
That one more
Whoever are
aspect
the
is
parties, they should be represented here.
Please, my lords, I will amend the cost title to that effect, my lords.
The office objections shall be complied with. You have an stay in this.
In all the four matters.
No, not in all the four matters.
ಎಲ್ಲದರಲ್ಲೂ ಇದೆ.
ಎಲ್ಲದರಲ್ಲೂ ಇಲ್ಲ.
Defer of the proceedings ಅಂತ ಮಾಡಿದಾರೆ last. There are interim orders, my lords, in all the four matters.
In one case, my lord, the order was passed not to pass, not take any further steps. In other cases, my lord, there is an interim order. Stay of further proceedings. My only request is, my lord, let him comply with the office objections.
Office
And in the
objections
meanwhile,
shall be
my lord, one more aspect is there.
Interim order granted earlier is extended till the next date of hearing.
No, my lord, one more aspect is, in two of the matters, the impugned order passed by the court below is in Kannada language, my lord. I'm not very sure, my lord, whether the lordship would be comfortable.
I will also
file
take
the translated copies of the impugned orders.
A date may kindly be
This
fixed.
matter on 2nd of July.
Please, interim orders in all the matters.
No, whatever interim order is there, it may be.
That's what I said, whatever interim order.
Yes, that's it.
Look at it in all the matters, whatever is interim order. Just say interim order earlier granted is extended. Yes, next.
Great.
I appear for the petitioner. The objection is that proof of service is not filed, PF is not furnished. I was permitted to serve the respondents by hand, my lord, on 13/3/26. I filed a memo with an acknowledgement to that effect on 4/4/26. Both the respondents have been served by hand.
Where is that memo?
Memo is dated 4/4/26, my lord. It was filed in the counter. One of the respondents, my lord, through counsel has appeared.
You appear for respondent number one.
I have filed Kalat also.
I think memo is not put up in the file.
I'll verify.
Counsel appearing for the petitioner submits that. Already the petitioner has taken out handsomens on the respondent 1 and 2. And the respondent 1 is represented by advocate, and she has filed a memo to that effect. Registry is directed to verify the same. You have an interim order in this?
No, my lord. Interim order was not.
This is matter on any urgency?
Please, my lord, there's some urgency. The execution.
On 17th of June.
Lord, the execution proceedings are listed on the 11th. May I request for tomorrow or day after?
The matter
There's
on.
some urgency.
On 10th.
On 10th, my lord. Great.
May I please? The next,
Two
my
R2
lord.
returned as
Yes. R2
R2
is
as
unclaimed.
unclaimed and R8 and R9 as refused amounts to deemed service of notice. Yes,
The remaining are served, my lord.
Yes.
They are represented.
yes.
The suit for injunction. That was decreed in my, that is my suit and it is decreed. The appeal filed by them was dismissed. And so also the SLP before the Honorable Supreme Court. Yet, they tried to interfere with my lawful possession with respect to the two items of the lands. Therefore, I filed the execution case.
When was the order of in the SLP, confirming the order?
The SLP. My lord, I have produced the SLP order on
Dated,
page, my lord, 178.
dated,
178. my lord.
dated.
6/6. 1 minute. my lord.
6/6?
13/2/2026.
13 to
6/6.
20.
13/2/26.
13 to 2026.
13/2/26.
Yes.
All that they have said, we are not inclined to interfere and so therefore dismissed. It is not in dispute that concurrent findings in both appeal, suit and the appeal in my favor. Therefore, he has no right to interfere with my lands. So we have filed the execution to take action according to law for the disobedience of the decree. Now we made an application also seeking police protection to put up the compound wall to safeguard my own property, not his property. That application is dismissed, stating that I have not made out a ground, against which, my lord, the present writ petition is filed.
Please come to the order. Execution is filed much before the SLP orders. It is execution of the year 2025.
Yes. After the High Court order. After the High Court order.
Yes.
That is one part of it, my lord. The second part is they filed another suit for relief of injunction, and that was dismissed.
With respect to the very same properties.
Different suit, not the very same suit. And as against that, we filed an application for in that suit for rejection of the plaint that was dismissed, against which we filed the revision here before this honorable court. And they also filed one more revision. All the two revisions and the one writ petition was clubbed and a common order is passed. My revision is allowed, and their suit that is filed for injunction relief is a plaint is rejected. I take my lord's attention to the common order passed by this honorable court in 2 CRPs and 1 WP recently. That is also
what is under challenge is at page 17, my lords.
1 minute.
We'll see from paragraph number 24.
My lord, page 155, my lord.
Paragraph number 24.
24 of the impugned order. Yes, that I'll read it. My lord finds it, the order on page 21. I number 1 filed by the decree holder under 24.
You can come to paragraph number 24.
Internal page 34.
On perusal of the aforesaid provision of law, it is clear that only two ways are available under law in order to enforce a decree for permanent injunction. That is, one by detention of the judgment debtor in civil prison, and another by attachment of his property, or by both unless and until the disobedience of the defendants for judgment debtors is shown and established. In the case on hand, the decree holder have not placed substantial materials before this court, as observed by the Honorable High Court of Karnataka in the above referred writ petition, to extend the police aid to the decree holders in violation of the permanent injunction granted by judgment and decree invoice number 124 of 2018 dated 3/8/2020. It is very clear that when the execution petition filed under Order 21 Rule 32 of CPC for enforce a decree of permanent injunction by arrest and detention of judgment debtor to civil prison or by attachment of property or both, pending consideration of the said petition to exercise powers under section 151 CPC, the executive court cannot direct the police to ensure obedience to the decree. Therefore, if there is a violation of injunction by the judgment debtor, the court, while pass the decree, can order detention and attachment.
Yes, I've seen the order.
Yes. So all that they say is only attachment and detention is provided, therefore police help is not provided, therefore.
And is it the case that the applications are pending? Whether there is any disobedience of the order of injunction, that application is pending consideration?
Execution proceedings is pending, my lords.
Or everything is over, my lord.
Execution proceedings are pending as per
What
the
is
order.
pending is the execution petition.
That's
That
what.
is pending. Now, what I am seeking is not enforcing the decree or any such thing. My land is there, and I am in possession, is also accepted by the three courts, trial court, first the Honorable High Court and the Supreme Court. When that being the case, I want to fence it to protect my own property, and I sought for the police help. I respectfully submit.
Yes.
Lords, the fact of the matter as on today is We are in possession from the past 4 decades. He has sought in his suit, the relief sought is permanent injunction along with declaration, which is granted. Therefore, my lords, the execution proceeding itself, going one step further, my lords, the execution proceeding itself cannot be, the order cannot be executed at all.
What
Today, I am
else?
holding the possession.
You lost till Supreme Court and you say that I am in possession of the property when their suit for declaration and injunction is decreed.
My lords, I would like to place one submission. What the order by granting a decree of injunction, the court has only declared his right. It has not conferred a right of possession to him. What the decree holder today is trying to do is, what he cannot do directly, he is trying to achieve it indirectly. My lords,
Your case. Suit is for declaration and injunction saying that he is in possession of the property and you should interfere.
very well.
And is there any finding that you are in possession of the property and he has not sought for recovery of possession?
My lords, that is not an observation which is made, my lords. Let me for a moment, let's keep this aside for a moment, my lords. All that today, my lords, the scope of the proceedings here is that he seeks an application under 151 and seeks police protection in the execution proceedings, my lords.
That submission I can understand. But the prior submission you made, I am not able to understand that. You say the suit for declaration injunction is already decreed, which has attained finality. It went up to Supreme Court, but I am in possession of the property.
My lords, under section 34 of the specific relief act, he has to seek all the reliefs. What he ought to do was declaration, possession and injunction. He has not sought possession.
Where is,
Therefore,
that's what I asked you a specific question.
I understand.
Where is the finding with regard to your possession?
My lords, that is for me to establish in the inquiry in the execution proceedings. I can do that very well now.
Not take up in your in a written
I have.
statement.
I have.
What is the finding on that?
My lords, there's no finding with respect to my possession.
That
But-
means what about it means that there is no finding means he is in possession of the property.
My lords, that's
Court
an
has not
implication.
accepted that you are in possession of the property.
Very well, my
And
lords.
if that is the way, if these proceedings have to be, then there is no finality to this litigation.
My lords, all that I would like to submit today is this execution proceeding is still going on. That is filed
That
under
you can make, that
21.
submission you
Very
can
well,
make.
my lords. I'll press on this submission, my lords, not the other submission. Order 21, rule 32, my lords, for a moment later. Let me read order 21, rule 32, my lords. Where the party against whom a decree for a specific performance of a contract or for restoration of conjugal rights or for an injunction has been passed, has had an opportunity of obeying the decree and has willfully failed to obey it, the decree may be enforced in case of the decree of restitution of so and so, in the case of a decree for specific performance of a contract or for an injunction by his detention in civil prison. Therefore, my lords, here the decree holder will have to show that I have not obeyed the decree and willfully failed to obey it in the inquiry proceedings. Therefore, my lords, today this application, my lords, cannot be considered. The execution proceedings are going on, and therefore it is for him to establish that I have disobeyed it.
Yes, God reserve. Yes, next.
Much obliged.
Orders of reserve.
Reserve.
May I place a few judgments before the court? Madam?
Yes.
I'll place it in.
Take those judgments.
Take it. Amin court.
No representation for dismissal. Yes, next.
The petitioner. Respondent, may I seek for a pass over?
But actually, other defendants have to be served, not other co-plaintiffs.
Await service of notice.
Yes, if
to
we,
R3
in the
to
meantime,
R5.
we could take notice on the council
Notice to-
representing.
Notice to R1 returned with a postal shudder unclaimed amounts deemed service of notice. R3 to R5, council for the petition is permitted to take out hand summons and file a memo to that effect by 24th of June, or else the stay granted by this court stands vacated. If the memo is filed, list this matter on 25th.
25th. But in the meantime, we'll permission to serve the council on the
Council.
council on the lower court.
Hand summons is on the council.
Yes, stay has to be extended.
Interim order earlier granted is extended till then.
Yes, please.
Memo is filed seeking dispensation of
Petitioner by
notice to
appearing for the respondent.
R1 and R3 or R1 to R3?
R1 to 3.
R1 to 3, Momo is taken on record and notice to 1 to 3 is dispensed with. Then what about R4? You appear for whom?
No.
R12 and 15, my lord.
12 and 15. Petition is permitted to take out hand summons on the counsel appearing for the respondent before the trial court. That is R6 to 9. R6 to 9. And shall file a memo to that effect. The R6 to 9 and you appear for R11. No, R11 also. R6 to 9. Where is that? Notice to 10 and 11 returned with postal share as unclaimed amounts to deemed service of notice. They shall take out hand summons on the counsel appearing for the respondents 6 to 9 before the trial court and file a memo to that effect by 24th. If the memo is not filed, the stay granted by this court stands vacated. Yes, next.
I may kindly be extended.
Interim order earlier granted is extended till then. Yes, 12.
I am proxy counsel for R1.
For the petitioner, my lord.
Complete.
Filing the memo, my lord.
Memo for?
The trial court advocate for respond number 1 to 4 refused to accept the hand summons, my lord, issued by this honorable court. I am for the petitioner, my lord.
Take that.
As per the system, advocate for R1 and R2, they are on record, my lord.
When the matter is coming up?
Last date, it was 6th 4, 2026, my lord. Next month, my lord.
Next month is coming up.
With regard to the R5, my lord, necessary application will be filed for the paper publication, my lord. R1 to R4, they're all relatives, my lord. And the same advocate is appearing for R1 to R4 before the trial court, my lord. He has refused. Appropriate order may be passed for R3, R4, my lord.
I am proxy counsel for R1, my lord. The service is necessary for R5. It is incomplete.
Yes.
And there are concurrent findings in my favor, both the trial court and appellate court. Moreover, the orders of the appellate court alone has been challenged here. The trial court has not been challenged here, my lord.
My lord, if they're ready for hearing, I am ready for hearing, my lord. With regard to the service of the summons, with respect to the R5, necessary application will be filed for paper publication. R3, R4, trial court has refused. Trial court advocate has refused.
Is it the advocate appearing?
He is the advocate for R1 to R4 who is on record, my lord, before the trial court in OS matter, my lord. Affidavit is filed, my lord, from the advocate.
It is submitted that the matter is coming up on?
Next month, my lord.
What is the date?
I may be excused, my lord. It's not on record.
It is submitted that the matter is coming up before the trial court in the next week. Then on the day when the matter comes about this order, you draw it to the attention of the court and advocates will be representing. Then we will record. That is better. You bring it to the notice of the court that a hand summons is directed to be taken and it is refused by the respondents. I'll ask the trial court to record it. It is submitted by the land counsel that. So, as per the order, when they have taken notice on respondents number, advocate appearing one Mr. What is the name? Mr. S.N. Murthy, advocate and associate.
Krishnamurthy, my lord.
Krishnamurthy.
Respondent's advocate, my lord. It's different.
S.N. Murthy, you wrote.
Oh, yes, ma'am.
Mr. S.N. Murthy, appearing for the respondent before the trial court. He has refused for the same. He submitted the matter is coming up before the trial court. This aspect, whether the advocate is appearing for the same, is still representing the respondents. This aspect shall be brought to the notice of the trial court, and the trial court in the order shall record with regard to whether the advocate is appearing and whether this aspect of pending WP is brought to the notice of, is in the notice of the respondents or not.
With regard to the R5, necessary application will be filed for paper publication.
Petition is permitted to take out, even for
R5,
R5, no
my lord.
advocate is
No,
represented.
my lord. The R5 is the second defendant before the OS matter. my lord.
No, there the advocate is not
No,
there.
nobody's coming.
The petition is permitted to take out, is permitted to come up with an appropriate application for issuance of notice to R5 by way of paper publication. Yes. Yes, next.
Acha.
For petitioner, my lord. My lord, there are office objections to comply. Kindly give us 1 week time to
A
comply.
week's time to comply with the office objections, and the petitioner, it is stated that the petitioner has not taken the hand summons. Petitioner shall also take the hand summons by the next date of hearing. This office objections within a week, hand summons also within a week, or else the stay granted, but the petition shall stand dismissed. Is 14.
It is listed for maintainability under section 96 of CPC. I am one of the defendant, second defendant in the
This
OS.
order
matters.
impugned.
It's a rejection of plaint, my lords. We have filed an application for rejection of plaint that got rejected. Against that, I have filed a writ petition. OS is still pending, my lords, so it may not be appealable.
So you have to, for not appealable, you have to file a CRP, that is what it is.
Yes, ma'am.
The office has raised an objection with regard to the maintainability. The petition, as the petition is filed against an application rejecting, filed under order 7 to 11, which was rejected. Petitioner is permitted to convert this petition into a CRP. And for statistical purposes, the writ petition is dismissed. Within 1 week, you shall file, you shall convert. Yes.
Obliged.
Beg to appear for the first respondent, my lord. Lord, I have filed for vacation of stay. Your ladyship was inclined to hear the matter on the last date, but they sought time. May I address the court today?
What is awaiting service of notice in respect of R1 to R19?
My lord, R1, I am the counsel. I had filed a caveat, but that was not put up and order was passed. I am appearing for R1. I have filed my statement of objections.
I'm ready.
And
I mean, all the other respondents were necessary.
They all sailed together. They all sailed together.
they are all, my lord, they have filed a common objection in the trial court. They are represented by the same advocate at the trial court, my lord.
Then you can file a memo that notice to others
I
are
will,
not
I will
necessary. A memo will file stating that no, all the respondents 1 to 19 are sailing, and first respondent is already served and represented. Hence, notice to respondents 2 to 19 may be dispensed with. Yes, please argue.
Lord, suit for declaration.
Hmm.
The contentious issue between the parties is the plaintiffs say that they have formed a trust. There is a temple in Mysore. With respect to that temple, the trust has got about 2 to 3 temples in Mysore. So we say that we have formed a trust. This trust is formed on 24/9/2009. That may be relevant.
Four?
The name of the trust, the plaintiff trust,
24.
24/9/2009.
Hmm.
The name of the trust, my lord, is Padavaralli Gramabudaya
Hmm.
Trust. This is the trust that is formed.
Hmm.
There are office bearers, and we say that the first defendant was the Archak. There was an earlier,
Please under what provisions?
it's a trust because of the villagers. There are about 2 to 3 temples were there. The trust was formed for the welfare of the people in the village.
It's not a registered trust.
It's a registered trust. It's a registered.
Under
Registered
the
and,
Act.
yes, trust. The trust act, my lord, if it's a public trust, section 92 of the CPC is applicable. If it's a private trust, trust act is applicable. That's the, so the trust was formed. There was some problem with the first defendant who started claiming that his forefathers were the occupants of this place and they were running the trust. So there was a suit that was filed earlier, OS 1653/2009.
Hmm.
This was filed with respect to these temples. A declaration suit was filed. In the meantime,
Declaration by him.
by me, I sought for declaration. That was filed by me against them. That suit came to be dismissed at my instance. At my instance, it came to be dismissed. For the reason we entered into a compromise.
When was it? When was it?
This, it came to be dismissed on 4/1/2014. Pursuant to,
You have compromised with this respondent.
the reason was he misbehaved, according to us. He misbehaved with a lady devotee. The matter went to the Tahsildar. There was an inquiry that was made by the Tashildar. There was we drew up the minutes and wherein we said that he would be paid about 30,000 rupees per annum for his activities as a nurture, in addition to the hundi money that he was going to get. That was the understanding that we get. At this juncture, I pause because none of us have filed the documents. If my lord were to say that proceed further, I'll proceed further because both of us have filed enormous documents before the trial court. It may be our duty to produce these documents instead of asking the honorable court to bring the records from the trial court. It may be at this juncture I say, and I proceed further. If my lords were to feel that documents are required, then you may direct me to produce. Thereafter, the compromise was made on 25/9/2017. He admits, the first defendant admits that he was only an archer. This is the important aspect. Then I filed this suit, my lord. He makes one more trust. Why all this confusion and the dispute is on 19/6/23. He forms a trust called Podavaralli Jodi Maramma Abhivruddhi Trust. I filed this declaration suit saying that the trust that he's created is void and he should not create any confusion in the management. I admit that he is an archer. I have no problem for him carrying out the day-to-day puja activities. That's not my concern. My concern is his creation of the trust as vis-a-vis the villagers have formed the trust.
You mean to say it creates confusion?
Because of his second registered trustee that he has made in the year 2023, the confusion is created because he is trying to take over the management, saying that he's been enjoying this from generations after generations from the year 1953. There is not an iota of document that is produced before the court to say that it has been enjoyed so on. Trial court grants me an injunction. So I enjoy. He prefers an appeal, MEA. The MEA is allowed. And the learned first appellate judge goes to the extent of, without there being any application, he says that a receiver is appointed. There is no application filed by any one of us. Kindly see this portion.
Where is that order of the?
That order, my lords will get it at ink page 54 and 55. Precisely at 54, it upsets the trial court order. But at 55, may I read that 55, page 55.
Please come to para 24. We will read from here. That's at page 45.
I find there is no expressed or written schemes in plaintiff's trust for management administration of Padavaralli Marigudi temple. Therefore, contentional plaintiff trust cannot be relayed completely based on the trustee resolutions or auditor's report and financial statement of the plaintiff trust. The first defendant also put forward contentions regarding his contention. No, the matter has gone against me on the premise that under
so that it will be clear.
Temple improvement cannot be brushed aside at this stage. Plaintiff trust and defendant number 1 trust both claim that they are discharging every responsibilities of the temple, including annual festival. Both have their own sentimental interest and attachment towards the temple. Hence, trial court decision that the plaintiff trust, which came earlier to the trustee of the defendant number 1 as a prima facie in their favor, cannot be accepted. It is one of the ground for appeal by the defendants that there are rival contentions regarding the management of the temple. In this context, trial court did not look into section 92 CPC. In this regard, he has relied upon decision reported in AR 88 Supreme Court on the file of the Supreme Court, wherein it is held, any dispute regarding the management of a public temple, district judge will have to frame a scheme. I have gone through the authority. It was in regard to Ram Mandir Varanasi established by one Purushottam. The entire paragraph.
Not required. You can come to
28, my lord.
29 you can come. I've read 28.
The suit schedule is a Jodi Marama temple bearing so and so, Vinayakanagara, Padavaralli, Mohalla, Mysore. In this case, there is no written and express deed with the plaintiff trust for management of the Marigudi temple. Definitely, plaintiff trust is not private, but public trust, Plaintiff trust did not produce before the court schemes that are drawn for the management of the temple. If at all there is no such express scheme or written deed or management based on customs followed in the village, it is a matter of trial. When there is claim and rival claim involving various facts to be proved in trial, it is not safe to hold prima facie case in favor of the plaintiff alone. It is true that section 92 is invoked by public trust. This is a suit filed by the plaintiff trust represented by its secretary, alleging that the defendant number one has committed breach of trust. It is the allegation of the plaintiff trust denied by the defendants that the defendant number one is an archak. Therefore, it cannot be concluded that plaintiff trust is an employer, first defendant is an employee without a trial. The plaintiff trust has produced a copy of the proceedings before Tahsildar dated 25/9/17 for enhancing the remuneration of 30,000 annually to first defendant and to enhance the same every 2 years, and agreeing that the temple hundi belonged to the trust and Mangalarati offerings belongs to the defendant number one. Plaintiff trust claimed that document is signed by first defendant.
I have seen. I have read the
Yes,
order.
ma'am. So here, kindly see the relief that I have sought. The trial court, the first appellate court fell in error. It is not my trust which is put to this. It is that what I have challenged is that he could not have formed any trust. That is this 2023. Therefore, section 92 has no application here. So therefore, the only thing that the learned first appellate judge has missed the point is by saying that you should have gone under section 92, that is 92 scheme suit, that should have been the way out for me. That is not correct. Legally, it is not correct because I'm not challenging my own trustee as one of the trustees are not challenging this act. We are only saying that he admits that he was an archak. So under a compromise, the first appellate court also comes to that conclusion. And we have no confusion in allowing him to carry out the religious activity. We have only confusion and we do not want him to get into the management because the villagers are managing. It is not, and he claims that it is his family trust. Family ancestors were carrying out. Not a scrap of paper is produced before the court. And therefore, in such circumstances, the first appellate court erred in saying that assuming jurisdiction under the order 40 was exceeding the jurisdiction it had, and saying that in the event they file an application, then you consider that may be exceeding the jurisdiction. First appellate court, merely because there is an alternate view that is possible or replaceable, cannot do it so long as it is able to establish that there is any perversity.
Yes,
Please. My Lord, before I get into the merits, one submission as to maintainability of the writ petition. My Lord, admittedly, it is filed by a trust. And the trust, it says that the cost title says that it is the trust is represented by the secretary. My Lord, I would like to submit this one decision of this honorable court, upheld by the honorable Supreme Court, wherein it is clearly stated. May I read out the relevant?
Oh, did you take this before the trial court and the
My Lord, I have taken this contention specifically before the trial court.
by the court in the due course?
No, my Lord, as even the writ petition cannot be maintained, that is the decision of this honorable court, that a writ petition filed by a single trustee cannot be maintained. It is maintainable only when all the trustees join together, my Lord.
Where is your IA before the whatever your pleadings before the court?
Please, my Lord, before the first appellate court.
Where is it?
Please, my Lord. At 135, my memorandum of appeal. Lord.
Yes.
Here, my Lord. Just one more. My Lord, page 139, para number 12, my Lord.
What is your submission on that?
My Lord, my submission is that here I say in the
One minute.
It is not a challenge to my own trust. If I am challenging if it is a trustee challenging the activities of the trust, then all the trustees are required and necessary and proper parties. Here, kindly see the relief that I have sought. The relief that I sought, my lords may kindly see the prayer. In page 67.
Yes.
67.
No, you have an order in the appellate court where
Please,
a
madam.
receiver is appointed
Please, madam.
immediately when they were running the affairs of the trust.
My lord, I have not admitted that.
On the ground of this issue, I will leave it open to be decided by
Please,
the trial
madam.
court. And you address on the merits of the matter, how
Please.
the order of the appellate court is.
Please, madam. My lord, this one decision just I may submit, my lord.
Anyway, but I will not decide that.
Please, my lord.
Take
My lord, because the petition itself is not maintainable, writ
You have
petition.
an order in a petition that is not maintainable, where a receiver is appointed when somebody else was administering the affairs of the trust.
My lord,
Temple.
please, my lord.
That will be decided by the trial court. We will not go into. I will consider your submission, but I will not give any finding
Please, my
on
lord.
that.
Even for any relief, they have to be made parties is what the decision is.
That before let the trial court will decide that. Now,
Please.
please come to the merits of the matter, how the order of the appellate court is right.
My lord, the appellate court, now what has happened here, my lord, there is a decision of the Honorable Supreme Court on which the appellate court has relied. The petitioner trust claims to manage the temple. There is no document that to say that they have been exactly managing that particular temple. In fact, in the entire trust deed, there is one passing reference to that temple. Apart from that,
The earlier settlement compromise between you and the petitioner,
please, my lord.
earlier compromise.
My lord, that also is not admitted by me anywhere. Because that so-called compromise, my lord,
That is not recorded by the court. Compromise is not before the court.
my lord, it is produced before the court by them.
No, when in a pending proceedings, you have entered into a compromise, which is recognized by the court.
No, my lord, that is before the tehsildar. It's not a judicial determination as such or a compromise as such. It is a private agreement between the parties that they have entered into. My lord, they also admit that I am an archaka. And my learned senior friend senior colleague had said that he has no objection to me offering puja and taking the hundi money. But what is happening?
Now their whole grievance is against your trust, which is established later, recently.
Please, my lord.
Which is creating confusion in the minds of the devotees.
Please, my
with
lord.
regard to who is managing the affairs.
Please, my lord.
So at that juncture, unless and until a full-fledged trial is conducted,
Please, my
court
lord.
cannot come to any conclusion.
Please, my lord.
What is this order of the appellate court? Why should the receiver be appointed?
My lord, receiver, I may concede that I am not defending the appointment of a receiver.
Concede, even if you concede on that aspect.
Please.
Unless and until the trial is conducted.
Please.
Concluded. The injunction is very much necessary in the facts and circumstances.
My lord, the injunction goes to the extent that I may not even offer worship at the temple. I may not even enter the temple or.
Let's see the order of
Please,
the
my lord.
trial court.
My lord, at page number 123, the operative portion of the order is there. 123, my lord, of the writ petition. Defendants, may I read, my lord? Defendants, their agents, servants, family members, power of attorney holder, any person acting on their behalf are hereby restrained from doing any acts or deeds in pursuance of the alleged.
Can there be such an order?
Correct order, my lord. It is the second trust.
No.
Second trust, my lord. It is not my trust. I admit that he is an.
What about the trust? Defendants, their agents, servants? No, this person.
I'll read, my lord. I'll read. Servants, family members, power of attorney holders, persons acting on their behalf from doing any acts, deeds pursuant to the alleged the trust is his trust. 2023 trust.
We will make it clear. We'll make it clear. He will not be doing anything in pursuance of that in the name of the trust. But he is he was an archika. He will be doing the acts.
Please.
He was doing earlier.
Please, my lord.
That's the first sentence I said was that.
Please, it may be clarified. May I submit, my lord? Yeah. Because I have produced photos that they are not allowing me to enter the temple. Police.
That we will clarify
Please,
that. Please come.
So further.
The order I'll dictate later. As far as this you take, the trial court, the submission with regard to the maintainability of the petitioner representing the trust and filing a suit. The petitioner, the respondent has relied on a judgment of this court in case of Chikka Muniappa Reddy Memorial Trust versus State of Karnataka, reported in ILR 1997, Karnataka 2460. This court is not inclined to go into the said aspect as the appellate court had passed an order whereby a receiver is appointed, which is against the interest of the appellant herein. However, it is left open for the trial court to decide this issue if an appropriate application is filed by the defendant. Number 2, the trial court has passed an order, has passed injunction restraining the defendants, their agents, servants, family members, power of attorney holder, or any persons acting on their behalf are hereby restrained from doing any acts or deeds in pursuance of the trust deed established by the defendant in any manner whatsoever pertaining to the scheduled temple is concerned till disposal of the suit. It is a contention of the land counsel for the defendant that under the guise of this order, though earlier the defendant was doing the rendering services as an archika, now he is not permitted to perform his duties as archika, which is denied by the land counsel appearing for the petitioner. Considering the same, the order of the order passed by the appellate court appointing a receiver and the entire order passed by the appellate court is set aside, and the order passed by the trial court in I number 1 in OS number 1636 of 2023 is modified, is clarified that there is the defendant is at liberty. A defendant shall defendant can perform the defendant.
First
What is the name?
First different.
Chikkarasanayaka.
Defendant is permitted to perform the duties as archaka as he was doing prior to establishment of this trust. But however, with regard to the affairs of the trust or concern, the order that is part, the injunction that is granted by the trial court holds court till the
Please, my lord, may I make one submission? Lord, puja as well as festivals and all that.
whatever the
Please.
whatever he was doing earlier.
Please.
Yes, puja and other activities what
Please,
the defendant was continuing before. First defendant is continuing before the establishment of this trust shall continue.
Please. And my lord, one more submission. May I make? May I make one submission? Lord, my learned senior friend had said that
Order I'll dictate. Yes.
he has no objection to me collecting the hundi money also. That may be also kindly included in
No, hundi money, there is no order by the trial judge.
Because I was
Not
collecting.
Hundi is the money that is given to the
Was he
general
doing it so earlier?
No, Mangalarati, that is Tatte Kasu we call it in Kannada. That's what is written by the Tatte Kasu is when the devotees give it at the spot.
That's what, that's the.
Hundi is different from Tatte Kasu.
Yes, what is it
So he
called,
cannot take the hundi money. He
a
is,
plate collection, whatever
that
it
he
is
is
called.
taking. Archak is entitled. Hundi is entitled by the trust.
Correct.
We are doing public activities.
The plate, the petition, the defendant is
That's
entitled
Who will
to
take?
have the plate collection. Yes. Receive the, and take the order today itself. Yes.
Cell number 16,
Begging,
Sheshgiri Rao.
this emanates from an injunction application, Lord.
What is the surveyed service of notice in respect of 1 to 16?
Respondents are yet to be served. Can I, not take hand summons to the advocates before the appellate?
Yes.
So that be permitted.
to take court hand summons on the counsel appearing for the respondents 1 to 16 before the appellate court and shall file a memo to that effect. You have an interim order?
No, it has to be considered for the interim.
Take a, and shall file a memo to that effect by 29th of June. If it is filed, list the matter on 30th, or else the writ petition shall stand dismissed.
Cell number 17,
The office will have to generate the hand summons. It will take some.
They'll do it 30th, I said. It will come on 30th.
cell number 17, Abhishek R.
For the petitioners, Your Lordship, in this, the petitioner had gotten a valid order of.
What is this
attachment.
non-compliance of office objections?
Your Lordship, there is a little discrepancy in the format. The interim prayer has come before the main prayer.
Whatever you can do it.
Your Lordship.
You can do it
I can
during
do-
the course of the day.
Your Lordship, the petitioner representative, authorized representative is not present. That's why I had made the council submission. He'll be coming in the next week, Your Lordship. But there is the urgency is that the case is pending before the commercial court. So I had made the council.
Prayer to be specified by annexures. Interim prayer to be stated before main prayer.
I have mentioned that.
Post writ petition before the court for orders regarding non-compliance of office objections. Urgency in so and so. When is this matter filed?
It was
On 11/5/2016.
filed 11/5, Your Lordship.
In the meantime, you would have complied with the objections.
Your Lordship, I could have, but the petitioner was not there, Your Lordship. He was not present.
Who petition will do the object, comply with the office
No,
objection?
he had signed. We had to sign, get the signatures on the prayer. column.
Office objection shall be complied with by tomorrow. Yes, what is urgency?
Your Lordship, in this matter, Your Lordship, the petitioner had gotten a valid attachment before judgment from the Principal Senior Civil Judge, Bangalore Rural, on 12/1/2026, in OS 110 of 2025, Your Lordship. That is at Annexure D. Annexure D. The respondent number one had filed a contempt application against the petitioner in commercial execution 198 of 2024, Your Lordship. So this is when I get to know that the petitioner had provided a loan to respondent number two, and for that loan, the respondent number two had given two properties, that is the scheduled properties, as collateral, Your Lordship. Subsequently, when I get this contempt application, I realize that there is a pending commercial execution which has the same scheduled properties attached. An attachment order is passed and an auction has been carried out, Your Lordship. Now, after the contempt application has been received by me, on 27/4/2026, I appear before the contempt commercial court and I file my representation. I file my wakalat. And I was given time till 8/6/2026 to file my objections to the contempt application, Your Lordship. During the interim, respondent number three, who was the auction purchaser of first scheduled property, he had on 2/5/2026, a day before the vacation, he approaches the court, files an application under section 151 of CPC, seeking to break open the locks of the scheduled property and take possession of the property. Your Lordship, now the difficulty is I also have a valid order of attachment before judgment, and there is a order from the commercial court also of auction. Auction has happened, and he also has an order. The difficulty here is, Your Lordship,
Who is the plaintiff therein?
plaintiff there is respondent number one, Your Lordship. Respondent number one. Respondent number one has filed this commercial execution based on a arbitration proceedings.
So their rights are already crystallized.
Your Lordship, yes.
Your rights are yet to be.
I also have an order of attachment for the same property, Your Lordship. The difficulty here is all of me, the respondent number.
The order, where is the order?
My order in my favor is at page number 36.
No, what is impugned now?
Your Lordship, now what has happened is that the auction purchaser is trying to take possession of the property, but there is a submission made by the respondent number two counsel saying that there is a mediation proceedings ordered by the Supreme Court of India. There is a proceeding pending before the Supreme Court of India, and there is a mediation proceedings.
What are the proceedings that are pending before the Supreme Court?
They have challenged the arbitration orders passed by the during the arbitration, and there is a proceeding pending regarding that challenge. So now there is a mediation referred to on 2/2/2026, and the Supreme Court had ordered to issue notice to all the interested parties. That is me, respondent number one, respondent number two, and respondent number one and three, and petitioners. So I have received the notice, and if I may pass the orders of the Supreme Court on 29/5/2026, they have directed to issue notice to me regarding the mediation, all the interested parties, which includes me, Your Lordship. I have received the notice recently by hand, Your Lordship, and I am willing to take part in the mediation also.
Now, what is the present stage?
The present stage is, Your Lordship, they have.
You are saying that to break open the locks, order was passed long back in the month of May.
No order was passed, Your Lordship.
Because you just said so.
No, he had filed the application, but the court rejected, saying it was not served to the opposite side. He had just gone to the court without giving us the notice for advancement.
What do you want from this court?
Your Lordship, what I want is, Your Lordship, a stay on the orders. Your Lordship, I apologize. Your Lordship, I want a status quo with respect to the possession, Your Lordship. The possession may not be granted to the respondent number 3.
What is, come to your prayer.
Yes, Your Lordship. Let me read, Your Lordship.
Issue a writ of mandamus directing the commercial court not to deliver portion of the property. You can't ask the commercial court about this.
Your Lordship.
And how can you come to the High Court without there being an order?
Your Lordship,
Whenever you are asking this court,
yes.
can't you ask the commercial court? And if commercial court passes some order, you can come to the High Court. And without asking the same, how can you straight away come here?
Your Lordship, they had filed it during the vacation time, Your Lordship. I had
No orders
given
are
the
passed so far.
Yes.
You have to file your objections,
Yes.
isn't it?
Yes.
Court will pass some order. If you are aggrieved, then you will come. Why should you anticipate that the court is going to pass some order? And now the same thing, when the Supreme Court has ordered for the mediation and you want to participate,
Yes.
all the more reason that the court will interfere.
We had made that submission before also, Your Lordship, during the.
But no order is passed
Yes.
so far.
Possession.
When the matter is coming up before the Supreme Court,
After this, I am not aware of it, Your Lordship.
go to the commercial court and tell the court. The petitioner has come up before this court, seeking the following prayer. It is submitted that in respect of the very same property, which the petitioner has an order of attachment before judgment, with respect to the very same property, there is an award passed and the matter is carried till Supreme Court. Now, the Honorable Apex Court has ordered for mediation, and petitioner has also received a notice in that regard, and the petitioner wants to participate in the same. It is submitted that in the meantime, the respondents have filed an application to break open the locks, and the same.
Respondent number 3.
Respondent number 3 has filed an application to break open the locks, and the same is pending consideration before the court. It is submitted that as the proceedings are pending before the Supreme Court, an order may be passed directing the trial court not to pass any orders on the pending application. Next paragraph. This court is not able to appreciate the submissions made on behalf of the petitioner, and this court cannot pass any orders directing the commercial court not to pass any orders. Whatever the grievance of the petitioner, he should have ventilated before the commercial court, and the commercial court would have passed an order. And still, if the petitioner is aggrieved, he could have come before this court, and this court cannot entertain a petition of this nature. In that view of the matter, this court is passing the following order: that the petitioner is disposed of, giving liberty to the petitioner to avail the remedy before the commercial court. Yes, 18.
180.
For the petitioner. Suit is for partition. The office objection says with regards to the B1, Your Lords, which is the plain copy, they say it's not legible enough. The same may kindly be overruled, Your Lords.
What is the office objection?
Is with regards to the
Date
plain.
and place of execution, executants with stated.
That is all done, Your Lords. Everything is taken care of. It's only
Annexure
B1.
B1, better copy not filed.
Please, Your Lords.
Annexure not attested by notary.
That is done, Your Lords.
Then what is not done?
It's only the plain copy, Your Lords. Annexure B1.
Where is it?
It is at page number 77, Your Lords.
Page number 70. How will anybody be able to read this?
It's small, I understand, Your Lords, but it's legible enough.
That's why they have asked. You file it. Will not dispense with it. The petitioner shall comply with the office objection.
I shall, Your Lords, if Your Lords can kindly.
I'll hear the matter. I'm saying you comply
Please.
with the office objection. Shall
Please.
comply with the office objections within 2 days. Yes.
The suit is one for partition, Your Lords. Originally, one Shivana has 2 children, Your Lords. That is the plaintiff Devarajama, and now represented by the petitioner since she is dead, Your Lords. And the defendant therein is a respondent hearing who apparently happens to be the brother. So they file a OS, and then item number 1 to 15 we file for a OS, Your Lords, and seek for 1 second share. And in that 1 to 9 is decided, Your Lords, saying that this particular suit partition has to take place. But only 10 to 15, it is not ordered, Your Lords. May place the partition, Your Lords.
Please come to the impugned order first, then we'll go to that.
Please, Your Lords.
Where is the impugned order? Page number?
15, Your Lords.
15.
Please, Your Lords. And the speaking order is in page number 19.
Page number?
19, Your Lords. 19 and 20. We then file a regular appeal, Your Lords, seeking for the stay of the.
Let's see.
Please,
Read the order.
Page number 19, Your Lords. Respondent had opposed the application on the ground that the trial court, by appreciation by oral and documentary evidence, has come to the conclusion that item number 10 to 15 self-acquired properties of respondent number 1, it has been acquired by them on individual capacity, hence prayed for dismissal of the application. Having heard both the counsels, whereby dispute with regard to the right, title and interest over the property in question, suit is one for partition. Hence, if at all the alienation takes place, petitioner will not lose his right over the property, as he can claim either mean profits or its value. The respondent has seriously disputed the right of the plaintiff. So in the circumstance, I proceed to pass the following. The IA number 2 filed on so-and-so under section so-and-so on behalf of appellant is hereby dismissed. We say, Your Lords, that item number 10, Your Lords, in exhibit P14, it is clearly marked that it is a partition suit. And that particular property is included as part of the partition. It's an oral party. It's an unregistered partition, Your Lords. All the item number from 1 to 9 are clearly from that particular partition detail.
No, you're concerned with 10 to 15.
We are concerned with 10 to 15.
Now come to the finding with regard to 10 to 15.
Please, Your Lords. It is at page number 37.
30?
7, Your Lords. 39, Your Lords. Surprisingly, the plaintiff has produced an unregistered Panchayat Parikat and the same has been marked as Exhibit P14. Exhibit P14 is an unregistered partition deed dated 5/7/1986, said to have been entered into between Chamarai Gowda, Shivanna, Siddhe Gowda and Chikkalingappa. The Exhibit P14 has been marked through PW2, though it has been registered. PW14 is the notarized copy of the unregistered partition deed. It is significant to note that the Exhibit P14 has not been supported with pleadings by the plaintiff. So in the absence of specific pleadings, Exhibit P14 cannot be accepted in evidence as a documentary proof. That's the reading with regards to Exhibit P14, Your Lords. However, every property.
What is Exhibit P14? It's
P14 is the partition deed, Your
I'm
Lords.
asking about this property. So where is the finding with regard to item number 10 to 15?
That is with regards to P14, that is 10 to. Okay,
Later, where did the court say that 10 to
Please, Your
14
Lords.
are the self-acquired properties?
So that is in 43, Your Lords.
40?
43.
Yes.
It is a specific suggestion the children of Gangodi, Siddhe Gowda and his children have divided the properties by virtue of the registered partition deed in the year 1957. This suggestion is denied by PW2. By making this suggestion so on and so forth, the plaintiff has also produced Exhibit P18 to P33 subsequent to the examination of PW2. According to the plaintiff, suit item number 11 to 15 are purchased in the name of second defendant out of the income of the joint family properties. But this plea of the plaintiff remains as plea only. Under Exhibit P24, the suit item number 11 is purchased in the name of defendant number 2, Siddhe Gowda, on 26/11/1996. So by virtue of Exhibit P25, the suit item number 12 is purchased in the name of defendant number 2. So except the pleadings by the plaintiff, nothing is produced either in the shape of the documentary evidence to hold that the suit item number 10 to 15 are purchased in the name of defendant number 2 out of the income of the ancestral properties. But in this particular backdrop,
Court says to hold the suit item number 10 to 15 are purchased in the name of defendant number 2 out of the income of the ancestral property.
Please.
Though the specific suggestion is made so and so.
But Your Lords, in the written statement filed by the defendant.
The court comes to the conclusion that no evidence is produced in this regard.
Exactly, Your Lords. But Exhibit P14 is the
When
part.
these properties were purchased?
Everything is prior to the death of my father, Your Lords.
What is the date? That's what I'm asking.
Please, Your Lords.
It's in 1996.
94, Your Lords.
1996.
94, 96, Your Lords, and 2000. Prior to the death of my father. And each of these properties are clearly from the partition, Your Lords. The Exhibit P14 clearly says the 1 to 9 are from the same partition deed, and Exhibit P14 also says 10 is from the same partition deed. Just because it is an unregistered document. In fact, in the written statement, Your Lords, the defendant also takes a stand that this particular item was taken from the joint family property. If I may take you to page number, Your Lords.
Please come. Then counsel for the petitioner submits that. The petitioners have filed an IA seeking stay of alienation of the property. That is item 10 to 15 of the suit scheduled properties. But the appellate court has failed to grant the same and observed that even if the properties are alienated and in the event the petitioner succeeds in the appeal, the said alienations are hit by list pendency. It is submitted that all the suit scheduled properties 1 to 15 are part of the partition deed and which is admitted by the parties. And in that case, and the properties are purchased during the lifetime of the father, the court ought to have granted injunction considering the same. There shall be an injunction restraining the respondent dependent respondents from alienating the suit 10 to 15. 10 to 15 scheduled properties till the next date of hearing. The petition is permitted to take out hand summons on the counsel appearing for the respondent before the trial court. Memo shall be filed by 2nd of, in addition, in all the matters, right, in addition, by 2nd of January, or else a stay granted by this court stands vacated. Yes, 19.
Cell number 19, Lakshmi Menon, for petitioner.
Lord, suit for declaration and injunction where I had filed two applications under 39(1) and 2, one for status quo and one for non-interference.
Suit for?
Declaration and injunction. I am saying that the petition, the plaintiff, my lords, in the lower court has perfected title by way of adverse possession over a period of 6 decades. 1960 onwards, we have been in possession. In 2003, I enter into a registered partition deed, again conveying the same suit schedule property to my next generation. That next generation is a plaintiff, my lords, before the trial court. My lords, in the interim, what happens is the difference.
So you have conveyed what you have, your right, you have perfected the title by adverse of position, and that you have conveyed it to your next generation.
Please. Defendant 1 and 2, my lords, are supposed to be the original owners of the property. D3 and 4 are now claiming to be the owners of the property. My case before the trial court is all of them are hand in glove because D3 and 4, my lords, recently, by way of petitioning to the Tahsildar, they asked for mutation in respect of the suit schedule property, 1 acre and 11 guntas, my lords, in Kolar, where they say they are trying to manipulate the name of their grandfather, who is the original vendor in my case.
Anyhow, what is IA? IA for injunction is dismissed.
My lords, the trial court, the interesting order of the trial court, my lords, page number 26.
20.
She considers that I have filed 2 applications, but none of them are answered. On my 3rd application, she says, at this stage, there is no fit case made out for grant of interim order. Without hearing the other
side. It's an ex parte order.
It's an ex
parte by 25/6/2026.
Please, my lords.
No,
Next date, I understand, my lords.
25/6/2026.
I filed this during court vacation, my lords, never reached.
So on that day, we will ask the court to decide it.
Afresh, my lords, because there is no reason also assigned when discretion has been
declaration injunction in respect of the property as filed IA2, maintains status quo of the property and filed another application restraining the defendants, heard learned counsel and Parusa. At this stage, is not a fit case. That's what the court.
But the court has ordered on IA number 1, which is only a dispensation application. IA 2 and 3 were my applications for status quo and injunction.
We'll ask the court to decide that.
Please, my lords, if they can reconsider 2 or 3, either way. I'm only saying because 3 and 4 are now trying to develop the property. They came to me, asked me for my permission to develop the property.
Whatever it is, your IA 2 for 2 under the order 39 rule 1, and your other IA is?
For non-interference, my lords, again under 39 rule 1 and 2. I would be satisfied.
Number 2 under order 39 rule 1 and 2, that is to maintain status quo you sought.
Please.
And what is the other one, IA number 1?
IA number 1, my lords, is I have made certain formal.
You sought for an ex parte injunction.
IA number 1 is where I filed an application under 80 clause 2 asking for dispensation with statutory notice because
yes, please come. The petitioner before this court is a plaintiff in the suit. And the petitioner is agreed by the order dated 29/4/2026, wherein the court has failed to consider the application filed by the petitioner seeking ex parte injunction and issued notice to the, issued summons to the defendants returnable by 25/6/2026. It is submitted that the petitioner has filed I number 2 seeking direction to maintain status quo, and also another application under Order 39 Rule 1 and 2, filed I number 3, restraining the defendant number 1 to 4 not to interfere in plaintiff's position of the suit scheduled property. It is submitted that the court, without considering the urgency, has issued summons. Now the matter is, the summons that are issued are returnable by 25/6/2026. Expert. Considering the fact that the court will hear the matter on 25/6/2026 after the notices are served on the respondent. This court is not inclined to go into the merits of the matter, issue notice to the respondents and keep the matter pending before the court, which is not in the interest of the parties. In that view of the matter, this court is passing the following order. The trial court on 25/6/2026, by giving a reasonable opportunity to the respondents, the respondent defendants, shall consider IN number 2 and 3 filed by the petitioners expeditiously, but not later than 4 weeks from 25/6/2026, accordingly disposed of. This court is not issuing notice to the respondents as no adverse orders are passed. Yes, 20.
Number 20. Great. Ravi Shankar, GS.
I accept notice for respondent.
Lords, there is an office objections which has been raised.
Party has.
It is actually supposed to be.
It's only one respondent.
Only one respondent. Matter has caused a stay of arbitral proceedings on account of an ex parte interim order secured at the vacation stage.
My lords,
I am disabled with my wakalat not having reached me in time. Could I request your ladyship to have this matter on Thursday or Friday? I'll file my wakalat. Petition does not deserve to even be maintained on account of it seeking challenge to an interlocutory order passed in arbitral proceedings.
my lords, there is an office objection which has been raised. Saying
Whatever it is, I'll take it up day after tomorrow. In the meantime, you comply with the office objection. Only one respondent in this.
Only one respondent.
So and so submits that he has instructions to file wakalat either on behalf of the respondent.
My lords,
Petitioner shall comply with the office objections.
No, my lords, that's the submission I wanted to make. It's actually we noted that it has been placed before the division bench, but probably it should have actually been placed before GM RES. So
When you can have an interim order from a single bench, why should we go to the division bench? If the matter has to go before the division bench, how come a single judge can grant?
That's the whole question.
In fact, the interim order is leaving open the question of maintainability. And
That's the question where the
No, the
maintainability.
question of maintainability is kept open. Issue emergent notice. All further proceedings are stayed.
Yes,
my lords, we are of the opinion that it should be placed before the roster bench of GM RES, not GM CPC, my lord. Because while we filed it during the vacation court, it was advised that it has to be coming before the CPC. But it's an arbitral proceeding which has been challenged, so it probably has to go before the RES bench, my lords. Rooster, my lords. It's not the division bench because you're challenging the award of the arbitrator. It doesn't go before
You argued the matter at GM CPC, have an interim order. No, argue the matter at GM CPC and conclude the matter.
In fact, the order under challenge is an order on the basis of which they have been prevented
I'm not getting into the minutes because he has to file because that's not what we get.
No. You had an interim order and when the matter is listed as GM CPC.
Yes.
Not that day you didn't say it has to be GM RES. No, I will not argue before that court. So you have an interim order.
Yes.
So you continue with that. How does it matter? List this matter day after tomorrow. Whatever office objections to be complied with shall be complied.
But it has to go before the division bench is what the office objection is raised.
Office objection.
Yes.
Let it be no office objections. This is matter day after tomorrow.
I'll oblige you.
Yes. After. Yes.
May it please your ladyship, may I pray
No
that I'm in
mentions
your ladyship, I'm in the item number 1 of the list 3. Just simply I'm praying, my lords, the matter may be taken up on 22nd, please, because the board is very heavy today. It may not reach even the postal session.
That should be done in the morning, not now. The
My
procedure is-
sincere apologies, your ladyship.
This court is, I will not take up any mentionings in the afternoon. What is that serial number?
List 3, item 1, your ladyship.
Respondents are there?
They are yet to be served, your ladyship.
When do you want?
There is office objection, I have to comply with that.
When do you want?
22nd, Your Ladyship.
This is matter on 22nd. Office objection shall be complied with.
My
by
lord,
the-
one submission.
My
My
lord,
lord,
list number 3, serial number 86, my lord.
My lord.
Madam, list number 3.
Sir. Sir. ಸರ್ ಮಧ್ಯಾಹ್ನ ಪಾಸ್ವರ್ಡ್ ಅಲ್ಲ ಪಾಸ್ವರ್ಡ್ ಇದೆಯಾ ಸರ್?
Madam, madam, list number 3, serial number 86.
ಒಂದ್ ನಿಮಿಷ.
Last. Number 2, number 3, serial number 1. Last
ಅಂದ್ರೆ 55 ರೀಚ್ ಆಗುತ್ತೆ 55 ರೀಚ್ ಆಗುತ್ತೆ ಆಗ್ಲಿ ಸರ್
15-6.
ಥರ್ಡ್ ಲಿಸ್ಟ್ ಪಾಸ್ವರ್ಡ್
List number 3, serial number 86.
ಮೇಡಮ್ ಲಿಸ್ಟ್ ನಂಬರ್ 360
ಸರ್ ಅದೆಲ್ಲ ಈಗನೇ ಅದು ಮ್ಯಾಟರ್ಸ್ ಎಂಟಿಗೆ ಹೇಳ್ತಾರೆ ಮೇಡಮ್. ಅದೇ ಸರ್ ಕೇಸು
Quota. Madam. Quota. Quota.
Your Honor, I missed the hearing in the morning by a few minutes.
What is to be done now? What happened to that?
No, I start.
When? Tomorrow. No, you shouldn't mention it at this hour. Well, when it reaches, you should. When the court is adopting a procedure, I think our advocate should follow it. At request of front counsel, the petitioner. When do you want? This is marked in the month of July, on 7th of July. Interim order earlier granted is extended. Yes, next. Continue the list.
List number 2. Number 21.
For the petition. Because there is an application which is not served on me. They try to produce some CDs. Those CDs are not furnished to me. Let them serve a physical copy on me, my lords. I'll file my objections so that my lords may hear itself. Because they are the stranger to the writ petition. They were neither the parties in the suit, nor the parties in the appeal, nor the parties in the execution proceedings, the order of which I have challenged before this honorable court. They are not parties in the execution proceedings also. Now they are filing implementing application. So I'll file my detailed objections. Let them serve the physical copy
on him. The petitioner shall, the respondent, the respondent has served the copy of the IA on the counsel for the petitioner. This is matter. When do you want?
After 2 weeks, interim order will be extended because the matter is now advanced.
This is a matter on 24th of June.
Please.
Interim order earlier granted is extended. Yes, 22.
Number 22. Chandan P.
For the petitioner. Challenge is to the trial court's order not granting me the ex parte relief. The office objections are all complied with. On 2nd June, your lordship said, common writ petition. Objection was how a common writ petition was filed. Lordship directed it to be considered later. I don't know if it is recorded.
I said office objection shall be complied within two days, I said.
That is complied. Those are complied.
But then what else? After that, it has come up yesterday.
It keeps coming, my lord. That's why maybe.
No. Multiple IAs cannot be challenged.
Yes, that your lordship said can be considered.
Petition before the court for orders on so and so.
That your lordship said on 2nd June can be considered later.
Then no argue on the merits of
yes,
the matter. Yes.
My lord, the challenge.
What are the 2 IAs?
3 IAs, my lord, are filed. IA number 2 is at page 48.
What are the IAs?
My lord, basically the petitioner, my lord, who is the plaintiff before the trial court, is running a restaurant in South Bangalore, my lord, in the area. The neighbor, my lord, was causing trouble. He would come there, my lord, he would abuse the customers, the staff. He would throw water on the customers and all of that. And then he gives a complaint to the corporation saying, I am running business activities in the basement, which is also not true. BBMP issues notice to me to respond. He puts up all sorts of posts, my lord, online. Give reviews against me, puts all photos, everything misrepresents facts. Then, my lord, he doesn't stop. So I went and filed this suit. The trial court says the corporation has issued notice, so there is no warrant for granting an ex parte order. My lord,
what is the suit for?
Suit for injunction, my lord, against him not to interfere with my business. Nothing more than that. My lord, I am not interfering with him.
Come to the order.
Yes. My lord, the order starts, my lord, at page 16, order sheet. Impugned order starts at 17. My lord, we can skip all of this, my lord. The page 21, your lordship may come to. Earlier is all facts. Page 21. May I read, my lord? The last 5 lines, my lord. Trial court says when the defendants are the aggrieved person, they have approached BBMP.
Please come. Issue emergent notice on I number 2 to 4 and issue summons to the returnable by 36/2026.
Yes, my lord.
It has not dismissed your application.
No, man. Not granting an ex parte temporary injunction is what I am aggrieved with. The last few lines, my lord, just above that, when the defendants are the aggrieved person already approached BBMP authority under such
Council
circumstances.
is agreed with the order. Agreed by the order dated 36/2026, whereby the court has issued emergent notice on I number 2 to 4. Then we'll do one thing. I'll set aside this order and we'll let the court hear you on in this on this IA.
30th June is the next date, my lord. My lord, till such time, my lord, let him not interfere with my
We
business.
can't pass such a time and ask the court to do it.
Then your lordship may
Then it
consider.
has to be. No, we will not keep this petition.
My lord,
pending
because
like
my
this.
only submission is, my lord, whatever it may be, now it is within.
Order is bad. We'll set aside that order. That court should have given some order or the other instead of issuing notice in the light of the urgency. Then without like it is coming up on 36, the court need not wait. I
Yes.
said notice is bad. Let it be decided by the court.
Let the trial court consider if I am entitled to an ex parte order, my lord, tomorrow or day after itself.
Today itself we'll ask them to do it.
Tomorrow or day after.
Petition is filed. Agreed with the orders passed on I number 2 and 4, where the court has issued suit summons to the defendants. Then counsel for the petitioner submits that the petitioner has sought for injunction against the defendant. But the court, on the ground that court, while issuing notice without granting injunction, temporary injunction has sought for, has observed that already the defendant's grievance. Defendant already approached the BBMP authority regarding the inconvenience and hardship caused to the neighbors of the plaintiff Bangalore cave.
To him, my lord. Defendant himself, I am the plaintiff.
Understood that. I'm reading what has been recorded by the court.
Yes.
By the plaintiff Bangalore cave, and only issued notice. Then counsel submits that when an application is filed seeking injunction. And ad interim injunction. The court has to pass an order whether the petitioner is entitled for such a relief or not. If the petition is not entitled for the ad interim injunction, court can dismiss the IA and issue the notice, but the suit summons to the respondent. But in this case, without considering the same, the court had issued summons. Then the petitioner is agreed with a said order, where the court has failed to pass any order. It is submitted that when this court has opined that the matter will be remanded to the court, when counsel for the petitioner submits that an interim injunction may be granted pending consideration by the court. This court is not inclined to pass any such orders as any such orders. The court ought to have, when an ad interim injunction is sought, if the court is not inclined to grant injunction, the court ought to have passed an order basing on the merits of the matter instead of issuing suit summons. In that view of the matter, this order dated 36/2026 is set aside.
28/4.
Huh?
28/4/26.
28/4/26.
26.
2026, and the matter is remanded to the trial court, and the trial court shall consider the IA number 2 to 4 on the merits of it within a period of 1 week from the date of receipt of the copy of the order.
Serial number
Accordingly disposed.
23.
Your liberty may be reserved to me to advance the matter.
Hmm?
Liberty may be reserved to me
But
to
is
advance.
reserved to the petitioner to advance the case. Yes.
23.
Item number 21, I was struck in the shift to my car. Then I had to climb I am a hypertensive, climb the steps and come. The opposite side of the, some urgency, my petrol pump is seized. For a day, 60.
When is it listed?
Posted to 21, posted tomorrow.
No, he has to file his objections.
I
itself.
will send them.
Which one?
No, he has to file his objections when you file an IA.
9 days over, my lord. 9 days back. We have
No, he says the copy is not served. That is a office objection.
Day after tomorrow.
Day after two, no. He has to file objections,
I will
isn't
give
it?
the copy to them today only.
Lists matter on, at best it can be 15th. Lists a matter on 15th. Inform the council for the response petition. Yes.
Serial number 23. Vivek S.
I'm for the,
Arjun Rao.
it has appeared last occasion, my lord. This is a order as a ex parte injunction. It has been refused. While refusing the injunction order, the court has gone on merits and virtually said that I have no case, as if the suit has become infructuous. Now that the defendants have appeared, and all that I request, on the last occasion this matter was taken up, all that I request is the parties may be relegated to hear the IAs without being influenced. Kindly see at your lordship may take up WP number
You said on the
15,000.
last occasion is acceptable for you.
Yes, here that is
So what we will do is, we'll set aside this and
Yes.
hear the matter afresh.
afresh.
Before the trial court.
Now, one other aspect in this, my lord, is kindly see this 15,722, 772. In that, my lord, the court has now it's a case of running a fitness center. There is a franchise agreement, and as per the franchise agreement, I am entitled to continue this till October 2026. Now, in the meanwhile, they sought to cancel this on the ground that there are some violation. Admittedly, I have got right now in this case, my lord, they have written during vacation tournament, they have written a letter that the two centers which I am running in Lucknow city are going to be closed. There's a letter. So I apprehend at annexure B in that writ petition. Your lordship, all that I request is let the parties be relegated, but let them not precipitate the matter.
For that, let me first pass orders on 23. I'll hear 24. Please come.
My lord, even
Same,
on
same.
24, my lord, my respectful submission is,
I'll hear
it's
it.
coming on the 15th
I'll
before the
hear
trial
it,
court.
Mr. Counsel. Let me complete this 23.
Yes.
The presented petition is filed. So question the order dated 2/5/2026 passed with a
6-7.
in I number 3. The petitioner before this court is the plaintiff, and he has filed the suit for recovery of money.
And also mandatory injunction,
Also seeking
permanent,
mandatory injunction,
permanent injunction.
along seeking permanent injunction along with the suit. He has filed an IA seeking injunction.
Annexure B, my lord, page 44.
Exemption of undergoing mandatory PAM proceedings in the light of the urgent release claim. I number 2 and 3 both are under order 39 rule 1 and 2, read with 151 CPC.
Common order.
Seeking an injunction restraining the defendants from launching and operating the proposed witness center at Indira Nagar, Lucknow, and to permit plaintiff to continue the existing franchise center at Gomti Nagar, Lucknow, and Mahanagar, Lucknow. The court, by order impugned,
Page 39, my lord.
has passed the order wherein the court has observed that insofar as the dispensation of PIM proceedings are concerned, the defendant is proposing to start the new centers in the month of June 2026 and further the civil vacations to the court being ensuing. In the light of the urgent release being sought, the court deems it proper to dispense institution of PIM proceedings and permit filing of the suit. And accordingly, on IA number 1 is allowed, and when it comes to IA number 2 and 3 are concerned,
Detailed order, my lord, page 39. no jurisdiction and all those things have been observed. And not even notice is ordered.
When it comes to I number 2 and 3 or concern, the court has passed, a court has issued the summons, and nonetheless, the court has given a passed an order wherein several aspects of the merits of the matter, in respect of the merits of the matter, certain observations are made. Then counsel for the petitioner submits that. The court can hear the case, the matter may be remanded back to the court. However, the observations that are made in this writ petition needs to be set aside. Next part, Land counsel appearing for the respondent submits that the respondent has no objection to hear the matter on the merits of it. Next part, considering the submission of the, having heard the counsels on either side, there's a material non record. Considering the fact that in this matter, only suit summons or issues on A number 2 and 3. However, court has made certain observations with regard to the merits of the matter. In that view of the matter, this court deems it appropriate to pass the said observations need to be set aside. In that view of the matter, this court is passing the following order. The writ petition is disposed of. The order passed, the order on I number 2 and 3 is set aside, and the court and the matter is remanded back to the trial court. And the trial court, after giving affording an opportunity to both the parties, shall consider the application as expeditiously.
Time bound.
As
There is
expeditiously
urgency
as.
because they are likely to close my 2 centers. I got my. Yes.
How much time, how it is in the before?
10 to
15 days?
15
The
days.
court shall consider the same within 15 days from the date of receipt of the copy of the order. Next.
Without being influenced by the observations made here.
Already
Yes,
it's set
yes,
aside.
correct.
24.
Yes.
Next point also, in common order, my lord, all that I am requesting this on.
What is that? That's not part of this.
No, this is common order. IA 2 and 3. There are 2 writ petitions.
Oh, that's
Yes.
not for both the.
Yes, the
Then
2
the
IAs.
Common order can.
Yes, yes, that's a
Common
common
order
order.
can be passed.
Yes,
So WP 15772 and the other one, against I number 2, you file the first writ petition. I number 3, the second writ
Correct.
petition.
The other way.
24 is the right.
Serial number 24 is IA number 2, my lord.
24, I number 2, and 23 is I number 3. I number 3. See, let it be.
Yes, and all that I requested there.
Nothing.
Status of the subject, reservation of the
Status quo.
subject, no, subject matter of the suit should not be defeated. That's what it has been done.
Let
No
it be.
jurisdiction.
Nothing will happen.
Yes.
Nothing will happen.
15
Yes.
days.
Number 25. Raghavendra Reddy, yes, petitioner.
Received the objection, my lords. I'll file it in the course of the day. Next week, my lords, and there are certain
Any
vernacular
urgency to you?
documents, my lords.
My lord, if they are not disconnected the power, I have no objection to agenda.
Who should tell you? You should only tell whether
Please,
the
ma'am.
power is
My
disconnected or
lord,
not.
my lord, they have filed a complaint against the petitioners under section 135.
You should tell what is the urgency. He wants to file his objections.
Please, ma'am.
Can it wait or not? Yes, let counsel appearing for the respondent submits the objections already. He'll file the same. List the matter on 25th June.
Grateful.
Till then, they are not supposed to disconnect the power.
Yes, 26.
26.
I appear for the 5th respondent that this writ petition is filed prohibiting not to draw the electricity line without permission so far as under 16(1) is concerned. That this present work is not executed by the KPTCL, the Power Grid Corporation. Power Grid Corporation is not made a party here.
Then counsel submits then counsel appearing for the respondent. You appear for BESCOM.
KPTCL R5.
You appearing for R5 submits that. The lines are drawn by
Power Grid Corporation.
Power Grid Corporation, and respondent 5 has nothing to do with the same. Then counsel for the petition seeks time to implead so and so. When do you want?
Next week, ma'am.
Let's this matter on 17th of June. Yes.
27, hearing on interlocutor application.
I appear for the respondent counsel.
Lord, in this case, one of the respondent is not being served. Respondent number 4. I am seeking for dispensation to respondent number 4.
They are not a necessary
Memo
party.
is filed, that's what he's saying. Memo is filed, seeking dispensation of notice to R4. Memo is taken on record and memo notice to him is dispensed with the scope of applicant. Yes, argue the matter.
And IA number 1 is filed seeking for early hearing. May I request next week, my lord? Next week. Any date may be fixed.
Date may be kindly be fixed.
16th.
A very
Number
short
one.
point, the quote below.
Number 1 of 26 is filed for early hearing. There's this matter on 16th of June.
Obliged.
Number 28. Devendra N for
I
petitioner.
filed a memo regarding dispensation of respondent number 7. Kindly dispense the respondent number 7 as a day.
Memo is filed seeking dispensation of notice to R7. The memo is dispensed with. So with this, the
All
service is
others
completed.
served, please.
IA number 1 of 26 is filed for, you filed the IA.
I filed mine.
IA 1 of 26 is filed for early hearing. This is matter on 29th of June. Yes, 29.
Obliged. 29th June, my lord.
Opportunity may be given to comply the office objections. Not as.
29.
There are no office objections. I number 2 of 25 for recalling the order dated 3/11/2025.
Please, my lord, the matter
Where
was
is the order?
dismissed for non-compliance of office objections.
Why did you not comply?
Lord, one set of objections were complied. Later on, some more objections were raised. Unfortunately, it's a suit for partition and
No,
lot
I
of
don't
parties were
understand
there.
how many days, months, years the matters will be pending for complying the office objections.
Well, we have filed the application immediately after
More
that.
than 9 office
Unfortunately, it was-
objections are
please,
there
my lord.
which are not
Lord,
complied.
we are ready to comply in a day, tomorrow itself.
Pending consideration of the IA, the petitioner is permitted to comply with the office objections. By office objections, let's just matter on 12th of June. By the time office objections are not complied, IA number 2 of 25 will be dismissed.
Number 30. 30, Mohammed
IA
Tahi.
number 1 of 25 is filed seeking dispensation of notice to R2 to R19. Dispense with, yes.
In this case,
What is the urgency for a 25 matter now?
what's
Without
urgency,
notice to the
urgency
respondents?
is that there is no cause of action. The suit which they are filed
Well,
is civil
correct,
property.
that was the cause of action right from last 1 year.
Actually, what is happened is matter is never listed. First time is listed before this honorable court. Earlier also they listed, never reached to the court. Earlier also two times listed, but never before the reach before the court.
No, it will now after you serve the notice again, it will reach.
Lordship, my humble submission is, Lordship.
Have
Any
to-
short, I will take a hand summon, short date may be fixed, Lordship.
Petition is permitted to take out hand summons on respondent number 1 only.
Yes, respondent number 1.
On respondent
Contesting
number
one.
1, and file a memo to that effect. If the memo is filed by 1st of June,
Tomorrow is the date is there in the trial court. I will serve it tomorrow itself, Lordship.
if the memo is filed by 12th of June, it's a matter on 15th.
Deeply obliged, Lordship.
Yes.
Number 31. Keshav Bhatia.
The respondent has filed a suit, but for declaration and injunction. Whose basis is that land has been granted to him by the government. That is the case. But the deputy commissioner has twice declared that document is a fabricated document. There is no such a grant. Twice he has declared. Therefore, the whole basis of the suit, there is nothing. It's a frivolous suit. Therefore, I filed an application to reject the claim.
Let's see your affidavit in support of order 7 to 11 application.
Yes.
Where is that?
Yes. Kindly see the affidavit. I have produced the order also. Order of the
First,
deputy.
let's see the IA.
Yes. Page 51.
Court officer, every day call the passers at 4 o'clock. Inform the advocates that it will be called at 4 o'clock. Yes.
At page 51, paragraph 4. I respectfully submit that the plaintiff has created some documents in order to knock out the valuable property of.
You said suit is for?
For declaration and injunction. Suppressing the material facts, and they have created documents like the Sagwali chit, official memorandum, sketch, RTC, etc. and MR number so and so. On all the said documents are created by the plaintiff along with the land grabbers to try to grab the property belongs to me and the extent extract money from me. Hence, any angle the above suit is not maintainable. I submit that the suit is filed suppressing several facts and earlier proceedings and parallel proceedings which are pending before the Honorable High Court in so and so. Therefore, the above suit deserves to be rejected on that ground. I submit that plaintiff is not in possession and all that. Well, Deputy Commissioner has twice declared, and in fact, my lord, a departmental inquiry was held as against 4 officials.
Where are all these facts? All these facts forms part of the claim.
Further.
I've seen that all these things, whatever you are saying, can the court consider it only by considering the plaint? Can the court reject the plaint?
But if there is no cause of action, if it is concluded that the document is fabricated, there is no such grant.
Who will tell the court that the document is
Deputy
fabricated?
Commissioner has said it so. Annexure E is the order which I have produced.
Is it before the court along with the plaint the document is filed? No. The court cannot decide. That will be decided during the course of the trial, not at this stage. Yes, please come. Dismiss. Order will follow. Yes, next.
Number 32.
This IA number, yes,
For delay, notice.
yes, 32.
Suit for money recovery, my lord.
32.
So, suit before a small causes court. The said suit came to be decreed. The petitioner herein is the defendant. The said suit came to be decreed only on the ground that, my lord, I have not filed a written statement, and I have not also been, since I did not file a written statement, I was also not allowed to cross-examine PW1. As per Supreme Court in Ranjit Singh and another versus State of Uttarakhand states that permission should be granted to cross-examine the any plaintiff's evidence, even if written statement.
When was the judgment and decree? Suit is of the year 2024.
Please, my lord.
When the court refused to grant permission to cross-examine. Yes.
In 25/10/2025, my lord. Let it pass on.
Notice to the respondents.
Number 33.
Serial number 28. Interim order may be extended.
Which one?
Serial number 28.
Extended, 28. Early hearing matter. Look at it. If stays there, extend. Yes, 33.
My lord, 33 is a challenge to a final order in an FDP proceeding. My lord, it has to be an RFA. It's a decree. A writ petition is not maintainable.
He passed away, your lordship. Senior counsel is engaged. He's stuck up in another court. He'll come and address the arguments, your lordship.
4 o'clock.
Please, your lordship.
Yes.
34. 34.
My lord, my it will be taken up tomorrow, my lord. Today he has small inconvenience.
Yes.
May be taken up tomorrow.
Several times they have took the
Whenever vacate
adjournment.
petition is filed, there will be a, let us see how many times this matter is adjourned.
My lord, only once we have asked for adjournment.
No, my lord.
This matter came up before me on
My lord,
4/6.
we are ready with
You
the-
sought for the time on that day,
My lord,
4/6. No?
no, my lord, it was not reached. Matter was not reached.
28/4, at request of the learned counsel of the petitioner, list on 4/6.
Only on that day we
At
have.
request, list on 28/4/2026.
My lord, we are ready with the matter, my lord. Only request is tomorrow, my lord.
Who will argue the matter?
Senior, my lord.
When you are on the other side, then you will understand the urgency. When other side file the vacate stay petition, all the time adjournments has to be sought.
And then
That's unfair.
Tomorrow, my lord.
List this matter tomorrow, no further adjournments.
Interim order.
Interim order is extended if again the adjournment is sought on any other ground, the interim order will be vacated and the writ petition will be dismissed. Yes, certify.
Cell number 35. A.B. Amarnath.
Yes.
The respondent has filed the application vacating interim order. My lord, this is a bare injunction suit, my lord. What has
Where is
happened?
the respondent? IA number 1025 is filed seeking to vacate the interim order. There is no representation on behalf of the. Argue.
My lord, the petitioner, my lord, had purchased a site sold by one person who had made sites in 2 acres, my lord, in survey number 45/1. Many sites were sold by him. Thereafter, after his death, my lord, his son sold several sites to others. Very few sites were there. By that time, son also died. The daughter-in-law, in collusion with some developer, my lord, completely changed the survey number 45/1 into 45/4. And they sold the sites differently. Then a complaint was lodged with the Lokayukta. Lokayukta held an inquiry and found that there is this survey number 45/4 doesn't exist. It's fake document. 45/4 does not exist. This is a report up by the dealer. But this defendant, Mala, he has purchased the site in 45/4. He put up a shed in front of my house, Mala, in the road. He says my site is this one and survey 45/4. When ADL report has come, certified.
What has happened to the IA?
Milan, IA for injunction, Milan, I sought for commissioner's report, Milan. They filed an objection. Milan, many suits.
Appointment
for
of
appointment commissioner, court commissioner. That has been rejected, Milan. In many other cases, there is the same survey number, Milan. There was injunction order, Milan, to appoint court commissioner. Court commissioner was appointed. Court report is there. That commission report I produced.
So granting interim injunction, court commissioner is appointed.
Appointed, that has been rejected. Just see the photo, Mel. In front of my house, the shed has been constructed.
So you are seeking injunction and you want a court commissioner to be appointed.
Examine whether it is under survey number 45/1 or 45/4. That has been rejected, Mel. Yes. And several other cases, Mel, court commissioner is appointed. Report is there. That report I produced. They said, no, the other court commissioner report I will not accept it. In the same survey number. That's why I filed an application to appoint court commissioner in this case also. That has been rejected.
Come to the order.
Blood?
Come to the order.
Order.
Why, when you're seeking injunction for that, why should the commissioner be appointed? You have to succeed on your case.
And that is only that is a crucial issue, Millard. This is under 45/1. This road is forum. Now he says that is the site under 45/4. 45/4 ADL report stated that is a fake document. There is no 45/4.
It will be decided in the.
Now he says it is under 45/1 survey number only.
Can you come to the order?
Yes, Millard. Produce the judgment, Mala. Even injunction suit also coordinate bench of this on court.
Let's read the order first.
Yes.
Where is the order in? You have straight away come before this court questioning this order.
Yes, it.
Why you can't file an appeal against this?
There is no appeal. It's civil court.
Oh, order.
Yes, civil court.
I was under the impression injunction.
Yes. Civil court.
Come to the order. We'll read the order first.
Order.
Paragraph number 7.
Paragraph number 6 is point number 7. Paragraph 7. Upon a perusal of the plaintiff amendments and the relief sought by the plaintiff, it is evident that the onus is on the plaintiff to establish the existence of the road on the western side of the suit scheduled property as claimed by the plaintiff. It is important to note that the issue of whether the site formed by the defendant under were located in a certain 45/1 or 45/4 is not relevant to the present suit. It is relevant, because overlapping.
Complete reading the order.
Yes, madam. In other words, the matter under consideration is limited to determining the existence of the road on the western side of the plaintiff's suit scheduled property, and the plaintiff is required to substantiate this claim. It is also undisputed that the plaintiff purchased half of the suit scheduled property from vendor, and as per the documents on record, the defendant's property is situated to the south of the plaintiff's site with site number 2 located adjacent to the site number 2 under 45/4, not on 45/1. 45/1, there's a road. In the light of the above, I am of the considered view that sufficient evidence is available on record to establish the identity of the disputed site where the identity of the property is not in dispute. There is no need to see identity of my property is there. Where this road comes under the 45/1 or 45/4 has to be established. In other reports, in other cases, there's a report.
Complete this order.
Yes, ma'am. There is no need to seek additional materials that relevant to the issue at hand. In such circumstances, the appointment of a commissioner to collect such materials would not aid in the resolution of the dispute in the present suit. Both the plaintiff and the defendants had submitted voluminous documents and photographs in their evidence to support their respective.
Come to the IA that is filed. IA.
IA. IA, page number 10. For the reasons set for so and so, technique that is the Taluk surveyor measure, identify the land bearing surveying 45/1 and 45/4, measuring 2 acres, 3 guntas of Malakali village, Bangalore North Taluk, identifying the location of the scheduled property in accordance with the sale deed of the plaintiff and the defendant number 1, submit the report in the interest of justice. Scheduled property is given. Then the verifying after I submit that I am the plaintiff in the above mentioned case and well conversant with the facts and circumstances of the case. The above suit is filed against the defendant for the relief of the permanent injunction directing the defendant not to put up constructions on the road western side of the plaintiff's property which affect the plaintiff's ingress and outgress using the road on the western side of the respective scheduled property. I state that the property purchased by me.
Where is the plaint? Plaint.
Plaint number?
Plaint he has not produced.
Plaint or not?
Why not necessary?
A plaint is not plaint. Plaint is. I'll produce it. They have talked about.
It is there.
Plaint is not.
At page 28.
Application section. Okay. Yes, 28. 70. It's a reasoning, not
No, the
28,
observation of the court, is wrong. The court says it has nothing to do or with the relief that is sought in the main suit.
Yes, my lord.
That is not correct.
We have
What
produced,
he has sought is the
we
same.
have produced many documents before the trial court to state that.
You please come to the observation of the court. That is not the correct observation.
In para 8 of the.
Para 9 you read.
They made observation in para 8.
9.
However, after applying the rationale laid down in the upper mentioned decisions, I am of the opinion that plaintiff has failed to establish sufficient ground for the appointment of court commissioner. The purpose of which the plaintiff seeks appointment of court commissioner is not material or relevant to the adjudication of the issues in this court. The plaintiff's claim pertains solely to the existence of the road on the western side of the suitable property. The appointment of court commissioner in the context would not contribute the resolutions of the dispute. Therefore, in view of the facts of
Why not? Why
yes,
not?
yes, my lord. It is clearly the plaintiff has admitted that there is a site number next to my south side. He's admitted in cross-examination. That is a 2, site number 2. My site number is 1. He is clearly admitted, yes, there is a site. So that court has come to the conclusion that there is a road next to that, not in site number 1. That my site comes under the 145/4. His site is 145/1. So lordship kindly.
No, what he has,
He's purchased the site in the year 2018.
no, along with the plaint, the boundaries must have been shown.
That is wrong.
Photographs also.
That is wrong. He admitted in cross-examination. That's what he is suppressing the facts.
No. Survey site number is survey no 45/4, 45/1. 45/4 is held as illegal and
When is that cross-examination?
Photographs we produced before the trial court stating that where is the road comes, where is the site number 1 situated, where is site number 2 situated. He admitted, everything is admitted. Only with the intention to drag the proceedings, I filed this petition before this honorable court. Except that nothing else.
Page number
It's clearly
27.
admitted. That's what
Kindly see the photograph.
in para
In
7
front
of
my
the,
gate, this shed is constructed. 27.
in para 7 of the order,
27, my lord, in front of my gate is put up the shed stating that my site. That was a road under survey number 45 by
What do
1.
you say about this?
he has purchased one site by Basvanna. His site, half of the portion only abutting to the road. Other half of the portion was not abutting to the court. That was the thing. Is a plaintiff is the,
No, where do you show that this is half is abutting and the half is not?
yes, my lord.
From this photograph.
I have a document to show that he has purchased the 40 by 42 site, out of which he has sold to his own brother-in-law 40 by 18.
Not only this house, there are other houses also.
No, it is only,
Next to that, there is
no.
another house.
no, it is the only house. That is only 40 into 18.
We can find the houses in this
No,
photograph.
there are no houses.
Why?
Next to my, there is second site number 2, yes, yes.
Where is your house in this? At page number 27.
Yes, not produced. Please. No,
What is this photograph and what is this photograph?
that is different because he has produced only his building photograph.
This is marked, my lord.
This is only his building photograph he has produced. He has not produced any other document.
That is not marked.
The witness is clearly admitted before trial court. My site is existence.
Forget about what he has admitted. So please explain to the court, what is this photograph? Where is your house? Where is his house?
Yellow color building is mine.
Ah,
Next to that, eastern side, east side is the building.
which one? Where the scooters are parked?
No,
You don't have another copy?
I don't have a copy.
Yes, this is matter. In the month of July, interim order earlier granted is extended. Yes, next. I number 1 of next. Yes.
Serial number 36. B.B. Sidramaya for petitioner.
The writ petition is filed by the defendant number 1.
Hmm.
Respondent number 1 and 2 have filed suit for partition. We have taken a contention that second defendant has filed a written statement seeking partition in some of the properties purchased by the petitioner after partition. Our main contention is there was a partition on 25/1/1991 and there was a dispute arises between the second defendant and 10/8/1996 the second defendant and petitioner have settled the disputes. Thereafter, the second defendant has filed a written statement seeking partition in the properties purchased by the petitioner after the partition effected between the family. Thereafter, my lord, the defendant number 1, this petition has also filed written statement. Second defendant has purchased some of the properties after partition. We are having both plaintiff and this defendant having share in those properties. My written statement is at page number 70. Thereafter, during the course of cross-examination, second defendant DW2 has admitted that he has purchased the property out of the joint family income and he has sold the property to third party. Hence,
defendant number 2 admitted.
To agreed. In the course of cross-examination, has admitted and he has sold the property to third defendant. So hence I have filed an application for impleading third defendant as a party to the proceedings. That application.
When was the property sold?
Please, Miller.
When was the property sold?
Property was sold in pendency of the suit on 1/2/2022. Suit was filed in the year 2012.
Let's see.
Well, the reasons for rejection is earlier the vendor of the second defendant.
What is the IF file now?
For impleading the purchaser as a party to the proceedings.
Where is the impugned order?
Impugned order is at page number
57.
Yes.
The reason assigned is Earlier, vendor of the second defendant has filed an impleading application. I have objected for impleading the vendor of the second defendant as a party to the proceedings. When I have objected for the vendor of the defendant to come on record, I have no right to file this application to implead purchaser as a party to the proceedings. That is the reason assigned.
Para 6.
So what is that rationale? Why did you oppose earlier?
So it does
If
not.
he is also not necessary, this person is also not necessary. Anyhow, it is hit by list pendency.
No, my vendor, no, not my vendor, vendor of the second defendant.
No, earlier,
Yes.
what you have objected, you stand on the similar line now.
So vendor has already.
That person is not necessary. This person is also not necessary party.
No, vendor has sold the property to second defendant. So then she has lost his right. Now second defendant
Who
has.
is the vendor?
Yes, madam.
Who is the vendor?
One Jayamma. So she has sold the property to the second defendant. Now second defendant has sold the property to third party. That third party is a necessary party to the partition.
Let's read that.
Page number 60. Para number 5. Plaintiffs have filed this suit against the defendant seeking for relief of partition and separate possession. When the matter was.
No, vendor's presence is not required.
Vendor is different,
Vendor's
purchaser is
presence
different.
Subsequent property who has purchased the property, his presence is required. Why vendor should be a party?
My humble submission, the survey number 106/4, it is not the subject matter of the suit.
This analogy as far as the vendor of the defendant number 2, his application is opposed by him. So this application cannot be.
She is not a vendor. She is a vendor of present impleading applicant. She sold, Jayamma was sold the property to the proposed defendant.
No. Jayamma filed an application on Order 1 Rule 10.
Please.
Jayamma sold the property.
She herself has filed the application to implead herself as a defendant. That application was.
The relationship of Jayamma with the family, with the joint family.
Jayamma is the wife of defendant number 2.
No, defendant number 2's wife has sold this property
Yes.
in favor of defendant number 3.
Not defendant number 3. Is a proposed defendant.
Proposed defendant.
Proposed defendant. She herself filed the earlier point of time. She herself has filed the application. The plaintiff has not objected. The defendant number 1 petitioner herein has objected and opposed for impleadment. That was rejected. After that, Jayamma sold the property to the proposed defendant. Once her presence is opposed by them, how can subsequent purchaser? She sold the property to the proposed defendant.
Our vendor is not a party to the
suit. And second point, the subject matter sale deed, survey number 106/4 is not the subject matter of suit or the written statement filed by the learned friend. That is not the subject matter. The property was not involved in the suit
It is
property.
not added to the suit schedule property.
Please, it is not a property.
In para number 17 of my written statement, I have taken clear contention.
Whether it is part of the suit schedule property or
No,
not.
please,
No,
Lord.
it is not a part of the suit
Then
schedule. But
why
in
do
written
you-
statement, we have taken a contention. After partition, the second defendant has purchased this property, is admitted in cross-examination. Immediately after he admitted in cross-examination that these properties were purchased from the joint family funds, I have filed an application. On admission in the written statement, in the cross-examination, we have filed this application. Admission portion is at page number. Well, at page number 30, it is in vernacular Kannada language, para number 4. Yes, clearly admitted. From the joint family income, we have purchased the property and now I have sold it. That is his contention. It's an admission, not contention. Page number 30, para number 4. It furnished the translated copy also. ನನ್ನ ಪಿತ್ರಾರ್ಜಿತ ಆಸ್ತಿಗಳ ವರಮಾನ ಇತ್ತು. Have the income from the ancestral properties. ಸದರಿ ವರಮಾನದಿಂದ ಸರ್ವೆ ನಂಬರ್ 164 ಮತ್ತು 106 ಸ್ವತ್ತುಗಳನ್ನು ನನ್ನ ಪತ್ನಿ ಹೆಸರಿನಲ್ಲಿ ಖರೀದಿಸುತ್ತೇನೆ ಎಂದರೆ ಸರಿ. It is true that we have purchased the property in the name of my wife in survey number 106/4 and 106 from the income of the
First
joint
of all,
family.
that property should be part of the suit property. Without that, what is
I am the defendant, my plaintiff has not included it. Intentionally, plaintiff.
Then what is the purpose to be achieved by this? When that property is not a part of the suit schedule property, by impleading a third party, what is the relief you will get?
So we have taken a condition, these are all the joint family property.
It should be included as a part of the suit properties.
With liberty, we have to see.
Sale deed produced by.
My lord, it is a technical error, I do understand. They have to seek counterclaim by seeking for share in those properties.
Thereafter,
They have filed one the return statement.
thereafter, question of impleading these parties will arise. Without any plea, without any issue, without any pleading. How many people you implead? What is the
After filing
consequence?
necessary application.
Huh?
After filing necessary application.
My humble
So
submission.
in view of the admissions made by the defendant.
What my learned friend submitted that, please lordship, Jayamma purchased the property in year 2006.
Now, it is in the cross-examination, it is accepted that this particular property is purchased from the joint family funds. That is the submission. And this property is not part of the suit property.
Good schedule property.
So now they will, if they want to take any steps,
Yes,
let
that
them
can-
take.
that can.
Then I leave it open to them. Once if the court allows, if there is any amendment application or any counterclaim with respect of the said property, if the court allows it, then they may be at liberty to file this application at a later stage.
Yes, please.
Please come. Agreed with the order passed on in an IA and order 1 rule 10 CPC. The defendant is before this court. The defendant has filed this application seeking to implead the purchaser from one K.A. Jayamma, who is none other than the wife of
One
defendant.
clarification. Jayamma and also this second defendant. Both of them are.
K.A. Jayamma and defendant, who are wife and husband.
And also daughter. All the three persons.
From the second defendant is wife and daughter. And it is the case of the petitioner that in the cross-examination, defendant number 2 has accepted the fact that the property is sold, property is purchased from the joint family funds. Hence, the petitioner has filed this IA under order 1 rule 10 to implead the third part, the purchaser as a party, as a defendant to the suit. Land counsel appearing with the respondent submits that this property is not the suit scheduled property, and when the property is not a part of the suit scheduled property, question of impleading the defendant, impleading the respondent herein as a proposed defendant will not arise. In response to that, land counsel for the petitioner submits that when basing on the said admission, the defendant ought to have filed an IA seeking counterclaim in respect of this property and ought to have filed this application once his IA is allowed. Next, having heard the counsels on either side, there is a material on the card. Admittedly, as on today, the property which is purchased for the proposed party from defendants 2 and their family is not part of the suit scheduled property. It is a case of the petitioner, the defendant number 2 has admitted that he has purchased this property which is sold to the proposed party from the joint family funds. Hence, he has filed the IA. Even then, the present IA that is filed under order 1 rule 10(2) is not maintainable for the reason there is no this property, in respect of this property, no partition is sought. Unless a partition is sought, the proposed party cannot be impleaded in this court. It is submitted with the land counsel to the petitioner that they will make appropriate application seeking counterclaim in those circumstances, a counterclaim. As of today, the order that is passed by the court is a well-considered order, and it requires no interference from this court. Accordingly, this court is passing the following order. The writ petition, this court do not find any reasons to interfere with the order imprint. However, if the petitioner if the petitioner's application for counterclaim, if it is allowed by the court, then he is always at liberty to renew his request for impleading the proposed party, accordingly disposed.
So counterclaim is subject to, counterclaim is subject to.
No, I didn't express any opinion on that. If,
Please.
and the
If
court
they-
will decide it in accordance with law.
Please, that,
All the counterclaim and other things, the court will be deciding in accordance with law, and the court has not expressed any of the, has not expressed anything on the merits of the matter.
37, Pradeep Nayak, for petitioner. Palata White.
Respondent number
There are
4 minutes.
two petitions, my lord. The first one is the suit filed by them, but that is the fourth respondent for injunction, saying that they are owning more than 40 acres.
For the defendant in the suit.
In the second writ petition, I am the defendant. In the first writ petition, I am the plaintiff before.
So
the-
what is your suit?
My suit is for easementary right, easement of.
Suit number?
Suit number 13 bar
2022.
2000?
22.
22.
Please, my lord.
His counter suit is OS number 13 of
Suit for?
2020.
Suit for?
Suit for easementary right,
Declaration of
easement
easementary
of
right.
way to reach our property. I am owning less than 4 acres for injunction.
My suit is for
OS
their
number?
injunction.
That is
OS
why-
number 49 of 2021.
Their suit is the first and mine is the second suit. My lord, their contention is this. They purchased this property from one Sampike Khan estate in the year 2021. And there is a road, but that road is exclusively belongs to them. Others have no right on that property. Accordingly, they filed a suit for injunction against the defendants in the said suit. See, your lordship may kindly permit me to read the orders in page number 30. That is page, please.
First, let me understand.
Please.
What is the IA?
IA for injunction restrain the defendant from interfering with the.
What is, in your case, what is the IA you filed?
I filed the injunction not to obstruct the use of road because it is only the easementary right which they are having and using since from long time immemorial. Now all of a sudden they have stopped it.
Then what happened?
That IA came to be rejected, observing that earlier suit for injunction has been filed by them and the injunction application came to be allowed. So accordingly, you have no right to seek for injunction. Accordingly, my application, which is filed in the
Their application is allowed.
my application is
Then
dismissed.
what happened to the
MA filed in both the cases. MS also came to be dismissed.
See the
Against
order,
that,
order in the MA.
order, your lordship may kindly now permit me to that in OS in writ petition number 11781 of 26, that is their case. In the observation is made by the honorable trial
case.
Writ petition number 11781 of 26. That is the next case. Next case, my lords. 37 bar 1.
What happened to the first case in the
First case is the second suit filed by the petitioner herein. In that, IA has been filed for injunction, in which it is observed that in the earlier, this is the second suit is the first suit. So the court observed that since their application came to be allowed, you have no right to seek for injunction. Accordingly, on that observation only, injunction application came to be
Let's see,
dismissed.
Page number.
30, my lords. Para number 23, may I read?
No, this is in their suit.
In their
49.
suit, that is their suit. May I read para number 23?
23.
23 in page number, running page number 30.
Yes.
It is relevant to note, survey number 304 is abutting to Devrunda Sakleshpura main road. Admittedly, defendant number 2 to 5 were passes through said road. Then in survey number 304, 308 and the 306, to root their properties, and it is a reasonable and acceptable one. It is relevant to note the plaintiffs have no properties in survey number 304 and in survey number 306. They have only 2 acres 33 guntas in survey number 308. Atlas copy of survey number 306/1, 2 and 3 produced by the defendant number 1 discloses the road that defendant number 2 had purchased and conveyed in favor of defendant number 1 in survey number 306/3.
Here the court is referring to defendant is you.
A defendant us.
Yes.
Starts at northeastern corner of survey number 306 and ends at southwestern corner of survey number 306. To have the access from survey number 304 to 306, defendant number 1 need not pass through survey number 308 because northeastern edge of survey number 306 directly connects to survey number 304. My humble submission is this is the wrong observation. Therefore, it is clear that defendant number 1 no need to pass on any land of plaintiffs. Therefore, the allegation that plaintiff closing the public road is not acceptable. Even if any road is closed, no hardship will be caused to the defendant number 1. It is relevant to note defendant number 1 in his written statement specifically pleaded he owns land in survey number 293/1 to an extent of 10 guntas. Also in survey number 293/2, survey number 293/3 measuring 2 acre 10 guntas. In survey number 300 measuring 1 acre 20 guntas. In survey number 308 and documents such as sale deed dated so and so discloses 12 guntas in survey number 306/3, that is road, 1 acre 4 guntas in survey number 362/1 and 1 acre 28 guntas in survey number 361/1. On perusal of village map, survey number 361 located to the north of survey number 362. Survey number 362 located on the south of survey number 306. Survey number 306 located on the to the west of survey number.
Where is the MA order?
MA order, my lord. It is in page number 36.
Yes.
It is also may be permitted to read page number 57, para number 20. May read.
Yes.
It is relevant to note that when possession is admitted, even a person claiming easementary right cannot take law into his own hands. Such right must be established in accordance with law. Until such right is declared or at least prima facie demonstrated, entry into another's property amount to interference. The trial court has rightly protected settled possession, which is fundamental principle governing grant of injunction. The controversy essentially revolves around the alleged existence of a public road said to be passing through the suit scheduled properties as mentioned in the appellant sale deed dated so and so. A careful examination of the said sale deed reveals that 12 guntas in survey number 306/3 was earlier acquired for the purpose of access. The recital merely states that there exists a public road inside Geetanjali estate at a distance of half a kilometer from Devrunda Sri Prasanna Rameshwara temple. However, no specific survey numbers are mentioned through which the alleged public road runs. No reference is made to the village map, revenue entries, grant or notification evidencing such road. No material is produced to show acquisition of easement by prescription, grant or necessity. The vague recital in a private sale deed cannot by itself create or establish a public right of way over another's property. Here the burden squarely lies on the appellant to establish existence of such right. At the interlocutory stage, the appellant has failed to discharge even a prima facie burden. Further, the appellant himself has pleaded that access to his lands is through the main Devrunda Sakleshpura road and thereafter through survey number 304, 308 and 306/1. The trial court has examined the village map and atlas extracts and past and has recorded a finding that survey number 306/3 directly connects to survey number 304 and that the appellant need not pass through the lands of the respondents. This court, while exercising jurisdiction under Order 43 Rule 1R CPC, will not reappreciate the evidence as in a regular appeal unless the findings are perverse or wholly unsustainable. The findings recorded by the trial court is based on so and so. See, my humble submission is, my lord, what the trial court and the appellate court relies on the document of the revenue, that the villagers has filed an appeal, and in the appeal it has specifically held that 3 guntas has been reserved for road. That has been suppressed by the other side and obtained an order. That has been challenged before the KAT. KAT also granted the stay. In the meantime, my lord, the Tashildar has passed, based on the application given by the villagers who are using that road, passed an order for resurvey and redo the port work. That came to be allowed, and the other side has filed a writ petition before this honorable court, and there is a status quo order in that also. My lord, it is not out of record to submit. Even they entered, entered.
Why all these facts were not brought to the notice of the court?
We have brought even that what I am trying to submit. On the first date of hearing, they entered appearance. If your lordship kindly peruse the order sheet, in the earlier writ petition dated 2/5/25, that is in writ petition number 13/4/10 of 25. On 2/5/25, Shri Prasanna Kumar, that is the first date of hearing, my lords. Shri Prasanna Kumar advocate undertakes to file wakalat for R4, issue notice to R1 to 3 and R5. Parties are directed to maintain status quo till next date of hearing. Please this matter on so and so date. Again, they moved an application on 10/9/2025. Your lordship may kindly see. D4 should not be dispossessed during the subsistence of the 10/9/25. 10/9/25. Yes, please. The respondent number should not be dispossessed during the subsistence of the subject petition on the strength of interim order. Interim order extended. See, your lordship may kindly see, on the 2 earlier occasion, the honorable judges of this honorable court expressed a view saying that we directed the parties to maintain status quo. You prove your right in the trial and let the court decide both the cases together. But for which
What
they
is it meant by status quo?
status quo regarding the using of that road. We are not claiming any right over the property which they are having more than 40 to 50 acres. We have access to reach our property which is only 3.5 acres. If it is not granted, we can't cultivate.
The authorities have passed an order of status.
Yes, they themselves have
Petition
obtained.
is also pending.
First and foremost, my lords, I approached the trial court and I secured an order wherein restraining petitioner number 1 not to trespass into my property, where there is court has a categorical finding that he and his henchmen or supporters need not pass through my property at all. Paragraph number 23 onwards, my lords.
Yes, sir. It is their case that they're using that road.
No, my lords. The fact of the
Say about the writ petition he is referring to and the findings of the authorities.
my lords, in fact, during the pendency, just specific to the dates, my lords, I secured the order on 8th of October 2021 with trial court having a categorical finding that he need not pass through my property. So he files a counter case on 17th of February 2022 with deliberately not making me as a party. I get to know about it 1 year later. I challenge that there is a finding of the court. And the interim order gets rejected, A, for suppression of facts, and also as there is a finding already that he need not pass through my property. My lords, I just need a minute of the time to demonstrate that this case has got nothing to do with the claim of the road. The fact of the matter is, during the pendency of the civil suits, the petitioner number 1 suffers an order on 8th of October 2021. He files a counter case. An interim order gets rejected. Soon after that, in May 2022, he files an application before the executive magistrate. And that proceedings is disposed with a categorical finding that in survey number 306 and 308, properties which belong to me, there is no public road whatsoever. Their claim is that there is a public road inside my property. And trial court in its finding, concurrent for finding is that the claim of the road is very vague and that can only be determined by a full-fledged trial. Second thing, my lords, while since secure, they in the counter suit what they file and the consequential MA, they challenge, they file a writ petition. On the first hearing, my lords, I did not had an opportunity to place all the material. So I place all the material. There is also a police protection order in my favor, as there have been repetitive violation of the trial court's order. There are 5 FIRs which are pending right now since they secured the status quo order. And the last of the FIR, my lords, even the advocate on record, which is myself, I am implicated as one of the accused. And a concurrent bench of this honorable court has given for stay order and any further proceedings on this, wherein date of incident, time of incident, place of incident is not disclosed. And my lords, crux of the matter is there is 20 guntas of land in this alleged survey number 308, which they are purportedly claiming. In the plaint, in the counter suit what is being filed, and also the written statement in which I have secured proceedings in which I have secured the injunction against them, they make a purported claim of 1 acre 20 guntas in survey number 308. But when they go before the revenue jurisdiction where they have challenged the PODI proceedings, they admit that they only have 1 acre of land. After this counter suit where the interim order is rejected, petitioner number 1 and 2 along with their henchmen, they file another suit. While in the written statement where they are injected, they admit that petitioner number 1 admits that he and his brothers are entitled for only 10 guntas of land. And in this, in November 2024, the other case what they have filed, they are claiming the whole extent of 31 acres and 24 guntas. By squatting on my property, which is 20 guntas right at the entrance.
Is it correct that you are claiming the entire 30?
No. We will undertake on
all
your
is
lordship,
part-
except the
part of
road
the
we are
record.
not claiming.
Show that.
No.
Lords, my statement of objections filed in writ petition number 13410.
One, 3, 4, 1, 7.
In page number 23, my lords.
When was it filed? Give that.
22nd May 2025. Is the reference.
Page number?
Page number 22, my lords. Statement of objection. Prop may read, my lords.
When the statement of objection filed? 22/9?
22nd May 2025.
May. Yes.
Lords,
Page number 22.
22. For this serial number 1 of item number 2 of scheduled property, survey number 293, this is the written statement. Yes, my lords?
Through Chaudhary, Angad Chaudhary. What is the name of the petitioners?
DH Vasantappa.
DH Vasantappa.
DH Vasantappa is the defendant in the suit.
Yes, my lords. My lords, DH Vasantappa has filed a written statement in the suit where I have secured an injunction. In this, he says, 293/1 of Devrunda village, admeasures 31 acres and 24 guntas, 6 acre, 15 acre, 6.15 acre of land belongs to the uncle of defendant number 1, D.N. Motaya. Further, an extent of 10 gunta in survey number 293/1 belongs to defendant number 1 and his brothers. This is the specific reference in their
10 guntas.
This is OS number?
OS number 49 of 2021, where I have secured an injunction against.
2021. This is in an instant suit.
Instant truth, yes, my lords.
Yes, my lords.
He is seeking 10 guntas.
10 guntas.
10 guntas.
Then what about the other case?
Then fast forward November 2024, my lords.
This is when?
This is in 2024. They have filed another suit.
No. This written statement is filed by
2021.
2021. Then where is the next suit?
Next suit is the counter suit what they file.
No. In that what they say? Same thing.
Same.
They don't mention anything about 293/1, but they continue to make a claim, purported claim of 1 acre 20 guntas in survey number 308, which is the bone of contention. Another survey number where in the civil suits they make a claim that they have 1 acre 20 guntas in survey number 308.
No. In their suit where they are seeking easementary right, how much land they are claiming?
See, your lordship, the schedule itself has been mentioned in the writ petition itself. My lord, if your lordship go to page number 13.
In OS number 13.
13.
What is the land they are claiming?
13, my lord, land. See, in item there are 2 items. Item number A and B. In item number A, I am owning the 4 items of property. Whereas B is concerned, it is, we have explained regarding the road. If your lordship permit me to read the
What is extent?
extent, total extent, my lord, in survey number 306/3, 1 acre, only 12 guntas. 306.
From 10 guntas, it has come to 12 guntas.
12 guntas, yes. 362/1, 1 acre 4 guntas. 362/1, 1 acre 28 guntas. 362/2, 14.5 guntas. 14.5 guntas. So for which we claimed the road that is in the B schedule. Your lordship may kindly permit me to read the B schedule. Road situated in survey number 308 of Devrunda village, Gonibidu Hobali and Mudigere Taluk, measuring 12 feet wide and 200 feet long, and said road commences from the road situated in survey number 304 of Devrunda village and touches to the road formed in the item number 1 of the schedule A properties. A properties, rough sketch is annexed to the plaint. See, what we are claiming is this 12 feet into 200 feet road, which is connecting the item number 1 of the A schedule property. If it is blocked, admittedly it is in their property. We are not disputing. We are claiming only easement rate. If it is blocked now, I cannot reach that property. I can left that property as it is.
In this writ
Moreover,
petition,
their own writ petition status quo directed to be maintained. Writ petition number, my lords.
You have completed your order.
Please.
In this writ petition number 13410 at page number 8 of the petition, my lords, the claim is defendants own 20 guntas of land and plaintiff 1 to 5, who are the petitioners here, they own 1 acre 20 guntas of land. Land in survey number 308 is the claim. Now, along with my list of documents, my lords, dated 22nd of September 2025, I have submitted the pleadings filed by petitioners before in a revision petition before the Karnataka Land Appellate Tribunal, wherein at ink page number 163, my lords, they admit that the father of the petitioners by name D.H. Vasantappa purchased 1 acre of land in the said survey number 308. So before revenue jurisdiction, they make a claim 1 acre. When it is before civil courts, they make a claim of 1 acre 20 guntas. The fact of the matter is this 20 guntas of land is right at the entrance of my estate, which gives access to the rest of my 80 acres of estate, my lords. And furthermore, as I highlighted earlier, in the written statement, they make a claim that 10 guntas of land in 293/1. And in the suit which they file in November 2024, they make a claim on entire extent of 31 acres and 24 guntas. Now the claim per se of the petitioners,
Claim by the very same petitioner.
same petitioners, while in civil suits, different claims have been made on different extents of land. And the second thing is, while agitating their so-called claim on public road, before executive magistrate also they have initiated two specific proceedings. Both have been relegated to the civil courts. And the fact of the matter is, when the proceeding was still pending before the executive magistrate, in encroachment CR 128 of 2021 Millards, the petitioner number 1 files an appeal before jurisdictional assistant commissioner, agitating his personal grievance. And that is also disposed with a finding that in survey number 306 and 308, there is no public space whatsoever. Now, all these aspects, multiplicity of proceedings, whenever they file the next case, they never mention, they never disclose.
All these aspects are stated in your objection?
Yes, my lords. Hence, my lord, they are blatantly indulging in suppression of facts. Repetitively, since securing the status quo order, 5 FIRs have been registered. And now, my lords, they are blatantly, viciously targeting this advocate on record by implicating me as one of the accused. And the coordinate bench has given the stay order in my favor in this case.
No, my lord, all the.
Number 1, my lord, 13410, the first writ petition. Some of the properties were sold to the, say, defendant number 2.
By whom?
By the respondent and their.
By this respondent to you?
No, I have sold it to this respondent. This, my lord, kindly the trial court, the appellate court, my lord, at page 66, my lord, para 30, page 67, my lord, few lines, my lord, I'll read. The conduct of the writ petitioner, my lord, what exactly now he stated before this court, it is not even placed before the trial court, my lord, at any point of time. What exactly is saying, my lord, before, what exactly the petition before the revenue appellate courts, my lord. These are the subsequently, my lord, he has initiated when he is unsuccessful to secure the interim order. Kindly page 30, my lord. Para 30, page 67, my lord, in the first writ petition. That is, my lord, 13410 of 2025.
There is no para 33.
No, no, page 67, para 30.
Page 67.
Page 30, para 30, page 67.
Which writ petition?
Page 13410 of 2025.
Yes.
This, my lord, may I read, my lord. As discussed above, temporary injunction order has been issued by the trial court against the plaintiff, that is, my lord, the petitioner hearing in OS number so and so, pertaining to survey number 308 of Devrunda village, standing in the name of the defendant number 4, but the plaintiffs have claimed the right of easement of necessity, that is, right of way for using the Schedule B road situated in survey number 308 of Devrunda village. But in the initial stage of the present suit, the plaintiff not arrayed the defendant number 4 as party to the suit. It appears that the plaintiff, by suppressing the earlier injunction order in OS number 49 of 2021, filed the present suit to have wrongful gain. This is concerned, my lord. He has not answered why he is kept silent, my lord, all these facts. And, my lord, his conduct, my lord, in the stage by stage, he has initiated, my lord, the magisterial proceedings, my lord, saying that there's a public nuisance. Road is blocked. And, my lord, later he is unsuccessful in that. Then he filed a complaint. He challenged the PODI proceedings. One after that, my lord, he initiated many proceedings. In every proceedings, my lord, is unsuccessful. Then, my lord, he filed a suit. In that also, my lord, the interim order is refused. Then, my lord, it is confirmed by the appellate court. Then, my lord, he filed this writ petition. Anywhere in this writ petition, my lord, whether he has not stated that why he has suppressed the grant of injunction granted in OS number 49 of 2021. He has not answered. That therefore, my lord, rightly the trial court and the appellate court has refused to grant the interim order by accepting the conduct of the plaintiff, my lord, where he has suppressed the material information. Because, my lord, as on that day, there's an interim injunction. If it would have been stated that order, my lord, definitely it is the black and white, his conduct will be placed before the court. Show that, my lord, whether road is there, the road is climbed by him, is available, my lord. It is, my lord, not even by way of any single material. For the first time, my lord, my learned friend is stating everything, my lord, so many documents which are not even placed before the trial court or appellate court. And, my lord, the revenue proceedings, my lord, which are, my lord, subsequent to filing of this suit also. Once, my lord, he is unsuccessful to get the interim order or an interim injunction, then, my lord, by taking advantage of the status quo order, my lord, more than 5 the criminal cases were registered, and, my lord, in which the lawyer is also an accused. Who is the lawyer, my lord, represented the defendant.
My lord, by way of reply, what my learned friend is saying, contending that we have not disclosed about the pendency of this suit. In fact, in para number 5 of the plaint, it is stated, it is respectfully submitted that another suit has been brought by one Sri Dhruvat Chaudhary and another at the instigation of first and second defendant in OS number 43 of 21. We have stated, we have not suppressed it.
Yes.
Their own proceedings has been
Heard, reserved. Yes, 38.
Number 38, attend. Number 39. 39.
interim order is there in this.
My lord, interim order will be there.
Please, highly.
And for the petitioner, they filed the application for the vacating.
Yeah, for respondent number 1 and 8, my lords.
See, the application, implementing application filed by the petitioner was rejected. During pendency of the revenue authorities, they filed in their partition suit. My properties have been included 3 items. Recently, before 2 days of the order, DC has remanded the matter. I will produce the copy. So implementing is necessary.
Have a copy of it.
Please, I have it.
They want to make a compromise without implementing the parties. Kindly see the page number 14. Translation 14, my lord. Only we are claiming our property 3 items have been in their schedule. The first paragraph, the present revision petition pertaining to properties in respect of 77/2B, 54/4, 77/7. Item number 15, 16 and 17 in their suit plaint. This revision only in respect of respondent 2 in this petition, my lord.
Once you succeed in the revision, if that is the case, so the matter is remanded. If you succeed there, then you ask the court.
No, my lord, but no, they want to make a compromise, not on the merits, my lord. Because once they have taken a decree, again I have to start ABCD. Now they have the first respondent, unless adjudication of the matter by the revenue authorities, he has no kata.
What is the suit for?
Please.
What is the suit for?
Suit for partition filed by the respondents. Petitioners are not the party.
What is the relationship between you and the petitioner?
No,
They are
no
third
relationship.
parties,
Only
my
the property granted by the land tribunal to the petitioner's father. There was a dispute. He raised respondent number 2 has questioned the mutation entry of the petitioner's father.
In a revenue records, whose name?
Yes, my father's name was there. Thereafter, he challenged that one. Respondent number 2 in the present petition, he challenged that my father's entry. Still, it is again
That matter is remanded to the.
No, my lord.
Assistant Commissioner.
After sorry.
Assistant Commissioner.
What is that?
After his name was entered, we filed an appeal before the Land Reforms Appellate Authority. They discontinued his name, challenging that Land Reforms Appellate Authority order. Instead of filing, they filed a suit before the trial court for declaration and injunction against me. That also came to be dismissed. They filed a regular first appeal. The Honorable High Court said that you have to set right this with the revenue authorities, and they never set aside the judgment and decree passed by the trial court in the year 2001 itself.
So what happened?
So,
to the
but
revenue
only thing is,
authorities?
reason
After
is-
that, they filed an application before the Tahsildar. The Tahsildar allowed their application and said that their names may be mutated. Then we filed an appeal before the Assistant Commissioner. Assistant Commissioner set aside the order.
No,
They challenged it. They challenged it before the Deputy Commissioner. Now it has been remanded back.
So now he is a proper party.
No, he's a third because their rights have already been curtailed by the civil courts in a suit for his father had filed a suit for declaration and permanent injunction. After full-fledged trial for 10, 11 years, their suit came to
Then
be
what is the
dismissed.
order of the appellate court in RA, this court?
They
Saying
said that they never set
these
aside.
aspects cannot be decided in the civil court. It has to be decided with the
Said
revenue
before
authorities.
by the revenue
So what
authority.
does it
That
mean?
is only with regard to the boundaries, my lord. It is not with regard to the, and moreover, the appellate authority, Land Reforms Appellate Authority has dismissed their claim with regard to 2 items in the suit schedule property, saying that, it is not in their name, it
But
is
that
in
is yet to attain penalty.
it has been.
Let him be, because he is, whatever the orders that are to be passed, he would be the affected party.
And they come and file an application after lapse of 14 years, 12 years, my lord. The suit is of the year 2014, 2025, they come up with an application
So
stating
second
that they have to
respondent
be
was a party,
implemented, my
Where
lord.
is I? Where is order?
Annexed,
Annexed F is the impinned order.
Lordship,
At
kindly
page
see.
number
Annexed
51.
D is the application.
Impinned order. IA number 4, Annex D 42, my lord.
Allowed. Order will
Please.
follow.
Achha.
Next. Only 40 call, thereafter the passwords.
Cell number
Please.
40.
I'll not take up any other matter after 40. And all other matters, the interim orders will be extended and it will be in the list.
Your Lordship, I am appearing for the petitioner in this matter.
I'm for respondent, my lord.
Serial number 40. Your Lordship, it may be taken up tomorrow, Your Lordship. Senior, due to some emergency, he left. It may be taken up tomorrow.
Tomorrow.
Serial number
Your
41, my
Lordship,
lord.
interim order may kindly be extended.
Serial number
Number three,
41. The
Great
matter
deal.
is on 12th, my lords, before trial court. Serial number 41, my lords. The matter is.
Please listen to the court. I'm here, I'm hearing the other matters, so no confusion at all.
40.
All these matters will be there in the list. Tomorrow, the matters will start from 41.
List.
Yes, and wherever interim order is there, that also will be extended and adjourned. So from 41 tomorrow, if you have any other matter is coming up tomorrow, day after tomorrow, in the morning, if you mention, I'll take it up at 2:30.
List number 3, serial number 19. Day after tomorrow, my lord, is the auction. That's why today's date was fixed.
Tomorrow, day after tomorrow, tomorrow.
Let
we
it come in
take
list 1, my lord, tomorrow.
No. Tomorrow in the morning you mention. Tomorrow in the morning, if you mention, I will take it up at 2:30. So not necessary to again start. If I start making that, allowing it, then there is no end to this. So morning you can make a mention if any matter which is urgent, any of the advocates.
Please, let it
Yes.
be.
So
Passover matters.
only I'll be taking up passwords now.
Passover matters. List number 1.
All
serial
other
number 3.
matters.
For
All
the
other
respondent,
matters
please.
will continue in the list. Look at it, wherever interim order is there, extend.
List 1, serial number 3.
1 serial number 3. Passover.
For the petitioner.
List one.
My lord, we have filed an affidavit stating that we'll pay 5 crores initially, that is by today, and the 10 crores will be paid by 2nd July, my lord. And balance, another 10 crores will be, 5 crores will be paid by August. I will give a revised proposal, my lord. By tomorrow, I will pay 7.5 crores, my lord. By 2nd July, by 8th July, pay another 10 crores, my lord.
First of all, what is the amount to be paid is a
My
first
lord,
question.
I'll listen. My lord, they are telling it is 31 crores 20 lakhs, my lord. We have made certain, but it will be around 29 crores, my lord. What I am suggesting, my lord, is because we have made certain payment that has not been considered in their memo of calculation, my lord. Anyway, that will be, I'll let them file memo of calculation before the executing court. But I would secure to the extent of 31
I
crores.
have already
Thing
filed, my
like
lord.
going once there, coming here
No.
again, no. So let there be a clarity with regard to what is the amount, what is to be paid.
Yes, ma'am.
Now again, half of it, now you'll take an order and then go to the going to the executing court. That all will not arise.
Yes.
First of all, let's have a clarity on what is the outstanding, what is the amount to be paid and how are you paying it.
Yes, ma'am. They have made a calculation. They have,
Do one thing, you prepare your calculation
ma'am.
memo, give it to him.
Yes, ma'am.
He will give his calculation
Yes, ma'am.
memo and basing on that, you, whatever reply objection, you do it.
Yes.
And I'll take it up this matter on Thursday. In the meantime, all this should happen.
If at all Friday, please, my lords.
Friday.
My lords, one
Friday I'm not in station.
Monday.
Thursday is okay.
Monday.
Monday is also okay.
Monday, this is matter
My
on
lords,
Monday.
one submission. Insofar as the memo of calculation is concerned, in today's objection statement which I filed, I've already given mine.
Yes.
Yes,
that is
given.
his
Therefore,
objection.
from my end, I have already given, please, my lords.
On the last occasion, it is submitted that the petitioners want to clear the amount and they'll come up with an affidavit. To the affidavit that is filed, the respondent has already filed his objections. In the light of the said objections, the respondent shall come up with the
Petitioner.
the petitioner shall come up with a fresh affidavit before this court with regard to the payments of amounts to the respondent. Basing on that, this court will pass further orders. This is matter on Monday.
Please, my lords.
Much
11, Rajesh Kumar S. Passover 11.
Lords, maybe just short Passover will be accommodated.
No passovers now. Yes, Liz's matter on Tuesday,
Please, my lords. Tomorrow, my lords.
next Tuesday.
My lords, there's a grievance.
No, we can't accommodate so many times.
Cell
Yes.
number 20. Son.
Please, my lords.
Yes, 20.
That petitioner is a plaintiff before the trial court, that he filed suit for declaration and injunction, that. Along with the suit, that he filed application under Order 13 and Rule 1 and 2. That suit was filed on the basis of Annexure A to F, that. Annexure A is the shell deed of the plaintiff, that. Petitioner herein, that. He is the absolute owner of the suit scheduled property, that. And he has executed the GPA in favor of the dependents, that respondent herein. And also they have executed the agreement of sale, that. And the memo of understanding between the petitioner and the respondent, that.
Now the IA for injunction is.
IA for injunction is not refused to grant ex parte injunction. They have issued emergent notice,
When is the matter coming?
that your lordship may kindly see that page 78, that.
Page?
78, that. The one submission, that. On the GPA, the shell deed has been taken themselves by the dependent, that. I am not a party to the shell deed,
Look at it, where is that order?
that your lordship may kindly come to page 78, that.
Page 78 is an application under Order 39.
That OS number 210, that.
That is at 82. The order sheet is at 82.
That annexure 76 is the proceedings, that order sheet. And relevant portion of the order is that 78, that.
27/5/2026, the matter is coming.
Please, that. And 27.
When is the matter coming? 20, returnable by 24/6/2026.
25th of filed the suit, that. On that day, it is reserved for the orders on 27/5/2026, that. And 27/5/2006, that the trial court refused to grant ex parte temporary injunction and issue emergent notice to the.
Please come. The petition is agreed with the orders passed on IA number 1, where the court without
I'm seeking not to alienate only, that.
without passing an order has issued the emergent notice. It is submitted by the land counsel to the petitioner that when an IA is filed seeking ad interim injunction.
Not to alienate, that. Sorry, ma'am.
Not granting any order. When the IA is filed seeking ad interim injunction, the court has to pass an order on that, either granting or rejecting the IA. But the court has issued emergent notice. It is submitted that during till the notice is served on the respondent that there may be a direction to there may be an injunction restraining the defendant from alienating the property. What is the injunction? Alienation.
alienation.
from alienating the property. Having heard the counsels on either for the counsel for the petitioner, there is a material not record. When the petitioner has filed an application seeking ad interim injunction, the court ought to have considered the same. And if the court finds no material, the court ought to have dismissed the same. Instead of passing any order on the IA, the court has issued emergent notice. This court finds force in the argument of the then counsel for the petitioner. Hence, the order dated 27/5/2026 is set aside, and the trial court shall consider the application that is filed by the petitioner, that's on IA number 1, in accordance with law, within a period of 1
The
week.
15/6 is the appearance date, Malad, before
Within
the.
1 week from the date of receipt of the copy of the order, petitioner can seek for advancement of the case.
Please, Malad.
Yes, next.
Number 2, serial number 33.
Let's appear for the respondent.
30?
Petitioner, your lordship.
33, my lord.
Your lordship, a short pass over, your lordship. He's on the way, he's coming.
No.
My lord,
A date may be fixed,
That
your
kind
lordship.
of lenience we will not show.
But this is a case where final order in an FTP proceeding is challenged in a writ petition. I'm only saying no prejudice will because they need to file.
Where is that order?
My lord, if my lord kindly looks at page 20. Kindly see page 29, my lord, final order. Page 29 in the writ petition.
Office has not raised the maintainability issue.
No.
Page number 30.
29, my lord. 29.
The report of the commissioner.
Court commissioners hereby accepted. As per sketch 4, the property in block 2 is allotted to the share of the plaintiff. Block 3 is allotted to the share of the defendant number 1. Block 4 is allotted to the share of defendant number 2. Sketch will form part and parcel of the final decree. Office to draw a final decree accordingly with respect to item number 3. So, my lord, this is a final order in the FDP proceeding. So, there was a partition of, in a suit for partition with respect to couple of one property, they said.
Maybe what they want to say is that they are agreed by the report of the commissioner.
Yes, my lord, far to the.
Not even so.
Commissioner's report has not been accepted because there are certain findings which go contrary to.
So, as far as
even that has to be challenged in appeal, my lord.
No, probably that is what the senior counsel wants to submit.
Yes.
If I may make one submission, my lord.
Any interim order in this?
Interim order is there, your
Interim
lordship.
order is there.
Where
A
is the
date
interim?
may be fixed, your lordship. We'll address our arguments on the next date.
Why did you ask for a passover in the morning when the counsel is not coming to the court?
No, sir, your lordship, he's there, your lordship. He's in court hall number 10. He's a little held up. That's the reason, your lordship.
My lord, if I may make one submission in this.
When is this interim order granted?
No, it filed in August of 20. I think, in July of 24.
Right from 24 there is a stay.
Yes.
But the matter was listed today before the trial court is posted for orders as well there. Because it was clarified about 3 days ago that it is not on, it is only on the order that the stay has been given. The proceedings can go forward, which the learned trial court is.
This is matter tomorrow as the first matter.
Please, your lordship.
Okay.
Interim order may be
Interim
extended.
order earlier granted is expected. Tomorrow, if the matter is not argued and
Please, Your Lordship.
any passover is sought, the matter will be dismissed on the ground. Already today, the matter in the morning sought for a passover. Again in the afternoon when the matter is called, again sought for a passover. Finally, let's this matter tomorrow is
Grateful, your lordship.
in list number 2 as a first matter.
Grateful, your lordship.
Yes. Passport? Done. Then still time is there, we'll take up anybody's next matter.
41,
Let it be tomorrow. Is 42?
42,
Tomorrow.
serial number 43.
All these matters, interim orders expected. Yes.
Serial
44.
number 43. 49.
44,
Serial number 44,
45,
44, 45, 46, 47, 48, Cell number 49, 50, 51, cell number 52.
No, whoever are there, if you call it their matter, they are
Cell
ready
number
with.
53.
For the respondent, Your Honor.
In which matter?
List 2, serial number 53.
53, yes. You appear for the petitioner?
Please.
The original suit, this is a suit for declaration that they have filed.
Yes, to argue.
It's infructuous. On the
Well,
last date, we filed a memo to that effect.
Let's see, what is the order?
My lords, I'm seeking adjournment in this matter.
Not adjournment, let's hear what she's saying.
Please.
What is the, where is the impugned order? What is the impugned order in this?
There was no entry order, my lords.
IA number 3. This is called for the records in OS number and allow IA number 3. This is a prayer. And then what happened?
My lord,
IA number 3 orders are passed.
the suit itself is disposed because it is a commercial dispute. By order dated 22/3, we filed a, 1 second. We filed a memo on the last date, along with a certified copy of the order, stating that
the writ petition is filed, seeking the following prayer. Then counsel for the respondent submits that respondent has placed a memo before this court stating that the suit itself, that is OS number 9126 of 2025, is disposed of on 26 March 2026, and nothing suffices for consideration in this writ petition. Accordingly, the memo is taken on record and writ petition is dismissed as infructuous.
oblige you.
Yes. 54.
Cell number 54, 55, cell number 56.
Madam, 55. Tomorrow, madam.
You are not party in person.
No, no.
If the advocate is not there, this is not a civil court, that where you will appear. Yes, next.
Cell number
56.
57, 58, cell number 59, 60, cell number 61, 62, cell number 63, 64, cell number 65, Pradeep, cell number 66, Rangamesh,
Serial number 65.
Yes, 65.
I am for petitioner. Day after 65.
Yes.
Day after tomorrow.
No, this will continue. This will continue. Only because there is some more time left. If anybody is ready, I want to take up the matter. That's it. Otherwise, the entire will come tomorrow. Yes, 66.
Tomorrow I am out of station, except tomorrow any date.
Have you informed the other side?
I will
Because
inform.
maybe they are under the impression that it will come tomorrow. That's why we can't.
I will
enter it.
inform by evening. I will inform. I have Dharwad. I have matter tomorrow. Except tomorrow, day after tomorrow.
Notified after tomorrow.
Much.
At the request of Land Council for the petition. 66.
cell number 66,
Yes, next.
67.
Keep on
Ramesh
calling.
Chandra, 68, 69,
Petitioner in this matter.
69.
69.
The petitioner filed challenging the judgment decree before the Lok Adalat. The respondent number 1 and 2 filed a suit for the relief of declaration to challenging the judgment decree passed before the Lok Adalat. The suit itself is not maintainable, and hence I filed a written statement on detail written statement and IA order 7 rule 11A. There is no cause of action. That application came to be rejected by the trial court. The tort has been challenged before the court, and Supreme Court saying that before any judgment passed in before Lok Adalat, the suit is not maintainable. Only on the writ petition is maintainable in the judgment of the Supreme Court also. That's what.
No, not that. Let her take the file.
Any judgment before the Lok Adalat, this is a prad or any.
It's not on that. Let us see the facts. What is that?
In the arguments made in the plaint also saying that in the admitted fact, my lord.
Please come to that. Come to the plaint. What is that the plaint is saying? Order, judgment and decree passed in OS number
Page 38, my lord. Page
on the
38.
file of the first edition senior judge dated and the decree passed on property measuring an extent of kuntas of land situated at so and so. So according to you, this judgment and decree, what they are referring is a Lok Adalat award.
Yes, ma'am. They have plain governments in the admitted, page 38. in fact.
Paragraph?
Paragraph, page 38, 38, my lord.
38.
Paragraph 35 in the middle, madam. Middle, 35, paragraph.
There is no 35 paragraph.
Sorry, ma'am. Page 38 to paragraph 25, ma'am.
Yes.
Therefore, the depend number 1 to 5, this suit without disclosing the above said fact filed in OS number 1151 of 2026 on the
Referring to the written statement or to the plaint?
plaint.
Para 35 says the cause of action arose on
25, ma'am. Paragraph 25.
25 only. It starts at the cause of action arose on 7/11/2023. It's at page 39.
38, page 38, paragraph 25 in the plaint.
Something wrong with your pages and your.
Paragraph 25. ma'am. Paragraph 25 in the plaint mail.
Plaint starts at page 30, correct?
Yes, 29 mail.
Hmm.
Let me check. Page 29.
How the para starts?
Paragraph 25.
How it starts?
First paragraph in the plaint governments.
Read it, how it starts.
Paragraph 25 in middle, man. Paragraph 25 in middle.
You are reading para 25 in middle.
Yes.
Then how will the court understand if you read in the middle without even mentioning that?
Therefore, nothing but a 1, 2, 3. Therefore, depend number 1 to 5 in this suit. Middle. Without disclosing the above said fact filed OS name was
It is thereby.
Yes, ma'am. Thereby, yes, correct. Thereby, the depend number 1 to 5 in the suit without disclosing the above said fact filed in OS number so and so on the file of the
Come to the order, how the court has dealt with.
compromise question is in a decree in before Lok Adalat. They are saying in.
Now come to the impugned order.
Come to yes.
Where is it?
Impugned order, my lord. Reason stated in page 21.
Yes.
Para 8, man. Reason cell para 8 lost. They are saying that. The plaintiff in OS number 1151 of 2023 is also filed. The said suit is filed by the one Munitayamma against Venkatesh and others. But the plaintiff are not parties in the said suit. The suit property is same as the present suit schedule. It was also filed for declaration and permanent injunction, and declaration of the gift deed is also sought for the said suit. The said suits came to be compromised between the parties from form number 10 produced. It is standing in the name of Gopalappa, who is the father of the plaintiffs.
Let the answer for the petitioner submit, sir. Taking the against a compromise decree passed by the court. A compromise against an award passed by the legal service authority. The suit is filed. It is submitted that party who's agreed by the same has to file a writ petition before this court, but not a suit. And when the petitioners file an application under order 7 to 11, the same was not considered by the court. Where is the judgment? Was not considered by the court. And counsel for the petitioner has relied on the judgment of the Honorable Apex Court.
Judgment order, my lord. 23rd February 2026.
In case of Dilip Mehta versus Rakesh Gupta and others, and submits that the suit is not maintainable, and the court ought to have dismissed, ought to have allowed the IA that's filed under Order 7 Rule 11, considering the submission of the petitioner. There shall be stay of all further proceedings in so and so, so and so. Petition is permitted to take out hand summons and file a memo to that effect by 29th of June, or else the stay granted by this court stands vacated. Yes, next.
Number 70. Serial number
One
70,
submission, my lords.
71,
Serial number 68.
70.
One submission, my lord. Serial number 68. I'm seeking short accommodation. My senior couldn't be here. He's held up in another courtroom.
If that order is not correct, file a review, I'll consider.
No, serial number 68. That is 53, my lords. Serial number
What happened
60.
68?
My senior is not.
That will come tomorrow.
Tomorrow, I think.
It'll come to me.
This will come tomorrow. I'm not passing any orders. All matters will come tomorrow because there is still time. I'm taking up matters. Yes, next.
70. Sadhana
Yes,
is Desai.
For the petitioners, my lords, I'm defendant number 3 in the trial courts, my lord, and the respondent is the plaintiff in the trial courts, my lord. This is basically a suit for partition of ancestral property, and my father is the defendant 1 before the trial court and respondent number 2 before this court, my lord. The petitioner plaintiff is a child of the defendant number 2 out of second marriage, which is a void marriage, my lords, because my father's first marriage was still in subsistence when he married the mother of plaintiff, my lord. Plaintiff admits that in the plaint that this property is an ancestral property, and she is claiming her part of the portion is in this property, my lords. And according to the judgment, as it is ruled in Revanna Siddhappa versus Mallikarjuna case, my lord, it is very clear that in page number 10 of the writ petition, my lords, it is very clear that a child born out of void marriage is treated as a legitimate. But there is a restriction under clause section 16 subclause 3 of Hindu Marriage Act, which allows that children from invalid marriage can claim only their parents' property and not their ancestral property. And this can be done only after notional partition is fulfilled, my lords. In this case, the plaintiff's father, that is Shivanandriya, defendant number 2,
File is not there.
is still alive, and hence she can't.
1 minute. It's there. Yes. Come to the order. How it is an admitted fact that the marriage is a void marriage?
My lords, when defendant, the respondent number 2 married plaintiff's mother, respondent number 3 was still alive, my lords. That is, my mother was still alive.
Is it the case of the plaintiff?
My lords?
Is it the case of the plaintiff?
Plaintiff is seeking partition.
Correct. All the facts which you are pleading now before the court or in by way of a written statement, is it stated so in the plaint?
It's not stated in the
How
plaint.
come the court can decide on an application under Order 7 Rule 11?
My lords, in plaintiff has agreed in the plaint that this is ancestral property.
No, with regard to the void marriage.
Indeed, my.
He's not saying, he's not accepting it.
She is accepting in the plaint, my lords. Page
Saying
number
that
22.
It is a void marriage.
Her mother was married to her father in second marriage, my lord, during the lifetime of the first wife.
No, it could be during the lifetime.
Lifetime of first.
No, whether they are divorced or not, or what is it? No, you will prove before the court.
She has agreed in the plaint that they are all residing together, my lords. Like that, together enjoying the property.
Anyhow, all that cannot be decided. Court was right. whether it is a void marriage, it's a void, how can it be decided? At this stage, at order 7 rule 11. Please come. The writ petition is dismissed. Order will follow. Yes, next. 71.
Number 71. Jagdish KG.
My lord, petitioner is a plaintiff in the trial court, my lord. A petition is claiming for the claiming the will, my lord, which is executed by her brother, who is a husband of respondent, my lord.
The suit for
Admission of letters, my lord. That is claiming of will, my lord. That is executed by her brother, petitioner, plaintiff's brother, and the
suit for
claiming the will, my lord. It is in the custody of a respondent, my lord. I mean, a defendant, my lord, who is a
come to the plane. Let's see what's the prayer in that.
Plaintiff petition trial court suit player, my lord.
Plain.
Plain prayer. That the plaintiff may be allowed to prove the said
Where is the
registration
plaint?
last will and
Where
test.
is the plaint? I'm asking.
133, my lord, page number 133. I mean, prayer is in the page number 123, 133, my lord.
Can there be a relief of this nature?
Yes, my lord. It is in the custody of the defendant, my lord, who is a wife of the executor, my lord, will testator, my lord. And plaintiff is a sister of a testator, my lord, which is executed in favor of plaintiff only. Now, the only question they are claiming, the defendant's claim is that it is not executed, my lord. Now, my contention is that I have to cross-examine the witness, my lord. But the one witness is whereabout is not.
What is the IA now?
IA is first day of procedure, my lord.
IA filed. What is the
IA
order?
to summon the
IA?
witness, my lord.
Yes, please come to that order. Let's read that.
It is in the page number 123, my lord. My lord, here the witness is not alive. One witness whereabout is not found, my lord, and one witness is not alive. Now I am summoning the wife of his brother, my lord.
Let me read. Please come. Then counsel for the petition submits are when an IA is filed by the petitioner. Praying to issue summons to the witness for production of the documents and giving evidence. The court, without considering the case of the petitioner, basing on the objections filed by the defendants, as in a mechanical manner dismiss the application. It is submitted that if the said witnesses are not summoned, it would cause a lot of hardship to the petitioner. Considering the same, they shall be stay of all further proceedings. Notice number 4 of 2008 till the next date of hearing. Same summons, hand summons to the counsel for the respondent and file a memo to that effect by 29th of June, or else the stay granted by this court stands vacated.
Grateful, my lord.
May I make a small submission?
My lord, list
Please.
serial number 72.
All matters
There
will
is
come
an interim
tomorrow.
order of stay.
That's what I said. All interim order will be extended. The list will continue from today, like where it is started, stopped at 30. From 40, all the matters will come other than what I heard.
One small submission, madam.
Yes.
Lord, serial number 82 in the second list, it is supposed to be posted for preliminary hearing. It has jumped into preliminary hearing B group.
Anyhow, tomorrow that will be always, it will come on the top almost.
That's
Because the list will start from 42, so your matter will reach tomorrow.
It's true, madam, but it comes in the B group, it becomes.
See again by to, yes. All the matters just what are called and what are there in the third list also, extend interim order.
Interim orders.
All interim orders will be extended.
My lord, sir.
My lord.
Submission, my lord. Serial number 70, kindly be listed tomorrow, my lords. I'll get back.
That's what I'm saying. Which matter 70?
70, CRP.
What happened?
Dismiss, you dismissed it, my lords. Kindly post it tomorrow, I'll get back to you.
Then you shouldn't argue. After arguing, you shouldn't say again some other date. That CRP list in the month of August.
My lord, with Lordship's permission, my lord,
Yes.
list number 3, serial number 44, it may be given 2 weeks, my lord. There's a Kannada translation is required.
That matter will take time to reach, but by the time you file the translated copies.
Great, my lord.
Madam, 86.
70 ವಾಪಸ್ ಕೊಡಿ ಸರ್.
Madam.
ನಾಳೆ
ಇಲ್ಲ ನಾಳೆ
ನಾಳೆ ಮತ್ತೆ repeat ಆಗಿ.
40 ಇಂದ ಎಲ್ಲ ರೆಡಿ ಫಸ್ಟ್ ಲಿಸ್ಟ್ 40 ಇಂದ ಫಸ್ಟ್ ಲಿಸ್ಟ್ 3 ಎಲ್ಲಾನು ನಾಳೆ ಇವತ್ತು ಬೆಳಿಗ್ಗೆ ಅಂತ
ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೋರ್ಟ್ ಆಫೀಸರ್ ಕೇಳಿಸಿದ್ಯಾ?
ಹೇಳಿ
ಲಿಸ್ಟ್
ಹೇಳಿ ಸರ್. ಸರ್ ಹೇಳಿ.
ಲಿಸ್ಟ್ 356 ನಾಳೆ ಬೇಡ ಮೇಡಮ್, ನಾಳೆ
ಎಲ್ಲ ನಾಳೆ ರಿಪೀಟ್ ಆಗುತ್ತೆ ಸರ್. ಆಲ್ ಮ್ಯಾಟರ್ಸ್ ವಿಲ್ ಬಿ ರಿಪೀಟೆಡ್ ಟುಮಾರೋ.
ನಾಳೆ ಬೇಡ ನಾಳೆ ಹಾಕೋಬೋದಾ ಅಂತ. ನಾಳೆ ಬೇಡ ನಾಳೆದಿಗೆ ಹಾಕೋಬೋದಾ ಅಂತ.
ಸರ್ ಹಂಗಿಲ್ಲ, ಅದು ರಿಪೀಟ್, ಅದು ಸ್ಟ್ಯಾಂಡರ್ಡ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಟು ಅಸ್ ಟು ರಿಪೀಟ್ ಆಲ್ ದ ಮ್ಯಾಟರ್ಸ್. ನಾಳೆ ಬಂದಾಗ ಕೇಳಿ, ಬೇಡ ಅಂತ.
ಓಕೆ.
It will be there in the list. Until it reaches, it will be there in the list.